From distant lands we gather, hearts of fire all along. Oh, big Nick calls we follow, through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. Warriors of the ancient sea, songs of glory dark and bold. In the night, our spirits free, legends born, tales unfold. Oh, big Nick calls we follow, through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. From horizons wild we roam, with thunder in our soul. Every battle brings us home to the stories ages told. Oh, big Nick calls we follow, through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight.
Oh, hey. There you are. There you are. Hello, folks. Yes, we are diving headfirst into a new trial. It is the trial against Mr. McIntyre, also known as J.K., a rapper out of Texas. He is already serving 55 years for another murder. Now, and this goes back to 2017. And he wasn't arrested until 2019 after the alleged other people in the car decided to, yeah, I'm going to save myself and say he did it. So this will be an interesting trial where the state has not one but two people on the stand who has been on probation, or at least with an ankle monitor, for a number of years awaiting this trial. And if and when this trial is over, they are walking free, even though they allegedly were in the car and one of them might have been the one pulling the trigger. We don't know. We'll just have to wait and see. But as I said, Mr. J.K. already serving 55 years. He's not eligible for the death penalty because he was a minor when all of this happened back in 2017. So, I say we go right into it. Dun dun dun. Dun dun dun. There we go. I'm going to put myself up here for now, at least. For now, at least. And let's have this here as well. All right. Oh, by the way, hello, folks. Hello. I saw Erin, Gigi, Skilletpan, Wim, Penny, and a bunch of people here at YouTube's. A handful, a bunch of people over at Rumble, and also a bunch of people over at X. Now, this trial has already started. I was supposed to start streaming this yesterday, but it did not happen because of work. But now we are starting, and I'm going to play in 1.25 speed, and also, since we are playing this after the fact, well, not after the fact, but we will catch up by skipping all the breaks, skipping all the lunches, and empty space in the trial. So we will catch up eventually. Hello, Justin Wright from Wisconsin. Hello. Bush is here. Hey. Brisbane, Australia. Yay, you're already in tomorrow. All right, but let's get right into it. And as always, let me know if sound is okay.
Late start. What I'm going to do now is I'm going to give you the oath. I know you took an oath downstairs, but this is an oath for this specific case. So if you could raise your right hands for me, please. Do you and each of you solemnly swear that in the case of the state of Texas versus Taymor McIntyre, you will a true verdict render according to the law and the evidence, so help you God? All right, you can lower your hand. State, are you ready to proceed?
Yes,
All right, you may proceed.
Through bill of indictment, in the name and by the authority of the state of Texas, the grand jury of Dare County, state of Texas, duly organized and paneled and sworn as such at the November term, AD 2019, of the 187th Judicial District Court of said county, in said court, at said term, do present in and to said court that in the county and state aforesaid and anterior to the presentment of this indictment, on or about the 23rd day of April 2018, Taymor McIntyre, herein referred to as defendant, did intentionally cause the death of an individual, namely Mark Anthony Saldivar, herein referred to as complainant, by shooting the complainant with a deadly weapon, namely a firearm, and the defendant was in the course of committing or attempting to commit the offense of robbery of Mark Anthony Saldivar against the peace and dignity of the state.
Right, to the indictment, how do you plead?
Not guilty, Your Honor.
All right, you may be seated. State, do you have any opening statements?
Yes, Your Honor.
You may proceed.
Please support. Counsel. Ladies and gentlemen, I'm going to take you back to April 23rd, 2017. When Lucy Salvador woke up that morning, she did not realize it was going to be the last day she talked to her son, Mark Salvador. But saw him alive. She spoke to him that day in the afternoon at the house, and Mark was excited. He had a rapper that contacted him about doing a photo shoot. Taymor McIntyre, Tay-K 47, or Tay-K, here in San Antonio, Texas. He was excited. His passion was photography. His passion was taking photographs and wanted to make that his career. He was young. He was 20 years old. Taymor McIntyre was almost 17 years old. He was an up-and-coming rapper that contacted Mark about this photo shoot. And when Taymor came over to pick up Mark from his house, at his mother's house, Mark went outside with his backpack and his camera, very definable white type camera, ran off to this car down the street, a black Kia. Little did he know he was getting into that car, and it would be falling off that car later on, shot by this individual that's sitting right over there. When he got to that car, he got in the back passenger seat. It's a four-door Kia. Taymor McIntyre was in the front passenger seat. Joanna Reyes was driving the vehicle. A good buddy of Tay-K's was in the back seat and scooted over to the middle, Jalen Bell. And then also there was a Jeremiah Rodriguez in the back seat. When they drove away, they proceeded over to 410 and McCullough, across the street from North Star Mall here in San Antonio, Texas. When they were at the intersection, an altercation began at that point. This man right over here pulled out a gun and turned around and started hitting with fist and also with the gun, telling him, "Give me your stuff, give me your stuff, give me that backpack." They're wrestling for the backpack. At that point, Jalen Bell also wants to get involved in this. He's a bigger guy, a lot bigger than Tay-K. He's in that back seat with Mark. They start beating him and trying to take away his backpack. His passion is in that backpack. His photography, his career. Tay-K gets that backpack away from him. Jalen Bell is still hitting and kicking and pushing Mark. They're at a stop light. There are people parked around them at that stoplight, witnessing what's going on. Because this happened at 5 o'clock on a Sunday in broad daylight. At some point, Mark gets kicked out of the car. They slam that back door. They won't let him back in the car. Help, help, help. He's yelling. What he loved is in that car, his camera. Give me my dings, give me my dings. He knows the light's about to turn green. He's frantic. He runs to the front. He jumps on the hood. One of the biggest mistakes of his life, or rather, the last part of his life. Joanna Reyes is driving that vehicle. The light turns green. They drive through that stoplight. It's a Sunday afternoon. Right across the street, or highway from the North Star Mall, there's a Chick-fil-A. Chick-fil-A is closed on Sundays. They pull into that Chick-fil-A parking lot. She slams on the brakes. Mark sort of stands up. Looks like he's stomping on the windshield. But then that car jerks and he falls. You'll see that passenger door open up, the front passenger door open up. But this man over here was sitting with that gun. He leans out. He shoots Mark through the shoulder, goes across his body, exits out of a little bit out of his lower back. He falls to the ground. The car reverses and takes off from the scene. You'll see several people run up and try to help Mark. But that bullet crossed his body. It hit his spine, hit his both lungs. If he would have been on the best medical gurney in the world, he wouldn't have survived that shot. He dies in that parking lot that day. As Tay-K and his friends drive off. They don't go to the cops. They don't call the cops. They run away. That's not the end of the story. Because that car was found less than a mile away, abandoned at a Mexican food restaurant. There's evidence there that Tay-K was there, that Jalen Bell was there, Jeremiah Rodriguez was there, and Joanna Reyes was there. Doesn't end there. Tay-K and Jalen take off. They run. They get out of town. Jalen is caught in Dallas. Taymor is caught in New Jersey. Nobody called the cops. Nobody said anything at that point of helping Mark Saldivar. A promising career, possibly photography, a difficult field of photography. You take chances. You do things for nothing. That's what he wanted. He had a chance that day to take some photographs of an up-and-coming rapper that had his career on the horizon, possibly, or wanted it to be that career of a rapper. But instead, that particular day, he chose to take a life of an individual, Mark Saldivar. That's what we will bring to you, and evidence will show that Taymor McIntyre committed capital murder on April 23rd, 2017. Thank you.
That was very short and concise opening statement. I liked it. They not like other trials where the prosecutor goes through every piece of evidence and what they are supposed to tell the jury. Simply up. This is what happened, and we are going to prove it. And then sits down again. All right. Let's see what the defense has.
Just one moment, counsel. All right, you may proceed.
May it please the court, opposing counsel, ladies and gentlemen. Assumptions and the general guesswork that is attendant to the story that the prosecution just laid out for you should be of deep and troubling concern. There's no dispute that Mark was killed. There's no dispute that he was shot. There's no dispute that there was an altercation in that car. But virtually everything else that the prosecution has laid out for you is going to be told to you through either people who are making a wild guess based upon very, very small fragments of information, the bystanders, for example, on the highway, on the access road where this altercation took place, or it's going to come from people who were in the car. And I want us to stop and consider what that really means in a case like this. Mr. McIntyre is accused of capital murder. You heard yesterday extensive discussion about something called the law of parties. which is the idea that if you are assisting someone in the commission of a crime, either before it happens, while it's going on, or after the fact, you are culpable just the same as the individual who pulled the trigger, the individual who decided to take a life. That's going to be the backbone of this case, is everybody in that car pointing their finger at someone other than themselves. And the state paid to get that information developed, not with money, not with the normal kind of a transaction, but with something that is the most valuable thing a person can trace, their freedom. That's the issue in this case. What exactly caused there to be a fight in this car and who that fight was with is all going to come from people that were occupants of the vehicle and, according to the state's theory of this, participants in what took place. As far as who struck first, what the argument was about, all of that's going to come from the other occupants of that vehicle who have a vested interest in making sure that it doesn't land back on them. The facts and circumstances about where people are seated, who fired the gun, why the gun was fired, all of those are similarly going to come from people with a vested interest in making sure that it doesn't come back on them. And ultimately, all of those things tied together, the way in which this case becomes a charged capital murder against Taymor McIntyre has been spun from the detective's lips to these witnesses' ears and about to be regurgitated back to you just the way the state wanted it, the state paid for it, and the state packaged it. That should be taken with an exceptional amount of scrutiny. And the law in Texas acknowledges that. I expect, after you've heard all the evidence in this case, that you will be charged on something called the accomplice witness rule, which tells you that in Texas, the law requires that the state provide corroborative evidence other than the testimony of an accomplice or a co-conspirator in order to establish guilt. And it is not alone sufficient to convict that corroborative evidence simply prove that a crime occurred. And what the state's going to try and do, I anticipate, is to stack accomplice on top of accomplice on top of accomplice to try and convince you all that that's sufficient to corroborate the offense. Don't let them do it. That's not how the law works. And you all would have to take each of those accomplices as being inherently suspect and recognize that they can't corroborate each other. And what we're left with at the end of that is going to be the actions of law enforcement investigating this case, which, as my colleague, Mr. Goldstein, will explain to you in a moment, were subpar, suboptimal, and not acceptable, especially when we have this kind of a case on the line. The investigation done here was half-hearted, lazy, negligent, dilatory, and ultimately was substituted by reliance on these accomplices as the proof in the pudding, as it were, that a crime was committed. You're also going to hear some evidence about the aspect of the case Mr. Garahan described to you, which is that Mr. Saldivar got on the hood of the car after some altercation took place in the vehicle. That is to say, there will be people that testify who were just on the roadside, that in broad daylight on a Sunday, there was some kind of an altercation in that car. Accounts will differ. Some people describe the individual as an African-American man, young. Some will describe that individual as having a pistol. Some didn't see one. Some will describe that individual as being a Hispanic young man. Some will say that the Hispanic young man had a gun. Some don't. All of those things, I think we have to understand, just are what they are. This happened in the flash of an eye. It happened in a place where you don't normally expect to see something like that. We're talking about Chick-fil-A over on the north side of town across from North Star Mall. Not your normal 5 o'clock Sunday activity. And what they saw is what little piece of this overall story they saw. But what seems to be consistently accepted, at least by the lead detective on the case at the end, as he synthesizes all of these little snippets of observation, is that Mark Anthony Saldivar got out of the vehicle, proceeded to argue with the occupants of the vehicle while inside, they're still inside, and then jumped onto the hood of the car and began stomping the windshield of that car. And you'll see the windshield of that car caved in as a result of that activity. You can see where his foot came through, and you can see the rest of it coming through with it. And it is in that context that gunshots are fired. It is in that context that Mr. Saldivar loses his life. We talked yesterday about self-defense. We talked about defensive property. We talked about provoking the difficulty. But fundamentally, I want you to keep those principles in the back of your head, because however these cooperators, these accomplices, decide to paint and shade this version of the story on this occasion, and there have been several, the bottom line is that the things that happened while everyone was in that car had dissipated. And I think a great many of us, confronted with an altercation inside of a vehicle like that, would have walked away. But that's not what happened here. Now, the state's going to try and maintain that the reason why Mark Anthony Saldivar didn't walk away is because his camera equipment was inside. But you'll hear testimony from one of the cooperating co-defendants, one of the accomplices, that the photo shoot that he just described had been called off. and that they were just giving this guy a ride. Any evidence that you do hear about a camera, about a backpack, about property of Mr. Saldivar being taken is going to come from these cooperators. There's no camera recovered in this case. There's not going to be an Exhibit 15, the camera of the deceased. You're not going to see money taken out of the deceased's wallet. The fact that those objects even exist is something that has to be speculated and guessed upon. And then ultimately, the only place you're going to hear it as evidence is from these accomplices. So fundamentally, the state can't prove that this was not a justified homicide. The state cannot prove that Mr. McIntyre was the shooter in this controversy. The state can't prove that there was a robbery, either intended or executed or attempted. Those things are all coming from people with an absolute vested interest to accomplish it. And so, no matter how the charge is broken up for you, I think that there is no question the state will not be able to meet its burden to establish proof beyond a reasonable doubt of capital murder. And far less question that they'll be able to establish even basic, fundamental first-degree murder. Those are the things that you all are confronted with. I'm going to turn it over now for just a moment to Mr. Goldstein, who's specifically going to talk to you a little bit more about the nature of the investigation in this case, and fundamentally why, as jurors, you are assessing the evidence in light of your duty to presume Mr. McIntyre innocent, that the investigation in this case should be criticized, and you all should not be filling in the gaps for the police. I want to thank you all for your time. I urge you to listen to the evidence carefully. I know you will reach the correct verdict.
May it please the court, able counsel.
Okay, short, concise, even brings up a self-defense what actually happened in and around that car. That's interesting. That's interesting. I'm not sure who this third guy is, but let's listen to him.
Counsel, ladies and gentlemen,
It's the next one.
ladies and gentlemen of the jury, this case is old. The evidence is old. It occurred in 2017, 7 years ago. Speaking of old, I'm 81. I'm probably the oldest person in this room, and that's why I need notes and why counsel come over and coddle me every once in a while. I've been sitting here listening to the able lawyers in this room speak to you. That's primarily going to be my job. I haven't said much to y'all or anyone up until this time, and I'm probably not going to say a lot during the trial. I'm going to be like, I'm going to be watching. I do think it's important that you understand that while you're listening to the evidence, that these are good lawyers on the other side, just as I know ours are very capable lawyers. I respect them. I respect this court. I respect our judicial system. 2.5 centuries. I mean, it goes back to ancient time. There's some magic in the number 12 when you listen to evidence. And I think almost every lawyer that's done this, I've been doing it 57 years, will agree. You come to the right result. I'm always, each one of y'all might not use the same tools. Each one of y'all might not come from the same place. Each one of you bring your own experience to this room. It must be your individual decision. Guilt or innocence. You should deliberate. You should listen to the other jurors when that time comes at the end of this case. But it has to be your individual decision. Let me suggest to you that this adversary process involves a lot of things. As we listen to this evidence, there's going to be disputed evidence. You're going to hear two different sides. That's why we have juries. You're going to have to make some decisions. Most of the evidence in this case is not in dispute. Most of it's not going to be contested. And you might think, well, why am I being subjected to all this? That's their job. Their job is to prove, if they can, each and every element of this offense beyond a reasonable doubt. That's the highest standard known to law. They will be, and they're going to be doing their job, and they have to prove each element, and therefore, don't think they're trying to bore you. That's their job. They have to prove it all up. So you're going to be listening to that evidence as we talk about evidence in this case. they get to go first and last. If you noticed. There's a reason for that. They have that heavy burden of proving beyond a reasonable doubt. Therefore, we give them the chance to open and at the end of the case to close. They'll be the last you will hear from, the last evidence, the last argument. And that's as it should be. But we're kind of squeezed in the middle like a ham sandwich. I'm Jewish, so maybe it wouldn't be a ham sandwich, but it'll be a sandwich nevertheless. Let's say turkey sandwich. Some people have described it that way. There are some matters that are in dispute. And I want to warn you in advance. Each side will vigorously present their evidence. There'll be objections. We may have disputes. We may offend each other on occasion. I hope not. I believe in the collegiality of fellow lawyers. Like I said, I respect these. But we're going to have some disputes. I may offend them from time to time. I may offend the judge on occasion. I may, God forbid, offend one of y'all. My hope is that if the lawyers should perchance offend you on occasion, hold that against the lawyers. Hold that against me. Tell me about it after this case is over with. Don't hold that against Taymor McIntyre. Tay-K. Please. That's not how our system works. Let's talk about the matters in dispute. Now we'll do that briefly. Taymor McIntyre is charged with capital murder. And as you heard, what they've alleged is this was a murder committed during the course of a robbery or attempted robbery. But that extra part is when you heard all the questions being asked of you during jury selection, everybody paid a lot of attention. It was because that's what's required to prove that offense. You have to prove both murder and that it was during the course of a robbery. And that's going to be an issue in the case. But let's talk about one of the disputed issues, the murder, the shooting. It is interesting in this case, what you will find is that there was only one spent shell casing found in the car. The black Kia that was owned by the state's key witness. That spent shell casing, when it was originally identified by the prosecution's technician, they identified it as a 40mm shell. Later, another or I'm not sure, but the technicians in the prosecutor's office, weeks, months later, re-examined the shell casing. It became important. And they decided it wasn't a 40mm shell. It was a caliber shell, 40 caliber. It was a 9mm shell.
So the first technician says, "Oh, it's a 40 caliber," and let's re-examine it. Oh, it's a 9mm. Didn't they read on the bunt of the shell casing what it was? Or was it one without any text? Didn't they have that slide measuring thing to actually measure? How do you mismeasure a shell casing? Anyone? Oh, thank you. Surreal Goose, thank you so much. $10 says, thanks, Nick. Oh, thank you. Thank you so very much. That's very generous of you. Oh, we're off to a good start with the investigators. Oh. Has anyone seen Discovery? Will they be allowed to use his music? I have not followed this pre-trial. I have not. So I don't know. We will see.
That casing, that spent shell casing, as most of you know, comes when you fire a projectile, a bullet, the shell casing remains behind. This one remained in the vehicle. 9mm shell casing. While there was a mistake initially, that goes to all of our, when we watch it, all the AI and all the technical magic that we see on TV, mistakes are made. It may not be important in this case, But I think we can all agree now it's a 9mm, not the 40mm that they originally thought it was. That empty spent shell casing found in the black Kia that was located the night of April 23rd, 2017. So there was only one shell casing found. There was another bullet. It was a 350 caliber, 380. I've got my muzzle sniffer here. Correct me. 380. That's not a derogatory comment. There was a 380 bullet, but it had not been fired. And that bullet was found in the seat where Taymor, Tay-K, allegedly was sitting that night. But the only spent shell casing, the only one that was fired, that's found in the black Kia that night, is a 9mm spent shell casing. There was also only one weapon recovered in this case. It was a 9mm Smith & Wesson, seized from the co-defendant that able counsel for the prosecution mentioned to you earlier, Jalen Bell. He had a 9mm Smith & Wesson, the same caliber. It was months later when he was arrested in Dallas-Fort Worth area. But it was the same caliber, the one weapon that has been seized, as the one shell casing that was found. Now, you've got one shell casing, 9mm, one weapon, 9mm, a Smith & Wesson. And you would think that the evidence would show that they compared them. That weapon sat for 7 years in evidence room between Fort Worth and San Antonio, years here in our own evidence. No one ever tested them. No one ever compared them until John Hunter. He kind of looks like Harry Potter. Well, no offense. He was one of my best students and he worked for me for a long time. So I think I have the right to make fun of him. He makes fun of me too, and you'll probably hear it. But here is the interesting part. No one ever compared them until he requested from this able prosecutor, who then located the weapon, and they had it tested by a technician, like the prosecution technician that mistook the 40 caliber that was actually a 9mm. And he says that weapon, that 9mm spent shell casing, matched the weapon that had been sitting in evidence rooms for 7 years. You're going to hear, I believe, conflicting testimony. It's going to be brought to you, but it's not going to, we have to wait. Remember I told you, they get to go first and last, and we're kind of sandwiched. Well, the part of our sandwich is after their piece of bread that goes first. They get to go first. So please, it's like, you've all been to the movies and you see a trailer and you think, God, I'm going to like that movie. And you go see the movie and it's not nearly as good as the trailer. You think I wasted, when I was a kid here, I could go to the Majestic for 15 cents. It's a lot more expensive now, but even then I felt ripped off when I thought, gee, the only.
That is a good analogy. That is a very good analogy. Think of it as a trailer for the movie. It sounds good, it looks good, and then you go watch the movie and you feel ripped off. Oh.
A good part of that movie, they showed me in the trailer. And I sat there for 2 hours. Well, I'm going to ask you to wait to hear this conflicting evidence. It's worth the wait, folks. This is a movie worth waiting for. Additionally, and kind of almost more importantly, is that the state, after 7 years, finally asked Jalen Bell, this co-defendant, about the 9mm weapon that he had. He said, "Oh no, that's not the weapon I had back in April of 2017. That was a different Smith & Wesson 9mm." 7 years later, What are we supposed to do about that? Those are all interesting issues of evidence that I would suggest to you are questions that might cause you to have a doubt based upon reason. But that's your decision. When you make important decisions in your life, whether it's to buy an encyclopedia or a new car or a new house, you have to decide how to trust someone. And that's the next issue you're going to be confronted with. How do you decide whether you believe somebody? How do you? Well, we all have that instinct, and we look at people. We listen to them. We watch their demeanor. Are they the kind of person we want to believe? Will we buy an encyclopedia from them? Will we buy a car from them? We've made mistakes, all of us. In 81 years, I've made plenty of them. But I will tell you this. This is a time when you're going to have to make those decisions. And you look at the evidence, you look at the witness, and you have to make a decision. What would help you? What evidence would help you decide whether or not to believe someone? Well, is there something that corroborates it? They say they were in New Orleans on a particular day and they got a plane ticket to New Orleans. They got a hotel room in some hotel in the French Quarter. Well, that doesn't say they were there, but at least it corroborates it to some extent. You also want to know, why would somebody tell a story like that when you're looking at this evidence if it's not the truth? Well, wouldn't you want to know what they said before? Wouldn't you want to know if they were paid something for their testimony? That'd be important to me. I mean, people could get paid with money. People can get paid with something more valuable than money, their life and liberty. You're going to see that the state's key witness was paid mightily with her liberty. She was promised something, and she got it for her testimony that met the prosecution's theory of this case. I can't promise anybody anything. I can't pay them. Not with money, not with their liberty. That would be a crime. How can we call a system fair that allows only one side to pay for what they call the truth? Well, that's what you're going to have here. You're going to have to decide whether this witness is believable. I want you to watch them. I want you to watch them. See whether this is the kind of person who you want to put your trust in. And give some consideration to what they got paid for that testimony. What would someone say if it would mean facing a capital murder case or walking free today?
That's a good point.
And coming to this school. How much is that worth? Is that worth telling the story that meets the theory of the prosecution? We leave this case. That's all right. I was hoping that San Fernando's bells would be ringing, but I'll settle for the tinkle. We're going to leave this in your hand. We picked you all, both sides, because we trust you. They say use your common sense, use it. Listen to the lawyers. We don't give you evidence. Our arguments are not evidence. But I think I'm going to listen to them, and I want them and you to listen to me and to John. John's going to have the heavy load in this case, as well he should. But I'm going to be watching it like y'all. We trust you will come to the right decision. All I ask, as the old man in the room, is that the next morning after we finish this case, you can look in the mirror and say, I did right. You can look in the mirror and say, the life and liberty of this young man was worth holding the prosecution to their burden. That's important. That beyond a reasonable doubt, the 12 members of this jury is a time-honored tradition in this country. It's what sets us apart from every other country in the world. I take pride in what I do. So do they. And I hope you will. And when it's all said and done, you can look in the mirror the next morning, the day after, say, I did. I did right to myself, my family, and to young Taymor. And ask for nothing. Thank you.
Thank you. All right, state, call your first witness.
State calls Ashley.
Okay, here we go. Good opening statements from both parties, in my opinion. Short, concise, to the point. No need for a lot of flowery things. Add sprinkles or anything. You can actually do an opening statement that is impactful in quite a short amount of time. As Dave says, very professional, very appropriate statements. All right. Moving towards the first witness.
All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
Okay, why is she wearing a face mask?
All right, make sure you speak up so that members of the jurors can hear. You can lower your hand, state your name for the record, and if you could spell your last name, please.
Ashley Buenteo, Buentelloo.
Let's see, what did she say? Oh,
I solemnly swear for the juror.
Telloo.
there. Let's get a banner up. Dun, dun, dun. There.
Buenteo. Am I witness judge?
Yes.
Ms. Buenteo, there's a microphone in front of you, so I'm gonna ask you to use it because you're a little soft spoken, okay?
That applies to you too, prosecutor.
No, if the one that usually does. All right, and did you spell your name for the court reporter?
Yes.
How old are you currently?
I'm 28,
Okay, and what city do you currently live in?
San Antonio, Texas,
And how long have you lived in San Antonio, Texas?
my whole life.
I'm gonna reposition because I'm having.
Okay.
You could just move a little closer.
Okay.
Okay, so how old are you again?
28,
Okay, and what city do you currently live in?
San Antonio,
Okay, and how long have you lived in San Antonio?
my whole life.
Okay, what school did you attend in San Antonio?
Linear.
Linear High
Your
School?
Honor,
Linear
I'm
high
so
school,
sorry,
yes.
I still cannot hear the witness's answers.
All right, so you'll need to lower your mask, please, so that everyone
Well,
can hear.
or at least bring the microphone up.
All right. And just make sure you speak loudly. All right.
Sorry, I'm gonna ask you to lean into the microphone, okay?
This one?
Yes.
Okay.
Okay. So how old are you?
28,
There you go. What city do you currently live in?
San Antonio,
And how long have you lived in San Antonio?
my whole life.
And what high school did you attend in San Antonio?
Linear high school.
Okay. And do you work currently?
No, ma'am.
What do you do for?
I'm a stay-at-home mom.
Stay-at-home mom?
Yes, ma'am.
Okay, and why are you here today?
To talk about the events that happened in 2017.
Okay, so I'm gonna turn you back to that date, April 23rd, 2017. Do you recall you were with that day?
Yes, ma'am. I was with family members. I was with my tios, my husband, and my grandma,
Okay, and so what's your grandma's name?
Janie Reyes,
Okay, and what are your tios' names?
Paul Caballero, and Ernest Reyes,
Okay, and your husband, what is his name?
Raul Quintero.
Your Honor, a juror has raised their hand.
Yes.
Was it?
Oh, I'm so sorry. So here's the thing. As jurors, you're not allowed to ask. No. It's fine. Sometimes, we don't know. So jurors, you're not allowed to ask questions. If you're not allowed to hear what a witness is saying, raise your hand and let us know. But the state and the defense, they are the persons who will be asking the questions. And if there's a question that you would like a witness to have been asked, you will just have to go with the questions that both sides have asked. Right. All right. You may continue.
Oh, no jury
And when you say
questions.
tio, what does that mean?
He's my tio,
Like uncle?
my uncle. Yes.
Okay, and can you just say briefly how you're related to them?
He's my mom's brother, and that's my mom's mom.
Okay. And so, what were you all doing on that day? Do you recall?
Yes, we were getting stuff ready for my grandma's upcoming birthday party that we were planning.
Okay. And were you traveling in a car?
Yes,
Do you recall what kind of car that was?
we were in a red Chrysler.
Okay. And Your Honor, may I approach the witness?
Yes.
So I'm going to show you what's been marked as State's Exhibits
Okay.
1 and State's Exhibit number 2. Have you seen these photos before?
Yes, ma'am.
And are they a fair and accurate depiction of the objects that are contained within on the day of the offense?
Yes, ma'am.
Okay, Your Honor, hinder offense or inspection. And state offer states 1 and 2.
I'm so sorry. I can barely hear what she's saying. What did she say to people? No objection.
All right, State's Exhibits 1 and 2 are admitted without objection.
May we publish, Your Honor?
Yes.
I'm going to show you what's been entered into evidence as State Exhibit number 1. And you just had an opportunity to look at that, but is that the red Chrysler that you were traveling in?
Yes, ma'am.
Okay, and can you tell me who's in the driver's seat?
That is my uncle Ernest.
Okay, and who's in the back seat right there?
Down is going to be my grandma.
And in State's Exhibit number 2, can you tell me who's contained in that photo?
That is Paul. He was in the front, and that is my husband, Ro.
Okay, so just for clarity, in the front passenger seat, who is sitting there?
Paul.
Okay, and then in the back, or directly behind that, who's sitting there?
It's Raul, and then me in the middle, and my daughter on my lap.
Okay, thank you very much. And so you guys were traveling in the car, and ultimately, did you guys end up at the light at McCullough on 410 access?
Yes, ma'am.
Okay, and when you pulled up, do you recall what color the light was?
We came to a red light.
Okay, and was there cars in front of you and behind you?
Yes.
Okay, and so at some point, did somebody get your attention?
Yes, there was a woman who came up to us because our gas tank was open, the lid.
Okay, and so when she informed you that the gas tank was open, what did the people in your car do?
Paul was the one who got off, and he went to go and close it. And then she informed us that the vehicle.
You're saying confrontation.
All right, that objection will be sustained as to hearsay.
So you can't say what the lady told you, but so you said Paul got out and closed the gas tank, is that correct?
Yes.
Okay, do you recall what kind of vehicle was behind your red Chrysler?
It was a black 4-door vehicle. I'm not sure what.
Okay, and at some point, did your attention turn to that vehicle?
Yes,
Okay, and why is that?
because there was a altercation that was going on, and so we all turned to look what was going on.
Can you please describe to the jury what you observed when you turned around to look inside of that car?
When I turned to look around, I did see McIntyre in the passenger side.
Your Honor, I'm going to object. Can we approach?
Yes.
Oh. Okay, I wonder what's going on. Are we allowed to hear this? No. Judge Boyd is very thorough when it comes to what we are allowed to hear or not.
Ms. Wendale, and how do you Ms. Wendale, and how do you know that the person that was in the front passenger seat name is not McIntyre?
After like when they ended up catching him, I guess, like the news.
Going
All
to
right,
do my
so,
objection, Your Honor.
yes. Your objection is sustained. Ladies and gentlemen of the jury, you disregard her answer with the name McIntyre in it. Does everyone understand? So you're to disregard the question and you're to disregard the answer.
Your Honor, we would respectfully move for mistrial.
That will be denied. You may proceed.
Thank you, Judge.
Okay, here we go. Here we go. I mean, this witness is apparently not prepped at all with you cannot say certain things. And this is on the prosecution.
So can you, without naming the person,
Okay.
can you describe what the person in the front passenger seat looked like?
He was a black male.
Okay. And the person that was driving the vehicle, do you recall what they looked like?
She was a white female with blonde hair.
And so when you're When you turn around and you look in that black four-door, what did you observe going on in that black motor vehicle?
There was a Mexican that was sitting in the back, getting beat up on by the people that were in the front and in the back, sitting with him.
Okay, and so when you say the Mexican boy that was sitting in the back seat was being beat up on, who was exactly beating up on?
Just the two guys, the black male in the front and then also the one in the back.
And did you see anything in the hands of the black male in the front?
Yes,
What did
The-
he have in his hands?
it was a handgun, a black handgun.
Okay, and where was that
And
pointed at?
he was also using it to hit him.
Okay, so it was being used to strike the person in the back seat, is that correct?
Mhm.
Okay, and so the person in the back seat that was being struck, eventually what happened with that person?
He somehow ended up getting out of the vehicle, and we had thought that was it, but he ended up getting on top of the vehicle.
First of all, well, if you actually see these kind of things, it's still impressive to have this amount of memory of the events. But seeing what happened inside a car in this detail, I'm not buying it. I really am. Even if it's the clearest windows of all times, that's really hard.
Vehicle after.
Okay, and so when the light turned green, what did your car do?
We ended up taking the right that was right there because with the gun situation, we had my daughter, so we ended up turning to safety and they ended up going straight.
Okay. Your Honor, may I approach?
Yes.
So I'm going to show you what's been marked State's Exhibit number 3, and you reviewed this before, correct?
Yes,
And you're familiar with the area.
Just so if you were in a car with your child, would you, there's an altercation, would it be to stare intently into the other car or getting to protect your child?
Where this occurred, right?
Mhm.
And so this is a fair and accurate depiction of the location. Is that correct?
Yes, ma'am.
Okay.
No objections.
All right, and that's State's Exhibit number 3?
Yes, Your Honor.
State's Exhibit number 3 is admitted without objection.
Okay, Ms. Fuenteal. And so, can you see that okay up there?
Yes, ma'am.
All right. And so you see where I'm pointing at, that's McCullough Avenue, correct?
Mhm.
And so, where I'm pointing at right here, is that where your vehicle was stopped at the red light?
Yes, ma'am.
Okay, and so earlier, you said that your vehicle took a right, is that correct?
Yes, ma'am.
Okay, and so that would have been traveling a right down McCullough
Mhm.
Avenue? Okay, and so then where did your vehicle go from there?
We ended up turning to the left into the shopping centers that are right there.
Right in here?
Yes.
Okay, and so when you turned into the shopping center, what did you hear? Did you hear anything at that point?
We heard one gunshot.
Okay, and after you heard the gunshot, did you see anything associated with the Chick-fil-A?
We saw the black vehicle speeding off.
Okay, and is that the same black vehicle that was behind you?
Yes, ma'am.
Okay, and is that the same black vehicle where the Mexican boy got on the hood?
Yes, ma'am.
Okay, and you said you observed it speeding off?
Yes, we had saw it taking a left that way and we were coming from this side.
Okay, so you're right here, is that correct?
Shouldn't it be I saw it, not we?
Yes.
Okay, and you're saying you see that black, come out through here and take a left, is that correct?
Yes, it's speeding off. Mhm.
Okay. And so, once you see that, what do you and people in your car do?
I mean, once we heard the gunshot, we were just like talking about it, and then passing the Chick-fil-A, we ended up seeing him rolling on the ground.
And when you say him rolling on the ground,
The Mexican. The Mexican?
the Mexican boy that was on the hood?
Yes.
Okay. And so when you see him rolling on the ground, then what do you do?
We got off the vehicle. Me, Paul, and Raul, and we ran to him.
Okay. And when you observed him, the Mexican boy that was laying in the Chick-fil-A parking lot, that's the same person that you observed.
Okay, if I get this right, they went right to the shopping mall, whatever's. The other turned over to the Chick-fil-A. We are talking about how this is quite a distance. And still she makes these claims. After, this is 8 years later. And this might be a bit of confirmation bias here, that she, after 8 years, she probably knows everything about this case. So it would be interesting to see what she actually told law enforcement at the time of the incident.
And the black Kia getting beat up on,
Yes,
is that
ma'am.
correct?
Mhm.
Okay, and so when you observed him, did you notice if he had any injuries?
He had a big bump on his forehead.
And did you make contact with officers on that day?
Yes, ma'am.
Okay, and did you provide a verbal statement to the officers on the scene?
Mhm.
Okay. And who passed the witness now?
All right, defense.
Thank you, Your Honor.
All right. That, well, I like even if I'm playing this in 1.5 speed, they are very short, concise questions. Just tell us what you saw. Now, I do think this witness is elaborating a bit too much because it's a bit too detailed. So now it will be interesting to hear on cross-examination. I assume that they have some kind of information regarding what she said at the time.
Good afternoon, ma'am. How are you?
I'm okay.
I just have a few questions for you. The first is, did you meet with the prosecutors at all in preparation for your testimony here today?
Like 2 weeks ago
Okay. You met with the lawyers themselves or with the advocate, or do you remember?
with her.
With Ms. Galloway?
Yeah.
Okay. Did you review anything in anticipation of your testimony?
Just everything that happened, like from the cameras.
You reviewed your previous statement?
Mhm.
Okay. And so you were standing outside the Chick-fil-A when you gave that statement to police, right?
Yes, I mean, yes, sir.
And you recall you were explaining to the officer several things that you had learned from other people in the parking lot and who were waiting for police to arrive. Do you remember that part of your statement?
No.
You don't remember the officer telling you to only tell him what you personally saw?
Oh, yes, yes.
That happened, right?
Mhm.
So by the time you spoke to the police, you had already spoken to several other witnesses to the incident, correct?
No, just the people I was with.
Okay. So you had talked amongst yourself.
Yes,
And how many people were in the car?
5 of us.
Okay. And what seat were you in?
I was in the middle and the back.
You were in the middle and the back.
Mhm.
Okay. So you didn't see the altercation first. Who saw it first in your car?
Paul.
Paul.
Paul. He was
He was the driver?
no, he was the one who got out to close the
The gas tank?
yes.
Okay. So he got out and closed the gas tank, comes back into the car and says, there's some people fighting in the car behind us. Is that basically it?
Yes.
And that's what prompted you all to turn around.
Mhm.
Do you know how long roughly that light that you all were parked at lasted?
It was a good minute.
Okay. Minute, couple minutes, something like that?
Yeah.
Okay. So what you saw happened very quickly.
Yes.
Okay. And is there tinting on that car? It looks like it from the photographs they showed you.
On our car?
On your car, yes, ma'am.
No.
There's no tinting at all?
No, not not like out the back window.
Uh-huh.
Maybe the sides, maybe, but not out the back.
Okay. And you're looking at the car directly behind you?
Yes, there's the car right behind me.
Okay. Is it parked like bumper to bumper? Is it parked back a car length? About how far from your back bumper would that car have been stationed?
The very next car, like
Okay.
right
And-
waiting for the
But she still saw what happened all the way in the back of that car.
light.
And you were watching for the whole time that the light was red?
Yes.
Now, you had someone in your lap, right?
Yes.
And so when you say that you're watching it, are you talking about craning your neck, or are you talking about you repositioned your entire body so that you're
No.
looking that direction?
Yeah. I'm looking back. Like
Okay, but basically your belly button's still facing forward. You're looking back this way?
no, I like turned. I was able to turn.
So more like kind of a side view.
Yeah.
Okay.
So there were 5 people in the car plus a kid in your lap, and you still managed to turn?
And there were how many people did you say in the vehicle?
Well, 6 including my daughter, but it's 5 of us.
Okay. Fair to say that there are obviously things in that car that block a full view of everything going on in the car. You'd agree with that, right?
Like,
Well, there are two seats in the front part of the car, right?
Mhm.
There's a driver's seat and there's a front passenger seat.
Mhm.
And there are people occupying those seats, right?
yes.
You can't see through the people or the seats, right?
No.
And so you can't see the parts of what's going on in that car that are obstructed by those seats and those people, correct?
You're talking about the
behind you.
vehicle behind us?
Talking about in the vehicle behind you, when you're looking into that vehicle, you
Mhm.
can't see what's obstructed by the front passengers and the front seats, right?
Well, you can because the Mexican was sitting right in the middle. So like, given those two that were in the front, you were able to see what was going on in the middle.
You can see what's going on in the middle. You can't see what's going on either side of the middle, though. You'd agree with that?
Yeah.
And so you can't say definitively who had a gun and who didn't have a gun amongst all the people in the car, right?
The only one I saw was the one in the front.
But there's nothing about what you testified to today that you want to convey that there weren't other guns, right?
Not that I know of.
Okay. And you don't know who pulled a gun first, right?
No.
The altercation had already started when it was brought to your attention that it was happening, right?
Yes.
They were mid-fight when you looked at it.
Yes.
And you said that the Mexican man got out of the vehicle, right?
Mhm.
And he continued to, I guess, argue, verbally gesture with the people that were still in the car.
I mean, he got out. He kind of like made a run for it, but they had already closed the door. And as soon as the light turned green, he was on top. I'm not sure. Like, we didn't have the windows down to hear what was going on.
And you didn't see how he got on top.
No. Well, yeah, he just jumped up on front.
Okay, so you saw him jump on top of
Yes.
the hood of the car? Okay. So did you see him crawl over anybody as he exited the car?
No,
Okay, you just saw him exit the car.
we just saw him exit the vehicle.
Okay. And you saw him stomping on the windshield?
No, we didn't see that part.
By that point, the light had turned green, right?
Yeah.
And so cars were beginning to move,
Mhm.
right? I'm sorry, ma'am. Yes or no?
Yes.
So your vantage point is at that point changing as your car is moving and their car is moving, right?
Yes.
And you didn't actually see the gunshot, you just heard it, correct?
We just heard it. Yes.
By that point, you're parked further over towards the music store
Mhm.
and not in the Chick-fil-A parking lot proper, correct?
We weren't parked. We were driving because we had just turned in there just to turn in there to get away from all of that.
So you're driving away from all of it and you hear a gunshot just in the car.
Yes.
That's the witness.
No further questions. Judge.
All right, is this witness excused or subject for recall?
He's by the seat.
Excused by the defense, Your Honor.
All right, the rule has been invoked. What that means is you're not allowed to watch anything about this trial, and you're not allowed to discuss your testimony with anyone. Do you understand?
Yes, ma'am.
All right, make sure you leave the clip. And you are excused.
Back that way.
State, call your next witness.
This is state calls Paul Caballero.
Okay, next witness is Paul, also a person in the car.
If you can have him if you put that little mic on your shirt so the court reporter can hear. All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. Make sure you keep your voice up so that the jurors can hear. If you'll state your name for the record and spell your last name, please.
Paul Caballero. Last name Caballero.
Right, state.
Thank you, Your Honor. Mr. Caballero. Well, one, nice to see you again. I've seen you a few times for this case. Is that right?
Yes.
And we met here in the courthouse. Is that right?
Yes.
And I'd like to go ahead and jump right in and ask you if you remember that day back in April 2017, on the 23rd of April to be exact. Do you remember that day?
Yep. One thing that caught my attention here was this other witness said that the Mexican guy sat in the middle. And then all of a sudden he was out of the car. That's kind of an adventure if you're in the mid seat between two people to get out of the car. Skillepan, what's with the mask? Is this from 2020? I don't know. I've seen this in a bunch of trials with witnesses using face mask. I think it is that people just don't want to be recognized more than, oh, I'm sick.
Yes.
And speaking about that day, were you in a vehicle that day with some of your friends and family?
Yes.
And do you remember where that vehicle was located on the road in San Antonio?
Yes, we were on 410 and Hello.
I'm sorry, what?
410 and Hello. Sorry, I stutter sometimes.
No problem, no problem. If you don't mind, that first mic that's in front of you, just make sure you speak into there so people can hear you, okay?
Okay.
I'm a little hard of hearing, so just bear with me. But one, what do you remember what type of vehicle that was that y'all were driving at, or rather that you were riding in that day?
Yes, we had a red Chrysler 200.
And you want me to approach? I'm
Yes.
going to show you some items that have already been entered into evidence. State exhibit number 1 and state exhibit number 2. Are you familiar with those?
Yes,
And are those photos of one of that Chrysler that y'all were in that day?
yes,
And does it also show individuals that you know in those photos?
yes,
And if in state exhibit number 1, can you identify the individual that's driving the vehicle?
yes. Ernest, my
Ernest?
partner.
Thank you. And then who do you see somebody in the back seat there?
Yes, his mom,
His mom. And what's her name?
Janie Reyes.
And in state exhibit number 2, can you identify the person standing there?
Yeah, that's me.
That's you. Okay. And then is there anybody in the back seat that you can see or identify?
Yes, Ashley and Raul and her baby.
And her baby, I guess you can see the top of the little baby's head there.
Yes,
Okay. So in addition to you and Ernest, which was the driver, is that correct?
yes,
And were you do you remember where you were sitting that day? Were you sitting in the front passenger seat or the back passenger seats?
and the front passenger seat.
Front passenger seat. So next to the driver.
Yes,
And then is that where Raul was, in state exhibit number 2, is that where he was seated at the time?
yes,
And also Ashley and the baby.
yes,
And then of course we got Janie Reyes sitting all the way to the left in the rear.
yes,
Okay. So this is accurate of how y'all were seated when y'all were at the intersection also?
yes.
Okay, thank you. Now, speaking of the intersection, I'm going to show you what's been marked state exhibit number 3. And are you familiar with this map?
Yes,
In fact, have I shown you this map before?
yes.
And so you've seen this map before. Can you point out on there where that intersection, McCullough and 410 is?
I'm sorry. It's right there.
Okay. And then where was your vehicle at?
We were right here behind the truck that was in front of us.
Behind a truck that was in front of you.
Yes,
So there was a truck in front of you and then your car.
yes,
Okay. So on this overhead projector, I'm going to zoom in here. And I'm going to point to where you pointed. You pointed to this vehicle right here.
yes,
And that's, let me make sure. This is not a map from that day. Is that correct?
no,
I mean, some things have changed on this map, but generally this is how it looks.
Yes.
Because that's the main intersection. It hasn't really changed since 2017.
Objection, speculation.
That'll be overruled. If you know the answer, you can answer.
I'm sorry. If you can repeat the question, please.
Sure. This intersection hasn't changed much since 2017.
think so.
Actual road, it hasn't moved.
Okay, yeah, no, the road's the same. I'm looking at this over here. Sorry.
Hey, bad question. Bad question. I'll move on from that, but this is the intersection that we're speaking of, correct?
Yes,
Okay. And you, like you stated just previously, that this vehicle right here is roughly where y'all were at that stoplight. Is that
Yes.
correct?
yes,
And, well, let me ask, were you stopped at that time, at that light?
yes,
And so is it assumed that did y'all have a red light?
yes.
And when you were at that light, did anything catch your attention?
Yes, there was a lady that was on the site that told me that my gas cap was open.
Gas tap was open?
Yes.
And so you're at a stoplight, so what did you do?
Well, I exited the vehicle and put the cap back on.
You know, where was the cap in comparison?
It's on the passenger side.
Passenger side? So let me see if it's. Okay, so state exhibit number 2. Show it to you again. Is that the gas cap you're speaking of?
Yes, it is.
So it's on the passenger side. Good, state exhibit number 2 here. Little zoomed in, but I think we get the picture that there's the gas cap is right there. Is that correct?
Yes,
And this lady told you that the gas cap was open
yes.
and then you exited. So what did you do at that point?
Well, at that time, as I was putting on the gas cap, she did tell me that the car behind her.
Hearsay confrontation.
The saying to hearsay.
I'll rephrase the question here. I'll ask you, well, let me ask you this. Did you ever replace that gas cap?
Yeah,
Did you
yes,
close
I
it?
closed it. Yes,
And after you closed the gas cap, what were your actions right after you closed the gas cap?
Well, the car behind us, I saw a gun. So at that time, I proceeded to get back in the vehicle and told my partner, as soon as that light turns green for us to make a right to get out of that car sway that was behind us.
Well, let me back up a little bit.
Okay.
And without telling me exactly what she said, did the lady that had mentioned the gas cap to you, did she mention something else to you?
Objection,
Yes.
hearsay, confrontation.
All right, the answer is either yes or no. You're not allowed to state what a witness has said. Do you understand?
Yes.
So that question requires a yes or no answer. Do you understand?
Yes.
All right.
And I think you answered the question if I'm correct, but
Yeah.
did she also mention something else to you?
Yes.
And can you tell the jury, like, what was her demeanor towards you when she was speaking to you about this?
Just very cautious,
Very what?
cautious,
Cautious?
like worried. Yes.
Okay. And then what did she say to you then?
Objection, hearsay, confrontation.
All right. So can I have parties approach?
I mean, prosecutor, you can't, you don't elicit that. I mean, you know bloody well that asking a witness, what did that person tell you? That's hearsay, and you know it, and you got objected to and sustained. Can we please hear this? Judge Boyd, can we please hear this? No, we can't.
You may proceed.
After this lady talks to you, what do you do next?
I get in the car and then I told my partner once the
Objection,
light turns
hearsay,
green.
That's going to be overruled. It's what he's saying.
Yes, Your Honor, but it's still he's relaying his out of court statement.
All right. That objection will be overruled.
You can answer the question.
I said once the light turns green to make a right.
All right. And the court will note for the record that that answer was previously stated.
And then what did you notice about a vehicle behind you?
Well, I looked back. I had looked back and I saw a passenger. He had a gun. That's what I saw. And then there was a little kind of like scruffle, like if he was fighting with somebody in the back seat.
Was somebody, okay, so there's a struggle,
Yes.
and let's just break that down.
That's not what the previous witness said exactly, that the guy in the front passenger seat was fighting with somebody in the back seat, was it? So, well, and by the way, thank you. Hey, just got raided by Dolly Talk. Thank you, Dolly. And for you who just joined, we are watching State versus McIntyre, also known as J.K., a local Texas rapper who is charged with murder, capital murder. And yeah, so this is day one. Day one. We are a couple of days behind, but there are a bunch of breaks and lunches and everything, so we will catch up eventually. Oh, and JK is already in prison for sentenced 55 years for another murder.
Did you turn around and look, or did you look in a mirror? How did you look to the car behind you?
I turned around and looked.
And so were you in the vehicle or were you outside your vehicle when you looked?
No, I'm going to object to leading. He can just ask him in a more direct way how he approached him and what he saw.
All right. The objection will be overruled. You can answer the question.
I was in the car.
And so which way did you turn around, or to your left or to your right?
I believe it was my left.
And so if it's to your left and you're sitting in the passenger side, that means are you looking through the back window of your
Yes.
vehicle?
Yes.
And so were you able to see, what were you able to see?
I saw the passenger of that vehicle fighting with somebody in the back.
And let's talk about that person in the passenger seat in the car behind you that you mentioned. Do you recall what that person, what that person looked like?
Your Honor, may we approach?
Yes.
Okay. folks, oh, I almost forgot this. Where is it? Where is it? Let's see here. This will be sidebar counter 3. Yeah, here we go. This it looks like it's going to be a sidebar trial. So here is the sidebar counter. And first 2 witnesses, 3 sidebars.
My question was, can you describe the individual that was in the passenger seat in the car behind?
He just looked real young.
Sorry,
He was real young.
real young.
Yes, young.
Do you know what, was he white? Was he Hispanic? Was he African
Hispanic.
American?
Hispanic?
Sorry,
Hispanic?
can you approach, Your Honor?
Yes.
Your Honor, I'm going to object to the presentation of that document unless it's laid a foundation for past recollection refresh.
I don't know if that's what he's doing because I don't know what the document is. So state you're approaching the witness. You want to mark whatever exhibit it is.
I agree
let's read
with
this
MG
statement.
Law. It's amazing how
You have
much
an
all these
opportunity to
people
give
were
a statement
able
the police
to
officer. I mean,
see through seats, frame, passengers. Was it for instance, was this a sunny day? Well, then sun would be reflecting off the windshield and you wouldn't see a damn thing. And even if it was cloudy and you could see somewhat I mean, it's not that easy to see the ethnicity of a person in the car behind you if you're going like this, because you're more or less only watching with through the corner of your eye.
to the police department that day.
Yes, I did.
And was it typed out?
Yes.
And was it typed out by a police officer and then you read it and signed it? Is that correct?
Yes.
And I'm going to show you what's been marked State Exhibit number 5. Can you just please review that and tell me if that is the actual typewritten?
Why are they allowed for him to review his written statement? This is weird. Isn't he supposed to testify from memory?
Statement and signed by you back on April 23rd, 2017.
Yes, it is.
And I know that you're nervous today. You mentioned that to me.
Yeah.
So let me ask you, in this description, can you read through it? And don't read it out loud, but to yourself. And can you tell me that when you look
To my nobody asked him if he needed something to refresh his recollection.
to the back,
Your Honor, I'm going to object to the question. Foundation has not been laid for him to be reading his statement to answer the question.
All right, that objection will be overruled.
Okay.
for time purposes,
And defense, you may move about the courtroom if you want to see what the statement is that's being shown to the witness.
Thank you, Your Honor.
Yes.
now previously, I just asked if you remember the race or the of the individual that was in the back in the car behind you in the passenger seat. Do you recall that?
Yes.
And you say it Hispanic.
Yes. I thought you were referring to the person in the back seat,
Oh.
not the passenger.
Okay,
So that's where we got confused.
that's my bad. I apologize. So let me rephrase my
Yeah, just for the record here, Tay-K is black, not Hispanic.
question, and that helped clear it up there.
Yes.
When you looked to the back and you looked at this vehicle behind you, the front seat passenger,
Mhm.
describe that individual to the jury.
He was African American.
And is this the individual that you stated? What would you determine his age possibly to be?
Well, he looked real young. I would say in his
Objection
20s.
asked and answered.
Overruled.
Now, at any time, if you need to refresh your memory, you can refresh your memory.
In his really young, in his 20s. Let me see here. This State v. McIntyre. Jesus Christ. McIntyre.
Okay?
Okay.
That's your statement that you gave. And again, is that the statement you gave back in 2017, April 23rd?
Yes.
Now, there was a driver of the vehicle behind you, was there not?
Objection leading.
Overruled.
I'll
Yes.
rephrase the question. Was anybody driving the vehicle behind you?
Yes.
And so there was a driver of that vehicle, is that correct?
Yes.
And can you describe to the jury that driver?
Female. She looked very young, blonde hair,
And I'm sorry, I couldn't hear you, but did you say the color of hair?
blonde.
Blonde. Thank you. Now, you said that there, in previous testimony, you said there was some type of scuffle.
Yes.
And can you tell me, who could you see participating in that scuffle?
The passenger.
And that is the black or African-American man that you said was in the front passenger seat?
Yes.
And what could you see that individual doing?
Fighting with somebody in the back seat.
I'm sorry,
He was fighting with somebody in the back seat.
in the back seat.
Yes.
Now you named the two occupants in the front. Can you describe to the jury any occupants that were in the back seat of that vehicle?
I just know there was somebody else in the back seat. I didn't really get a description of that person.
Okay. And you see this scuffle going on. At any point, did you see anything else happening back there?
Yes. I believe the person he was fighting with did exit the vehicle. He was yelling for help.
Person that he was fighting with exit the vehicle yelling for help.
Yes.
And
Tay-K. According, is he really 47? No, Tay-K 47. Is that his name? He is 24 years old. He was born 2000. So he was 17 when this occurred, and this man described a person in his 20s. Okay.
did you, at that time, see what that individual was yelling for help? What did he do?
He was asking for help, yelling for help, and then proceeded to jump on the hood of the car.
And now this is all behind you, right?
Yes.
So as you told the jury, you're turned around and looking this way through the window, and you're watching all of this
Yes.
unfold behind you at the stoplight.
Yes.
And after the individual jumps on the hood, well, let me ask you, do you remember if he jumped on the hood like standing, or was he on all four, like on his hands and knees? Can you describe to the jury if you remember?
He was on all fours.
On all fours?
Yes.
And at any time, did the light, what happened? Did the light ever turn green?
Yes.
And at that point, what did, I guess Ernest was driving the vehicle. What did he do?
He went right, as I said.
And so you're saying that from this position here, when the light turned green, Ernest took a right.
Yes.
And the vehicle behind you that had the individual on the hood on his hands and knees, where did it go?
It went straight.
So it would have gone straight through the light.
Yes.
And at that point, where did y'all proceed to?
We went right, and then we turned into that shopping center that was right there.
The shopping center here?
Yes.
And did you ever see that that vehicle with the individual that was on the hood? Did you see that vehicle again in this parking lot?
No.
Okay. Did you ever see that vehicle again?
Yes. After it had. Yes. Yes.
Where did you see that vehicle at?
It came out of Chick-fil-A.
And this is, again, this is a 2025 rendition, so it has some awnings here that weren't there before. But did you see it come out of this parking lot?
Yes.
And where did it go?
It went left, once it was straight, so it went left,
Okay,
going
right.
past. Yes.
And then where did it go from there? Do you recall?
It went by whatever store was right there, and then it just left.
Just left.
And it
Okay.
just left.
And so you're in this parking lot. When you're in this parking lot, did you hear anything?
Yes, we heard one gunshot.
Gunshots. And did that bring your attention to this area by Chick-fil-A?
Yes.
And that's where you just stated that you saw that black vehicle drive through the parking lot.
Yes.
And if I can go back to the actual intersection again, when y'all are driving off, did you look back and see anything in the vehicle that individual was on his hands and knees
As we drove off, yes, he was still on all fours.
on all fours? And did you ever see what that front seat passenger, that African American male, was doing when the individual was on the hood and he was driving?
No, not at that time.
Did you ever see anything in that black African American's hands?
Once we drove
Objection
off,
has to
no.
answer. The first question was,
Overruled.
did you see him?
Overruled.
Oh.
If you could re-ask your question, please?
Yes, may I approach you?
Yes.
I'll ask you to review your statement.
Oh, yes. with-
Again,
with the
object to the
windshield.
lack of foundation. It's never been asked whether or not that's necessary.
All right, you can ask your question. I have no idea what the question is because no question has been asked. I don't know what's being shown to the witness because the court hasn't received information on that.
I'll ask this
Prosecutor
question.
just asking him to review, he's instructing the witness to review his statement, having laid no foundation for tendering that document for him to testify from in front of the jury. He's received no instruction about how he's to handle the exhibit while he testifies. That's continued on, and I'm just renewing that objection now that we're back to it.
All right, state, you may proceed.
Thank you. Now, after reviewing this, did you ever see anything in that passenger's?
I'm not too happy with allowing a witness to check his prior statement before answering the question. I'm quite sure they are supposed to testify through recollection. If not, then he is not necessary. Then just present the prior written statement.
Hand that that African American that was sat in that front seat.
Yes, he had a gun. Yes.
Okay. And is that in your statement that you gave back in 2017?
Yes, it is.
I'm going to show you what state exhibit number 4. One. Have you seen this item before?
Yes.
And can you identify anything in it?
Yes, our vehicle's right there.
And that's you said our vehicle. Is that the vehicle that you testified to that you were in that day?
Yes.
And is that the vehicle that Ernest Aveas was driving?
Yes.
And also you were the passenger in that vehicle.
Yes.
And is this from the day of April 23rd, 2017?
Yes.
And right after you saw the black vehicle exit the Chick-fil-A parking lot?
Yes.
Your Honor, state would offer state exhibit number 4 as evidence. We'll tender to defense for any objections.
I'd just like relevance, Your Honor.
All right, state relevance.
The relevance is, Your Honor, it leads to their credibility that he was actually there that day and that this was actually what he just testified to, that it confirms that he's in that vehicle passing by soon thereafter of the black vehicle with the murder victim.
All right, can I see the state's exhibit 4, please?
I'm sorry?
Can I see
State
state's
exhibit
exhibit number 4?
Neither is an issue, Your Honor, and there's already an exhibit of that same vehicle in evidence. So it's cumulative and not relevant.
All right, so defense's objection to number 4 is overruled. State's exhibit number 4 will be admitted.
Yeah, publish, Your Honor.
Yes.
And Mr. Caballero, is this the
Thank you,
vehicle
Garrett.
that you just testified to that you were in?
Yes.
And where is that vehicle currently? In this photo, where is this vehicle at?
We don't have it no more.
No. Sorry,
Is that what
I don't
you
mean
meant?
the actual vehicle.
Oh.
In this photo, where is it located at in this parking lot? Where is it?
It was right outside of the restaurant,
Okay,
Chick-fil-A.
Chick-fil-A. And is this that Chick-fil-A parking lot?
Yes.
Okay, and this is your vehicle in the behind the Chick-fil-A. Thank you. Now, after y'all drive by, what do y'all do after you drive by? And what do you observe when you're driving by the Chick-fil-A parking lot?
Well, we saw someone laying down on their driveway where the drive-thru was at.
And what did you do at that point?
Well, we went ahead and turned around, parked, and then that's when Ashley and Ro went to go see.
And went to go see the person on the ground.
Yes.
And did you ever approach?
Yes.
And what did y'all do at that point?
I believe Ashley called 911.
Was there any other individuals out in that parking lot?
Yes, there was other few people there as well.
And did you ever touch the person on the ground?
No.
Did you ever try to assist in first aid?
No.
And did you view anything else on or near the person on the ground?
Yes, he had weed on his side, and also it looked like there was weed shoved in his mouth.
And just to be fair, you say weed. Is there another more technical term?
Marijuana?
Marijuana. Okay,
Marijuana.
thank you. And let me ask you: did that person that's on the ground, did they ever speak to you?
No.
Did you ever see any wounds on this individual?
No.
And at any time when you were at the scene, did that individual ever get up or talk to you or talk to anybody?
No.
We'll pass the witness, Your Honor.
Defense?
May I proceed, Your Honor?
Yes.
Good afternoon, sir. How are you doing?
Good.
Prior to your testimony today, have you spoken with anyone from the prosecution about your case?
No.
Okay, so the questions that were put to you, that's the first time you've spoken to a prosecutor?
Oh, sorry. Yes, we have spoke before.
Okay, and in the course of those conversations, have you reviewed any documents in preparation for your testimony?
Just my statement?
Is that the document Mr. Garahan showed you a moment
Yes.
ago?
Yes.
May I approach, Your Honor?
Yes.
When was the last time you reviewed this?
Today?
Okay, this morning?
Yes.
And fair to say, this was written on the day that you saw these events you testified to, right?
Yes.
And what you remembered back then was fresher in your memory than what you remember now, correct?
Yes.
And it's fair to say in State's Exhibit 5, marked for identification, you don't mention seeing anybody on the hood of that car on all fours, right?
Not on all fours, but I did mention somebody on the hood.
Yeah, you're right. You mentioned someone on the hood back on April 23rd, 2017, correct?
Mhm.
But you don't, anywhere in your statement, say that you saw the gentleman on all fours, correct?
No.
And you spoke to police and would surprise you to learn they didn't write down anything about you seeing someone on all fours, correct?
No, because they didn't ask if he was on all fours. They just said I just said he was on the hood. If they asked if he was on all fours, then I would have said he was on all fours.
It's fairly significant, wouldn't you think? Whether he's on all fours or he's standing up on it,
Yeah, but he wasn't standing.
and you didn't see him stopping on the.
This is a bit nitpicking. I mean, he was on the hood.
Windshield of the car?
I didn't see the stomping, no.
But it surprised you to learn that other people in the car did?
Yeah.
Well, let's just talk a little bit about your vantage point. You said that you were in which seat of the car?
Passenger.
Front passenger,
Yes.
right? And there are 3 people on the back bench of the car, right?
Yes.
And the person in the middle seat actually has a child on her lap, correct?
Yes.
So you're looking through all of that to see this altercation, right?
Yes.
You say that when you pulled back around to look at the gentleman that had fallen from the car on the pavement, that you saw marijuana in his mouth,
Yes.
and you saw a bag of marijuana next to him, correct?
Yes.
How large a bag?
Wasn't that big.
Okay. Size of my fist, smaller,
Maybe
larger,
a little smaller.
a little smaller than the size of a fist. Okay. You never saw anyone shoving marijuana in the man's mouth, did you?
No.
And to be fair, you didn't see him eating the marijuana, right?
No.
Sorry.
No.
But somehow marijuana was in his mouth.
Yes.
Okay.
That's weird.
Your view of the back seat of that Kia was also obstructed by the things that were between you and the back seat of that Kia, right?
Yes.
You couldn't see all of the occupants fully from they were in the back seat of that car, correct?
Yes.
You couldn't see all the things that they were doing, right?
Yes.
And you can't say whether there was one gun or multiple guns in that car. You don't know, right?
Yes. I don't know.
You recall telling a policeman that the person that you saw in the front seat might be an African American.
No, I said he was. I didn't say might.
Okay. If an officer summarized you as saying that it might have been African American, that would be the officer's mistake, not yours.
Yes.
May I approach, Your Honor?
Yes.
Yeah, how did a bag of weed get in this kid's mouth? What actually happened in that car? I mean, this is it's weird. It's really weird.
And that's you here, right? Paul Caballero.
Yes.
That's your date of birth right here.
Yes.
And again, on this page, listing you as W1, that's Paul Caballero. That's you, right?
Yes.
And then you'll notice here, if you could just read to yourself this sentence in parentheses.
Mhm.
Let me know when you finish reading it.
This one.
Starting at with that word and then reading this sentence, a particular emphasis on that portion.
Okay. I read it.
Okay. And
Your
again,
Honor, I'm going to object at this point to hearsay and lack of foundation.
I haven't asked the question.
All right, so I don't know what defense exhibit number 1 is.
It's a report that was generated summarizing the statements of Mr. Paul Caballero. And I'm
All right.
showing it to him to see if he is going to accept and adopt the statement that's made or whether he's going to reject it.
And Judge, not to this, he did not write this report.
All right, if I could see defense exhibit number 1, please. And if I could have parties approach.
Seems like there's a discrepancy between the report and testimony. So impeachment. Hi, Nicola. If he's shouting for help, why jump on the car instead of running away? I don't know. It sounds really, really strange. And dun dun dun. Sidebar counter 4. Yeah, as I said earlier, we will catch up.
These are my rules, follow my rules. You're not allowed to discuss anything that you've heard
Oh,
so
they're
far in
taking a
this
break.
case. You're not allowed to discuss it amongst yourself. You're not allowed to start deliberating about this case internally on what you've heard. You're not allowed to watch anything, view anything, or do any investigation. Everything that you need to know about this case is to be presented to you inside this courtroom. Does everyone understand? So I'm going to give you all a break, and I'm going to have you all back here at 3:50. That'll give everyone a chance to have a break, all right? All right, everyone, please rise for the jurors.
Yeah, both witnesses said the front passenger person, an African American young looking guy, had a gun. And that would be Mr. McIntyre. Oh, I want to hear this. Okay, witness is off the stand. Let's see if they're going to talk. Oh, he's back on the no sound. No, he's talking to the judge. Oh, I really want to hear this. Now, jury is back.
All right, everyone, please be seated. All right, defense, you may proceed.
Mr. Caballero, just to be clear, do you recall on the 23rd of April, 2017, telling someone from law enforcement that it was a possible African American?
No.
Okay. Would it surprise you if someone noted that somewhere?
Yes.
Okay. Now, I want to get back to a couple of other things. We discussed the fact that you were looking backwards through someone seated in the middle back passenger seat of your car and a child on their lap, right?
Yes.
and that you were looking at the car directly behind you, correct?
Yes.
And so from that vantage point, obviously the people in your own car are going to be blocking some of the things you otherwise have been able to see. You'd agree with that?
No, because they actually, it wasn't that much of a blockage. Actually, it's real short. So when it comes to the backseat of my window, it was as clear. You know,
Okay.
like I can see.
But you would agree that there are some things you just don't know, like whether
Yes.
there was one gun or many guns, for
Yes.
example,
Yes.
how the marijuana got in the man's mouth or on his person.
Yes.
You just don't know those things.
Don't know.
Whether, and you don't know whether those could have been seen at a different vantage point or they just weren't knowable by anybody, right? Let me rephrase the question. Let me back up. You also were outside of your vehicle, right?
Yes.
And you were fixing the gas cap, correct?
Yes.
And that's when you saw the gun.
Yes.
And when the prosecutor asked you at the very beginning, what was the thing that you saw? The first thing out of your mouth was a gun, correct?
Yes.
Fair to say the gun's the most significant thing you saw about the whole encounter.
Yes.
You said that that gun was silver, right?
Yes.
You said that the individual that you saw in the front seat had short hair, very short hair, correct? Would you
Yes.
refresh your recollection to recall your statement that you adopted on the 23rd of April, 2027
Yes.
or 17?
Yes.
Is that in front of you?
Yes.
Can you review it to yourself briefly and tell me if you noted the length of the hair of the person you saw?
Real short hair.
That you told the officer real short hair.
Yes.
I wonder what
And again,
hairdo
in that same document, you never notated.
I want, because since the defense is really focusing on this, it sounds like Mr. McIntyre did not have very short hair.
You never said anything there about being on all fours when the man
No.
was on the hood, right?
No.
And you said that no one asked you that question, right?
Yes. I just said he was on the hood of the car.
And to be
I
fair,
didn't-
you didn't tell them at the time, no, go back and rewrite the statement. He was on all fours. You didn't do that at the time.
No.
You didn't describe anybody as being Hispanic or Mexican, correct?
Yeah. The person in the backseat was Hispanic.
Okay.
I- 5 p.m.
But you did indicate in your statement that date that you could not see who was in the backseat of the car, right?
Yes.
And you didn't see a backpack, for example.
Oh, so at the time, he had apparently didn't see anyone in the back seat of the car behind. But on the witness stand, he is adamant in guy in back seat Mexican or Hispanic.
No, I didn't see a backpack.
You didn't see anybody struggling over some kind of an object like a bag or a backpack, did you?
No, I just saw the scruffle in the back.
Pass witness.
No further questions, Your Honor.
All right, is this witness excused?
Yes, Your Honor.
Yes, Your Honor.
All right, the rule has been invoked. You're not allowed to discuss your testimony with anyone. Do you understand?
Yes,
You're
ma'am.
not allowed to view anything. Do you understand?
Yes, ma'am.
All right, you may step down. Remember to leave the mic. All right, thank you so much. All right, state, call your next witness.
State calls Ernest.
If everybody in that courtroom is afraid of apparently it's measles, then why are they using the same microphone?
Reyes, Your Honor.
All right, they are running through witnesses. Let's see who's next.
Testimony. Oh, no problem. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. If you'll make sure you keep your voice up so that the jurors can hear.
Okay.
Just state your name for the record and spell your last name.
Hello, I'm Ernest Reyes, Reyes.
All right, state, you may proceed.
Thank you. Mr. Reyes, good voice. You have a voice that travels, so I appreciate
Oh,
that.
thank
So
you.
if you don't mind, keep that up, all right? Sir, I'm gonna go ahead and jump right in and ask you, on April 23rd, 2017, were you traveling with some family and friends?
Yes, correct.
I'm sorry, Your Honor, if we could approach briefly.
Sure.
Okay. And sidebar counter 5. 1, 2, 3, 4, 5. Oh, there's going to be a lot of sidebars, apparently.
Ladies and gentlemen, what I can tell you is, all right, ladies and gentlemen, what I can tell you is usually when people testify, they don't have masks on. but one of the witnesses, is ill and has some illness. So everyone is just trying to make sure that they are protected against any illness they may have. So that is
If that is correct, then why are they using the same mosquito microphone, which they are all touching? Yeah, I don't buy that entirely. I do believe that they don't want to show their faces.
why. And the first witness, the reason why I asked her to lower her mask, because everybody was having difficulty hearing her. But since this witness, no one has informed me that they're having trouble hearing them, I'm allowing on them to keep their mask on, and neither the state nor the defense have any objection to their wearing their mask. But that is why you've seen witnesses with mask on, because they're ill. They have some sort of cough. All right,
Okay, cough,
state, you may proceed.
Thank you, Your Honor.
not measles. Okay.
I think last question you're about to answer is, here on April 23rd, 2017, you were in a vehicle with some family and friends. Is that correct?
Yes, that's correct.
If you don't mind handing you over to exhibit number 3 that's on the monitor there. Did you end up at that intersection of McCullough and 410 Access Road?
Yes, yes, correct.
And on that particular day, who was driving the vehicle?
It was me.
It's you?
Yeah.
And when you're driving the vehicle, are you the one that was driving on this particular time when you came up to the red light at that intersection?
Yes, correct.
And did you stop the vehicle?
Yes, came to a complete stop at the red light.
And your vehicle in relation to other vehicles, were there any vehicles around yours?
Yes, one completely in front of me and one directly in back of me.
And at some point during this stop at the light, did your attention get brought to the vehicle behind you?
Yes.
And do you recall what type of vehicle that was behind you?
I don't know the make or the model, but I do know it was dark black vehicle.
Okay. And what brought your attention to that vehicle behind you?
A person that was in the vehicle with me was notified that
Objection, hearsay, confrontation.
Sustained.
Let me ask you this. At some point, you looked at the vehicle behind you. Is that correct?
yeah, that's correct.
How did you look at that vehicle behind you?
Directly through my rear view mirror.
Did you use any other mirrors or devices to look at that vehicle behind you?
I would switch from my rear view, from the side mirrors, but it was mainly through the rear view.
That is a really good question, Auto Doctor. If they saw a gun, why did they wait for the green light? Yeah, it is perfectly legal to turn right on a red light there. I actually agree. That's a really good question. If they actually saw a gun, there are 5 people and a small child in that car, and nobody says, "Gun, get us the hell out of here." I mean, yeah.
I'm going to show you what state exhibit number 1. Is that the vehicle that you were traveling in that day?
Yeah, that's correct.
And who is that driving the vehicle?
That's me.
That is you?
Yeah.
And who is this in the back?
That is my mother.
Okay.
Yeah.
And then on state exhibit number 2, show you that one also. Is that the same vehicle?
Yeah, correct.
And can you see individuals that are in the back seat?
Yes, that's my niece and her husband and her child, her kid.
Okay. And it's just the names of those individuals that were in the back?
Ashley and Raul.
Okay. And then who is this individual standing here?
That's my partner, Paul Anthony.
Paul Anthony.
Yeah.
What do you call him?
I call him Anthony, but his family calls him Paul.
And was that the individual that just testified today?
Yeah, that's correct.
Okay, thank you. So you just testified that your attention was brought to that vehicle somehow, and while you're looking at and through the mirrors of your vehicle, what did you observe?
Yes, it was a clear view. Right away, I saw a passenger waving a pistol, a firearm, directing his attention to the back seat of the car. because it was an altercation.
So it's a car full of people with a small child. Everybody seems to have seen this gun, and they are not taking off. I don't know about you guys, but if I'm looking at my rear view mirror after somebody telling me there's a fight, somebody has a gun behind me, I'm flooring it. I'm absolutely flooring it.
Sure, it was a struggle in the backseat.
Okay, and so let me ask you, you observed this through the mirror.
Yes, correct.
This is not something that you learned from somebody else.
Oh, no.
This is something that you directly saw looking through the mirror.
Yeah, correct.
And what time of day was this? Well, do you remember what time of day?
So when sun was out, it was about 4 afternoon, 5 o'clock in the afternoon.
Okay, so it was daylight.
Yeah,
So it wasn't like a nighttime day where you couldn't see very well.
no.
And so when you're looking, you said you saw the passenger, and which passenger in that vehicle in the back? Was it a backseat passenger or a front seat passenger that you saw with a gun?
A front seat passenger.
And can you give any description of that front seat passenger?
Not a direct. I mean, I couldn't point out facial hair, tattoos, or piercings or anything, but he was just a black male.
Black male?
Yeah.
And obviously you just stated, I'll just need to ask, could you
absolutely
even tell the
amazed how
age?
much they managed to see.
If you can.
Yeah, no.
And when you're observing this front seat passenger, black male with a gun, you said he was, what was he doing? How was, if he's in the passenger seat up there,
Yeah.
and Your Honor, may I just stand here and
Yes.
demonstrate to the jury, if you're that black male with the gun, and there's a driver, is that correct?
Yeah, that was a female driver.
A female driver?
Yeah.
And so that I'd be right next to you. So if I'm that female driver, and you're that black male with the gun, do you remember which hand he was using, or do you recall? His right hand? Show the jury what that black male with the gun was doing.
Initially, what I did see, he was reaching over like to the back, swinging it and like trying to intimidate somebody that was back there that they were trying to get a control over or something. I'm not sure.
So in the back seat.
In the backseat, yeah.
And so you're saying swing, was the person leaning, or was he turned around? How was that individual?
The gun was in his right hand, and he was just reaching over, like, you know.
And could you tell if it was passengers in the back seat?
I believe I saw 2 individuals. There might have been 3. But yeah, those.
There was individuals in the back.
Yeah, correct.
And you just stated at least 2, maybe 3.
Yeah, that's correct.
Okay. And did you see any other individual in that car with the gun?
No.
I guess to be fair, you couldn't really see all those passengers in the back seat, so you don't know for certain if somebody may or may not have had a gun.
Correct.
Okay. Now, when you see this, I guess what you described as intimidating, or with that gun in the back towards the back seat, what happened at that time? How long did? Well, I'm sorry. Let me retract that question. Do you recall how long that interaction happened? Was it?
It seemed to be like quick. Everything happened so fast. I was focused on the light changing. My attention was fixed on the back, the car behind us. So just a lot of emotions going on. It was quick.
Okay. And so it was pretty quick, you say, and then anything of significance happened after you viewed that?
I just seen them to look like to be beating on the person in the back seat. I don't know if he was.
And you saw all that through your rear view mirror in a car full of people, 5 p.m. with more or less this road. I saw this in chat is due west. It should be glare in the windows.
Forced out or pushed out or with me or what, but at that point, we did end up on the access road on the outside of the car.
Okay.
Just yelling, saying, just give me my things. Give me my
Objection,
things.
hearsay, confrontation.
All right.
This is excited utterance at this point.
All right, then, counsel, if you lay the foundation for excited utterance, and then defense, you can make your objection, and court will make a ruling.
Thank you, Judge. Now, Mr. Reyes, when this individual was yelling just words, was he calm, or what was his demeanor?
No, he was in a panic mode. He was just,
How the fuck do you see that through a window? Or through a... How- Yeah, it's orthodox to say they were facing a sun that was fairly high still at 5 p.m. And you claim to see the demeanor in the back seat of the car behind you. Okay, I do believe that the defense should maybe focus, or not, maybe not, but at least talking about it.
infuriated. Like he was had a lot of adrenaline.
Was he yelling or was he just saying things like I'm saying now? Was he saying it like that or was his voice elevated?
I don't know, elevated yelling.
How did you
Wanting
hear
things,
that?
just saying, give me my thing, give me my thing.
So, okay, let's talk about this. People in this car that he is driving. Behind them, a lot of people claim they see a gun. First of all, you're not flooring it, even though there's a small child in your car. And you're facing the sun, 5 p.m. There should be glare on all the windows. And this guy claims he sees to the back seat of the other car the demeanor of the guy and also hears what he's saying. Yeah, I don't buy this.
Did he say anything else?
Not at that moment until I saw what happened next.
Okay, well, tell the jury what happened next.
At that point, the light did finally turn green. So the car in front of me did move up and I did get the chance to turn at that light. And at that moment, I was still looking through the rear view. And then even on my side window, my side mirror, because at that point he was on the street. And that's when he went in front of the car and he jumped onto the car. And at that point, it was their time to, take off. And that's when the driver sped off. So as I turned on, I believe it was McCullough Street, that right, he was yelling and screaming as he was on the hood, just saying, help, somebody help me, please, somebody help me.
I'm going to renew the objection, and while I recognize the court has asked the prosecutor to lay a foundation for excited utterance, that only would resolve the hearsay component. The confrontation component is not satisfied purely by the fact that it's an excited utterance. That is not a Michigan v. Bride exception, and I would object under confrontation clause and in my hearsay objection.
All right. State, until the foundation is laid as to who the person is, their identification, their objection is going to be sustained.
Motion to instruct the jury to disregard all the testimony about what the man said on the hood of the car.
All right, ladies and gentlemen, you're just to disregards the statement that is attributed to the person who was on the hood of the vehicle.
And
Seriously? You can't unhear stuff like that.
motion for mistrial.
Denied.
And
This
that
person that was on the
mistrial
court,
motion
let's go
number
back
2.
to when, I believe you,
I'm going to have another one of another banner actually. That was second motion for mistrial. And we are maybe an hour in. Or maybe an hour and a half.
use the terminology sped off.
Yeah, correct.
That individual was on the hood at that time?
Yeah, correct.
Do you recall if the end of, I mean, well, how fast would you say, how did the vehicle take off? Did it just take off really fast? Or did it just sort of glide out of that intersection?
I would say glide and pick up speed.
Mhm. Was the individual standing on the hood or how were they on the hood?
No, at that moment he was holding on, lose his balance or fall off the side. So he was holding on to the, I guess what a windshield is that?
Mhm.
He was holding-
He was holding on, okay. And so now When you take a right on McCullough,
Mhm.
where do you go from there?
Um, I continue straight and then there's like a shopping center.
Mhm.
And then I take a quick left into the shopping parking lot.
And that's a quick left, and that would be, took a right on McCullough, and then you took a left into this parking lot here.
Yeah, correct.
And then at that point, when you're in this parking lot, where did you drive to?
Well, on the cutoff, I was taking my time. I was driving slow because I was trying to get the name of the streets and inform like the officers because I believe my niece was on the phone with the police at that time. So I was trying to get the street name because I didn't know. I'm not from that area, so.
Mhm.
As soon as I got onto the shopping lot parking lot, I just continued straight back.
Okay. And so you just sort of drove through the parking lot?
Yeah, correct.
Did you ever observe or see this vehicle, the dark or black vehicle with the individual on the hood?
Yeah, it's up there. As I was on the cutoff,
And let me bring up exhibit number 3 so you can point it out there and then I'll point here.
yeah, as I was on, when I took that right, I was still looking over my shoulder like to see because they continued straight
They continue straight on the access road?
on the access road.
Okay.
So as I was, I was driving like slow because, like I said, I was trying to get the street name.
Mhm.
I was looking over my shoulder to see like I initially thought they just went all the way straight and continued straight. But as soon as we got on the parking lot,
Mhm.
then I noticed like a little further up that I saw the black car speeding around one of the establishments. Like I think it was another building around there.
Okay. And do you see that building, on the map here?
It was like after around here Chick-fil-A,
Okay.
they said in that direction.
And this direction?
Yeah.
Okay. And again, approaching state exhibit number 3, you pointed out that the vehicle, that black vehicle was speeding off this way. Is that correct?
Yeah, that's correct.
Okay. And I'm going to show you what state exhibit number 4 has been entered into evidence. Can you identify that vehicle that's in that photo?
That's my vehicle.
That's your vehicle?
Yeah.
Okay. And so this is the vehicle, this is behind the Chick-fil-A, is that correct?
That's correct.
That's state exhibit number 4. And did you hear anything when you were in that parking lot?
Yeah, as soon as I got onto the parking lot, I heard a shot. Could have been 2 shots. Yeah, I know I heard a gunshot.
You heard gunshot or gunshots?
I was a gunshot.
Okay. And did y'all ever stop?
After I initially went around the parking lot, I think I took a little circle around. That's what we saw the victim on the parking lot of Chick-fil-A. So I did pull over, and then my family members ran to give him aid to see if he needed help.
Now, this person that you classified as a victim that's on the ground, is that the same individual that you had seen on that hood of that vehicle?
Yeah, correct.
And so is that the individual that was yelling at that intersection? Is that correct?
Yeah, correct.
And was it also that same individual that was yelling on the hood as it sped off?
Yeah, correct.
And what did that individual say?
Objection, hearsay, confrontation.
This time we got to
Draft and answer.
All right, so
That's an answer.
everyone, you can remain seated when you make your objections. That makes it easy for the court reporter to hear. And defense, what is your objection?
Well, same objection as before, Your Honor, and I don't think they've laid any additional foundation for what the court has indicated is concern.
All right, and state.
Let's stay with the argument. 1, he's been identified. 2, it is the individual that's deceased. And 3, it's a dying declaration. This is an individual that is actually subsequently dies in that parking lot. Your
All
Honor.
right, with regards to dying declaration,
Yes, Your Honor, dying declaration is also not an exception to confrontation. There's an additional finding that the court would need to make, and if that kind of an issue needs to be addressed, I would request that we have a hearing outside the presence.
all right, ladies and gentlemen, if you can step outside for a moment, please. Remember my previous instructions.
Dying declaration here, I don't think, because he didn't know he was dying. A dying declaration is if you say something when you actually know you are dying. I mean, this is weird. All right.
Whether or not,
Yes,
Your Honor, the issue is not dying declaration. The issue is whether or not there's forfeiture by wrongdoing, which would require the court to conduct an inquiry into whether or not it's the actual conduct of the defendant that has procured the result. And frankly, I think that that's an inappropriate finding to be made in a murder trial when that is just solely
the finding I
contested
make
issue.
will be the finding I make. So
I mean, I'm just saying, I don't think it would be essentially the court making an ultimate ruling as to the guilt or the innocence of the accused.
no, I don't see it that way, but this is what I will tell everyone. Everyone, just make your objections and I will make my ruling, and my ruling will be my ruling. So
my-
your answer to the state saying that it's a dying declaration, what is your response, counsel?
Dying declaration is not an exception to the confrontation clause.
All right, and then they also said it was an excited utterance.
Also, that is not an exception to the confrontation clause. I know of no judicial authority that says otherwise.
All right, state.
Your Honor, the dying declaration is exception. This does not infringe upon the defendant's right of confrontation. To be the text of the U.S. Constitution and the Gardner v. State 306 Southwest 3rd 274 and Green v. State 840 Southwest 2nd 394.
I don't know what those opinions say. I'd like and it sounds like they may be pre-Crawford as well, which is a concern.
Well, we say things sound like something. The question is it? So if you all want to look up the case law that the state has provided, you're more than welcome to look that up now.
Thank you, Your Honor. Yeah, How
All right.
long of a recess can I have?
All right, you all can do it right now. Does everybody have Wi-Fi and connection to the
I don't
computer?
have my computer set up. My co-counsel does. Like, get those sites again.
All right, so Cindy, do you need a break? All right, they're gonna look up some case law. You can step down, but remember, these are the instructions. You're not allowed to discuss your testimony with anyone or to view any.
Okay, let's skip ahead.
They've met the foundation, turn some of the things that the prosecution has thrown out here.
Yes,
The first thing is, I don't think that they've met the foundation for a dying declaration, which is 804A, I'm sorry, B2, statement under the belief of imminent death. The statement that the declarant, while believing the declarant's death to be imminent, made about the cause of the circumstances. The statement that's been offered by the witness is is not about the cause of his death. He has not been mortally wounded. He has jumped on the hood of the car himself voluntarily. And what's being testified to is that he was calling for help and then apparently also asking for assistance in recovering his property.
okay.
So I don't think that it meets that exception. Also, if for whatever reason he's trying to suggest dying declaration as a backdoor to the idea of forfeiture by wrongdoing, I call the court's attention to Giles versus California, 554 United States 553 from 2008, where the court said it's not sufficient that the declarant is being killed by the defendant. It must be demonstrated that the defendant killed the declarant to secure his unavailability at trial. In other words, to prevent his testimony. With that specific intent. So I don't think that it meets a forfeiture by wrongdoing exception either. I think based on those issues, there is no way to end around the confrontation clause exception to this. Not to mention the fact that under Rule 403, Your Honor, for a balancing test purpose, the prejudicial effect of this is extreme because it goes directly to the striking core issue of the case, which is the robbery. And there are several reasons to doubt its reliability. Talking about an event that's occurring where distances are changing as the cars are moving, one car is driving away. This is something that other individuals who are in the same vehicle as this particular witness have not testified to in their testimony, which is suspicious in its own right. And it has to be weighed against its tendency to confuse and mislead the jury under all those circumstances. So for 403 and the hearsay rules, 803 and 804, we would submit it. It shouldn't be admitted evidentiary wise. But first and foremost, there's the Crawford confrontation concern because we don't believe they've met those exceptions.
All right, thank you. The court is doing a balancing test. The court is going to find that it's more probative than prejudicial. Defense's objection is overruled. Let's bring the witness back in. If you could line the jurors up, please.
Okay. That I didn't expect. That I did not expect. But balancing test on what? What's the balancing here? Because if Crawford says these must be met, then what's the balancing? Yeah, more probative than prejudicial is not the right test. This is weird. Was he dying or not? No, he was not shot at that time. He placed himself on the hood of the car. That is not a dying declaration. or an excited. George Boyd, I really liked you. Don't ruin it for me. What caused his death? He was shot shortly
Lost
thereafter.
the train of thought there. Mr. Reyes, I believe I was asking you what this person you indicated as the victim that was on the ground back at the intersection. When he was first had gotten out of that vehicle, when he was outside the vehicle, what was he saying at that point, or yelling at that point?
He was saying, give me my things. Just give me my things, just give me my things.
And
They wanted his property back, whatever it was.
and was he saying it? Where was he directing that to?
The people in the vehicle.
And then, as you testified earlier, he jumped on the hood of that vehicle,
Yes, sir.
and then as it sped away, and he was holding on. What was he saying then?
That's when I guess. That's when he was saying, just screaming, help me, somebody help me, please, somebody help.
You guess? You guess?
Thank you, sir. We'll pass the witness.
All right, defense.
Thank you, Your Honor. Good afternoon, sir. So you observed this first because of what someone else told you. It didn't key in on your eyesight originally, right?
We were notified.
Without going into what you were told, did somebody else call your attention to it, or did you see it first?
No, we were notified to watch out or be careful.
Objection, Your Honor, non-responsive hearsay.
Sustained.
confrontation. If court could just instruct him to answer my question, did someone else point it out to him, or did he see it first?
All right.
They pointed it out to me.
Okay, and then you saw it in the rearview mirror.
Yeah, that's fine.
Was it your side rearview mirror, or was it your rearview mirror in the passenger compartment of your car?
The top rear mirror.
Okay, and so looking back there, you also saw the people that were in the backseat of your car, right?
Yeah, of course.
Okay, and so you said that you saw someone in the front seat, and then you made a motion like this. Do you recall doing that with Mr. Garahan a moment ago?
Yeah, sir.
They were holding a gun, you saw a gun, and they made a motion like that.
Yeah, that's when I saw the pistol.
Okay,
He was they were waving it around like.
so help me, just for the sake of the record, this and that don't really come across very well for the court reporter. So just tell me if you disagree with this description of what you did. You're holding your hand like you were holding a gun in your right hand, and you made a motion where you sort of brought that arm up, and your hand sort of landed on your shoulder as though you were going to toss the gun behind your back. That's kind of what it looked like as you were doing it. Do you agree with that's what you were
no.
trying to do?
No.
Okay.
The person in the passenger side, like reached over with the gun. He turned his body. He fully turned his body, and he was like waving the pistol to the back.
Was he wearing a seatbelt?
I assume no, because he was.
You assume no? Is that what you said? If you, I don't want you to answer a question if you don't know the answer. Yes or no? Do you know whether he was wearing a seatbelt?
No, he wasn't.
He wasn't wearing a seatbelt. Okay. Now, this was what, 7.5 years ago?
Correct.
And out of curiosity, have you spoken with the prosecutors at any point in getting ready for this trial since this incident happened?
Initially, when they called me in,
When was that?
saying, to be here, I went over.
When did they call you?
I believe I'm not sure the exact date, but it was about 3 weeks ago, I believe.
Okay. Did you come physically into the courthouse or to the DA's office and meet with them?
Yeah.
And did they show you anything?
They showed photos and the video.
Okay.
Yeah.
So you listened to your audio recorded statement?
From the police,
I mean, did you read or listen to anything that were your words?
yeah, correct, from the police officer.
Okay. Did you read or listen to anything that wasn't your words?
No.
Okay.
But you just say
Um,
you
now-
saw a video.
I want to get back to this issue with the motion that he made and the motion that you were gesturing to the jury. Okay. You say his seatbelt was on. So in terms of the torso of his body, was his belly
Judge, I'm
button?
just going to object that mischaracterization of the testimony given.
All right, if you can ask your question.
Did you testify that the seatbelt was on a moment ago?
I would say it was off.
Okay. The seatbelt was off.
Off, yeah, correct.
Okay. Was his belly button facing towards your car, or was it facing the other direction, towards the back seat?
To the side,
So the belly button would have been facing the driver?
I would assume, because he was,
Okay, I don't want you to assume. You
Yeah,
saw it, we
sure,
didn't.
yeah.
So help me understand. You know, when I say the belly button, I want to understand where is this man's torso that you're observing? If Mr. Goldstein here is the driver of a car and I'm the passenger in the front passenger seat of that car and I'm looking at your car and you're saying that the person you saw in this seat is having a fight with someone in the back seat, right?
Yeah, no, his torso, his belly button, as you're saying, was faced to the driver.
Okay, so he's faced like this and his neck is craned this way so that,
Not all the way completely like that.
okay. Is he attacking the man in the seat behind the driver? Is he attacking the man in the middle seat? Is he attacking the man behind his seat?
The middle seat,
He's attacking the man in the middle seat.
correct,
Okay. With his right hand or his left?
is right.
Okay. So he's got a gun in that hand, right?
Correct,
Okay. So he's attacking with the same hand as the gun.
correct,
And he's using the gun as a bludgeon, right? Like a club.
correct,
He's not trying to shoot somebody with it that you can tell he's using it to hit somebody with.
correct.
Okay. And so you're saying that this is how you saw it. Striking across his body.
You could say, yeah.
Okay. What color was the gun?
That is a hell of a reach. If he is turning around with the gun in his right hand and managed to get all the way to the back seat to the middle guy and start hitting him. Really? Really?
I don't know my gun type, I don't own a firearm.
I just want to know what color it was.
It was black.
It's a black gun.
Yeah.
What color? I'm sorry. What kind of hair was he?
Oh, now we have witnesses describing two different color gun.
Displaying? What was it? Long? Was it short?
What did that mean? I'm sorry.
Well, okay, like my hair's kind of longer than yours, right?
I couldn't give you a full description of the person, like I said before. Like, I didn't know if they had piercings, tattoos, long hair, short hair.
The gun was
I just know-
something.
Yeah, I just know he was black, male, and the passenger.
Okay. Fair to say the gun probably plays a bigger role in your memory than what his face looked like.
I was fixed on everything going on. I was fixed on everything that was going on. So I was not just fixed on him. I was
The whole situation.
exactly.
Okay. You don't remember if there were 2 or 3 people in the back seat, correct?
On those two, there could have been 3.
Okay. You don't know if there were any other guns in the car or not. You didn't see any.
No.
But you're not saying that there couldn't have been, right?
Correct.
Did you see anyone struggling over any belongings, a bag, a backpack, anything like that?
Yes, the individual in the backseat.
Okay. You never told the police that though, did you?
I'm not sure.
Okay.
I'm not sure it's been so like long ago. Like,
Well, you said 3 weeks ago you reviewed your video, right?
yeah,
That
correct.
wasn't so long ago, was it?
But as I go along, like the memory comes back.
Oh, okay. We're not talking about that question. What I'm asking you is, when you spoke to the police officers in 2017, your memory was fresher then than it is now, right?
Yeah, of course.
Did you tell the police at that time that you saw a struggle over a bag?
I didn't say a bag. I said it was struggle in the backseat. I didn't say a bag.
Okay, that's what I'm asking is like, did you see contents of a bag?
Oh,
Okay. And fair to say, because of the way his body is turned, you're not looking at his face head on the way that you and I are looking at each other, right?
correct.
You're looking at him in profile.
Yeah, correct.
Okay. Did you talk to the prosecutors about a bag?
No,
Now, to be clear, you did not see him get shot, correct?
yeah, that's correct. I did.
You all were way past the Chick-fil-A in the parking lot of the other businesses in that strip mall when you heard the gunshot.
Yeah, I was making my way into the parking lot when we heard the shot.
And you and the other people in your car talked about what each of you saw before you spoke with police, right?
No, I mean, I gave my personal, what I saw and heard. That's what I gave.
Did you speak with Mr. Caballero about what you saw before the police arrived?
We talked about what had occurred that day, but
That's what I'm asking. Did you and the other people in your car that day
Oh, yeah.
talk about what you saw before
Yeah,
you
sure.
spoke to police?
Yeah.
Okay. So some of what you have testified to today your memory may be impacted by what other people say they saw. Would that be fair?
not quite. I mean, I'm telling you what I've seen and I heard that day.
Well, have you ever played the game of telephone? Do you know what that game's like or how you play it?
No.
Have you ever played a game where somebody whispers something in somebody's ear and then they whisper it in somebody else's ear and it passes around and then you finally get to hear what it comes back through after it goes through 4 or 5 people?
Judge, I'm just gonna argue relevance.
Sustained.
All right, I'll rephrase it. Everybody in that car had a slightly different angle on what they saw, right? Because they're sitting in different places.
Yeah, sure.
Okay. And so you don't know exactly what, for instance, Ashley saw or what Mr. Caballero saw that maybe you did see or maybe didn't see, right?
Yeah.
And you don't know what they heard or didn't hear
Yeah.
comparatively, right?
Sure.
What you do know is that all of you talked about what each of you saw and heard after the fact, right?
Correct.
And there were 3 adults and 1 child in the back seat of the car.
Correct.
Okay. Did you get a sense of we're talking about the people in the back seat of the car? You said that the woman who was driving the car was white. You said the man in the front passenger seat was black. What about the racial makeup of the people in the back seat of the car? Did you get to see any of that?
Yeah, the only person I did see or could see in the back seat was the one sitting right directly in the middle, which was the victim, the Spanish individual. He was the one sitting in the middle.
Imagine yourself in a car. Up here you have your rear view mirror. So does the car behind you. So your rear view mirror, other car. I'm not sure, or I don't think they saw what they think they saw. They saw after the fact a Hispanic man who they tried to save the life of. And they know who's the suspect or who is charged. I'm not entirely sure they are. This is confirmation bias, and when stuff like this happen, and you talk to each other, you create memories, and that is really, really bad. Now they have described 2 different color guns. The others, I mean, yeah. Did they see something? Yes. Did they see what they claim? Did they see what they claim now in court? I don't think so.
Middle.
As a witness.
State.
No question. No.
All right, is this witness excused or subject for recall?
Excuse by the state, Your Honor.
Excused by the defense.
The rule has been invoked. You're not allowed to discuss your testimony with anyone or watch anything while the trial is proceeding. Do you understand?
Yeah.
All right, thank you. You may step down. Be sure to leave the microphone behind.
Thank you.
State, call your next witness.
They are moving ahead really, really, really fast here. That's good. All right.
You see
Who
that little
is-
mic this thing right here?
Yeah.
Can you grab that and just put it on the lapel of your shirt? That's for the court reporter to be able to hear you. And then this is a microphone for all the courtroom. If you just speak into that, please, okay?
Yes. Could you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Just make sure you keep your voice up so everyone can hear. And if you could state your name for the record and spell your last name, please.
My name is Hester E. Rogers. My last name is spelled Rogers.
All right, state, you may proceed.
Ms. Rogers, how old are you currently?
I will be 58 this July.
And
58? Oh, she looks older. Auto doctor. So is there any witnesses from inside the car that saw what actually happened in and around? Yeah, everybody started out blaming each other, and then eventually they all started to point their finger at JK. And they walk if they testify. All the others will walk. So will we hear the truth from these people from inside the car where everything happened? Or will you hear something that will save their asses?
where were you born?
I was born in Elizabethtown, Kentucky.
Okay. And do you currently live in San Antonio, Texas?
No, ma'am, I currently reside in Crescent Valley, Nevada.
Okay. And did you used to live in San Antonio, Texas?
Yes, ma'am.
Okay. About how long did you live in San Antonio, Texas?
It varies. Throughout my whole life, I have moved down here. It's been 5 years or more each time that I lived in San Antonio, though.
Okay. Now I want to talk to you about April 23rd, 2017. So we've spoken about the case via Zoom, correct?
Yes, ma'am.
Okay. And so when I spoke with you, you had a chance to review a statement that you gave to law enforcement. Is that correct?
Yes, ma'am.
Okay. And regarding that statement, that was, I guess, you were taken down to the police station on that day, April 23rd of 2017.
Yes, ma'am.
Okay. And you met with a detective on that day, correct?
Yes, ma'am.
Okay. And so that detective typed out your statement for you. Is that correct?
Yes, ma'am.
After you relayed the information to him.
Yes, ma'am.
Okay. And then after that was completed, did you have a chance to review the statement?
Yes, ma'am.
Okay. And you signed it, correct?
Yes, ma'am.
Okay. Your Honor, may I approve the witness?
Yes.
And, there's been some mention, this happened back in 2017. So would this statement help refresh your memory at any given point if you needed to refer to it?
Yes, ma'am.
Okay. What's been marked as State's Exhibit number 6 for identification purposes to defend?
I don't like this because they are supposed to testify from memory, and the law. This, let me explain here. If the prosecution takes 8 years to get to trial, they shouldn't be rewarded by being allowed to have their witnesses have their recollection refreshed in this way. That is my opinion, because they have had every opportunity to bring all of this years ago, and they chose not to. But now all of a sudden, yeah.
Your Honor, our objection would just be that there's been no foundation that she lacks that memory.
It's all right. That's going to be overruled.
All right. Now I want to talk to you about the day, April 23rd, 2017. Do you remember what you were doing that day?
Yes, ma'am. I had actually been homeless at that time, and I was out flying a sign at McCullough and 410 Access to get money to try to.
So, homeless lady. Okay, you judge the credibility of what she actually saw.
Have a place to stay that night. I just was standing at a bus stop waiting when I seen this whole thing go down.
And was that bus stop located at McCullough and 410 Access Road?
Yes, ma'am.
Okay. And at some point while you were standing there at the bus stop, did a car get your attention?
Your Honor, I'm going to object to leading.
Overruled.
You can answer the question.
Yes, ma'am. A car did get my attention. Actually, 2 cars that day got my attention.
Okay, so the first
Another car had the gas cap open, and I just told them so they could shut it. But the second car was what really got my attention.
Okay, so that first car, you said the gas cap was open, is that correct?
Mhm.
Okay, and so you notified them of that?
Yes, ma'am.
Okay, and then after that, can you tell me more about the second car and why that car caught your attention?
Well, I happened to notice a fight in the car. The front passenger was turned around and was fighting somebody in the back seat, and I didn't know who it was. And then the passenger in the back seat jumped out and screamed help and was yanked back in the car. That really got my attention. It's like, wait a minute, somebody needs help here.
Okay, and regarding that vehicle that the fight was going on in, do you recall what color the vehicle was?
I believe it was black at the time.
Okay, and so do you know what the driver of that vehicle looks like?
She was a Hispanic female, and her hair was dyed blonde. At the time, I believe I saw her wear a white t-shirt.
Okay, and regarding that front passenger of that black motor vehicle, do you recall what he looked like at all?
I knew he was about a medium skinned black guy that had about a 2-inch afro, and there was like a little blonde streak in his afro. He was brandishing a firearm at the time.
Brandishing a firearm? That she's using for a person being homeless and everything, that's a lot of technical jargon here.
Okay, and so you observed this front passenger with a firearm in his hands.
Yes, ma'am.
Okay, and so when you say that he was brandishing the firearm, can you kind of explain that to me? How was he doing that?
When he was turned around fighting whoever in the back seat, I could see him holding the gun up like this. And that's how I noticed he had a gun in his hand. I seen it through the windshield.
Okay, and in your demonstration, you're using your right hand. Is that the hand that the person was using to
Yes,
hold the
ma'am.
firearm?
Yes, ma'am.
Okay, and so when you say that their front passenger was fighting with someone in the back seat, can you kind of describe the motions that you were observing in that motor vehicle?
It was, they were swinging their arm,
Okay,
you know, and then they were holding the gun up.
and then you said that you heard the person in the back seat yell help. Is that correct?
Yes, ma'am.
Objection leading, Your Honor, that
How could they hear a person inside the car in the back? Yeah, this all sounds so coached.
I believe that was.
With regards to leading, that'll be sustained.
Move to instruct the jury to disregard the question and the answer.
All right, ladies and gentlemen, you'll disregard the question and answer for that
Motion.
last question and answer.
Motion for mistrial, Your Honor.
Denied.
Okay,
And motion for mistrial. 3 on the first day. Were the windows open? We don't know. How close was homeless lady? I don't know.
and so when you were standing at the bus stop and you're observing this, what you've described as fight going on, did you hear anything from the person in the bus?
When he jumped out the car the first time, he said, help.
Objection, hearsay, confrontation.
All right, that's overruled.
Okay, so he said help.
Yes.
And after that, what did the person that exited the vehicle? Do you remember what he looked like at all? The person that exited the back seat?
Just a Hispanic man.
The guy is in the back seat, in the middle back seat. That's the claim from everybody. How did he get out of the car? From middle back seat. He's surrounded, if everything they are saying is correct. How did he get out?
Not quite sure on details of features, but
That's
I
fine.
do remember him being a young Hispanic male.
Okay, and so when that person exits the motor vehicle, what does he do after he's yelling for help?
The second time he jumped out, it looked like he was trying to run away, and it looked like he had come from that back to go around the front of the car. At the time, the light turned green, and the girl hit the gas pedal, and he wound up on the hood of the car.
Okay, do you remember how he was positioned on the hood of the car? You can't recall, that's fine.
I'm not quite sure. I don't want to state something that may be wrong.
Yeah, thank you very much. And so when that individual, that Hispanic male, was yelling for help, did anyone help him?
No, because nobody really saw but me.
Oh, okay. And once he ended up on the hood of the car, were you able to
Just one
see-
moment. Jurors, do y'all need a break? Anyone? All right, can I have attorney's approach?
light turns green and that Hispanic male is on the hood of the car?
Yes, ma'am. It pulled into a parking lot that Chick-fil-A was in.
Okay. And so once you see that black motor vehicle turn off into the Chick-fil-A parking lot, did you hear anything at that point?
Yes, ma'am. That's when I heard 2 gunshots.
Okay. And just to be clear, you know, from where you were standing at that bus stop at the intersection, you were not able to observe the shooting. Is that correct?
No, ma'am. There's a wall that was there.
Okay. And that day, did you make contact with police on that day?
Yes, ma'am.
Okay, and so that's what we talked about earlier, right? That you made contact with police on that day. You were given a ride downtown, and you told them what you observed on that day, correct?
Yes, ma'am.
Do you recall the age of the driver and the passenger?
All of them looked kind of young, at least between 18 and 21. They were really young.
All right, we pass the witness.
All right, defense?
Thank you, Your Honor. Good afternoon, Ms. Rogers. How are you?
Okay, and how are you?
I'm well, thank you. I just have a few questions for you. You had just found a moment ago that nobody really saw what was going on but you. You recall explaining that to the prosecutor?
Yes, the reason why I thought that was because I was right there in front of the vehicle. I was like maybe 20, 25 feet from the vehicle, and everybody else that witnessed it, besides the cars around them, were over in a hotel parking lot at least. I
What?
can't even guesstimate further than 100 feet from the vehicle.
Fair to say you didn't see anybody from any other vehicle come to their aid.
No,
You mentioned that you saw another vehicle that day that had a gas cap that was open.
yes, sir.
Did you notice the demeanor or the behavior of the people in that vehicle with the gas cap?
No,
Okay.
I didn't pay attention. I just let them know that
Okay. You said that there were two Hispanic males in the back seat?
I believe so.
Okay. And just to be clear, you described the individual that you saw in the front seat as having an afro about 2 inches in length, right?
Yes,
And there was a white or blonde streak on the left side of the man's head?
yes.
Okay.
Yeah, that's not what any of the people in the car in front of the car in question. Yeah, there's something strange here.
I just want to, for vantage point's sake, are you, you're on the curb of the curb that would be next to the access road, right?
Yes, sir. I was actually at the bus stop right there.
Okay.
Because once you pass the light, you go up the access road. So I was right there at the bus stop.
Okay. And so from that point, you said you were flying your sign. Is that on the passenger side of this vehicle or the driver's side of this vehicle?
Passenger side.
Okay. So let's just say that I'm sitting at that bus stop and I'm observing this. Is the passenger's side car door, the front passenger side car door directly in front of your field of view, or is it slightly off to this side or this side?
I would say it was slightly off to this side.
To the left.
Yes.
Okay. So,
I was standing there able to face it, but it was one car back from where I was at.
one car back from where you were
Yes.
at. So would you say that what you were observing, you were looking at through the front windshield of that car or the side
The
windshield?
front windshield.
Okay. And again, you said a blonde or white streak in the man's hair.
Yes, sir.
Okay. You also indicated that the man was holding a gun and you made a gesture, but I just want to get a sense, where was the gun barrel pointed when you saw the man holding the gun?
Straight up.
Straight up.
Yes.
Did you ever see it pointed at anyone in the car?
Not in the car. Outside the car, he pointed it at that, but not in the car.
Okay. And when you indicated that there was, fighting and swinging of arms, you made a gesture that looked to me like maybe you were indicating that a different arm was used for the punch or the swinging
Yes.
with the gun. Is that right?
Yes, sir.
Okay. So you don't think the gun was being held in the hand that was doing the swinging?
No.
Okay. You indicated that the gun was gunmetal gray?
That I remember.
Okay.
Yes.
And you believed it was
And now we have a third color of the gun. We have heard silver, we have heard black, and now it is gray.
a 9mm?
Yes.
Okay. Do you have any experience with firearms?
Not really, my brother owned a 45. My cousin owned a 40. I mean, not really, just what I've seen they have.
Okay. And based on that, just sort of anecdotal experience, it didn't look like a 45 or a 40 to you. It looked like
No.
a 9.
Yes,
So you know enough to know what a 9mm is.
yes.
And during opening statements, we learned that the person owning a 9mm gun was not Tay-K.
I noticed that you're wearing glasses today.
Yes, sir.
Were you wearing glasses on that day as well? Or did you?
I believe I was. I've been wearing glasses for a long time, since my 40s.
Pass the witness. Thank you, ma'am.
No further questions, Your Honor, and please by state.
Accused?
Yes, Your Honor.
All right, the rule has been invoked. You're not allowed to discuss your testimony with anyone. until these proceedings have ended. Do you understand?
Yes, ma'am.
All right, and if you'll remove the microphone and you may step down.
Okay, thank you.
Thank you.
And I'm sorry, I forgot one of the-
State, call your next witness.
State calls Lasagna Robinson.
Yeah, that was a great opportunity for holding up fingers.
Correct.
Yeah, that's true. Gray and silver could mean basically the same thing, but then we still have two different color guns. All right, next witness.
This is the mic. Speaking.
I like this trial, the format of the trial. I don't agree with a couple of Judge Boyd's
Could you
decisions.
raise your right hand for me? Do you
But
solemnly swear or affirm
reading
the testimony you
through
give will be the truth and
testimony,
nothing but the truth so help you God?
great.
All right, you can lower your hand. Make sure you keep your voice up so that members of the jury can hear. If you'll state your name for the record and spell your last name, please.
Lasagna Robinson. All
right, state, you may proceed.
Ms. Robinson, will you let the jury know how you're presently employed?
As a paralegal / custodian of records for SAPD Communications.
Okay, when you say SAPD, is that San Antonio Police Department?
Yes.
Okay, and as a custodian of records with the San Antonio Police Department, can you explain to the jury your duties in that role?
Yes, that's to maintain and maintenance the records, to pull upon request and to retrieve and send as requested.
And is that 911 calls?
911 calls. Yes.
Okay, and so you maintain the 911 calls for SAPD, is that correct?
Yes.
Okay, and can you just briefly explain to the jury how these 911 calls are kept?
They are stored on a digital database, and they're kept on that database until it's time for us to, until we get a request to retrieve them or send them out, and then they're uploaded into another database.
Okay, and are these calls maintained in the normal course of business?
Yes.
All right. And when somebody calls, is there any documentation that's generated when that call is created?
Yes, it's called an incident detail report.
Okay. And the devices that you were saying, are those digital devices where they're stored?
Yes.
Okay. I want to turn your attention now to April 23rd of 2017. Do you know if SAPD received any emergency calls that they associated with SAPD incident number SAPD 2017-04-24102?
Yes.
Okay. And do you know the total amount, or did SAPD receive 3 calls?
Yes.
Okay. Your Honor, may I approach the witness?
Yes.
Yeah, so she's just there to
So I'm going to
get
show you
evidence
what has been marked as State's
as a
Exhibit
custodian of
number
records.
7, 8,
Hey,
and
and they're done
9.
that.
Do you know what is
Good to see
contained
you.
on State's Exhibits 7, 8, and 9?
The 3 audio, 911 audio calls that came in.
All right. And have you reviewed these discs?
I have.
Okay, so you've reviewed States 7, States 8, and States 9?
Yes.
Okay, and looking at States Exhibit 7 through 9 inclusive, do they all contain an identifying mark on there?
Yes.
And is that how you're able to realize that you've listened to States 7 through 9 inclusive?
Yes.
Okay. And just starting, well, have you listened to States Exhibit 7 through 9 inclusive?
Yes, I have.
All right. And specifically regarding States Exhibit number 7, can you identify who the call taker is on that call?
Yes. His name is Xavier.
Okay. And do you know who made that call?
Her name was Anna.
Okay. And she was she was a refused caller, is that correct?
Yes, I'm sorry. Yes.
Okay. On State 7, who is the
Okay.
caller?
So I have the 3 calls written down. I don't know what order you have yours in.
Okay. If you want
Is
to,
this the first?
if you just want to take a look, so State's Exhibit number 7 is,
Okay.
we've listened to it, correct?
Yes.
All right. And so who was the caller on that?
She refused to give her name.
Okay. Thank you. And regarding State's Exhibit number 8, who was the caller on that one?
Elizabeth.
Okay. And regarding State's Exhibit number 9, who was the caller on that one?
Anna.
Okay. And State's number 9 on the call where Anna is the person that called in, who was the call taker on that one?
Xavier.
Okay. And regarding State's Exhibit number 8, where Elizabeth is the one that called in, who was the call taker on that?
Howard.
Okay. And were these phone calls all made on April 23rd of 2017?
Yes.
And are they uniquely identified by that
incident number, SAPD 2017-0424-102.
Yes.
Okay, and since you've reviewed states 7 through 9 inclusive, are they a true and accurate copy of the 911 calls as SAPD received them?
Yes.
Okay, and were they made on a device that's capable of capturing an accurate recording?
Yes.
Okay, and was the operator competent to operate that device?
Yes.
Okay, and so it's an accurate representation of the statements made on that day?
Yes.
And has states 7 through 9 inclusive been altered in any manner?
No.
All right. Your Honor, I'm tendering states 7 through 9 inclusive to defense and state officers.
Your Honor, I mean, the foundation for their chain of custody can be established through this witness, but as to some of those questions, I guess, can I briefly go down with?
Yes.
Good afternoon, ma'am. How are you? I'm well, thank you. You were not the person who took any of these calls, correct?
That's correct.
And so you were not listening in on these calls when they were made?
No.
And so as to the questions that were put to you about whether or not these calls have been modified or altered in any way, you never heard the call as it was being laid down to record, right?
Well, yes, because as the call comes in, it is recorded in real time.
I'm asking, did you personally hear the recording?
Did I hear the record? Yes, I heard the recording.
I mean, I know, when the person got on the phone and called 911, you were not listening in on that phone call as it was being said, correct?
No.
Okay. You have heard a recording since.
Yes.
Okay. So you do not have personal knowledge as to whether this truly and accurately depicts the phone calls that are made on, correct?
Well, the call is recorded in real time.
Yes, ma'am. I understand that. But as to whether or not it accurately depicts how the call was made, you're not the person to ask because you weren't on the call, correct?
No, I wasn't on the call.
That would be my objection, Your Honor.
All right.
That and hearsay and confrontation.
All right, any response?
Judge, it's not, well, the confrontation clause doesn't apply because the statements are non-testimonial. They were not made in advance of the criminal prosecution. And as far as hearsay, I mean, there's an exception, so.
This depends on if the prosecution is going to call the person making the call to what's said, or to the person actually receiving the call. But it feels like a bit petty.
Presence and confession.
Well, Your Honor, I am not going to accept that at face value. And this is not a Michigan v. Bryant example. And there's been no foundation laid of that. And this would not be the witness to lay that.
Objection.
All right, so State's Exhibit number 7, 8, and 9 are admitted over objection.
Maybe publish.
Yes.
For me, it depends. Are they not calling the person? Then I have a problem. Oh, they're actually playing the 911 call. Yeah, then I don't think this is the correct witness. She's supposed to be there only to get evidence in, not to listen it and authenticate the content of it. Yeah, why aren't they calling the caller or the taker? This is, again, this is really strange.
I just witnessed a gun shooting.
Oh, what, ma'am? Hello?
Hello?
Hello, ma'am, where are you?
It's Jones Maltzberger and 410 by the Chick-fil-A and Joanne South.
On 14 or Jones
On the
Maltzberger?
hood of,
And I'm having a hard time hearing you.
Jones Maltzberger and 410.
Okay. What's going on?
The guy on the hood of a car that was driving, and they pulled into the Chick-fil-A parking lot, and the passenger shot his gun at the guy on the hood.
Okay, so was the Chick-fil-A, was that on, was on Jones Maltzberger? Was that inside or outside the loop, ma'am?
Was it inside or outside the loop? Outside?
Like,
It's like across, it's across from North Star Mall. It is. It's outside, just outside the loop.
Okay, because outside on Jones Maltzberger, right there, I'm showing hotels, and then the Hampton Inn, and the Four Points Inn, the Drury Inn.
Right. So in that center, there's a Joanne Fabric, there's a Perfect Sim strip club, there's a Chick-fil-A. There's some strip club.
Okay, so on Jones Maltzberger near Chick-fil-A?
Yes.
Okay, and what kind of vehicle was it, ma'am?
What kind of vehicle was it? Like a black car.
So there's one caller who is asking around. And I mean, that's not unusual, but it should be that caller who should be on the stand, not the custodian.
And who did you shoot at, man?
I'm sorry?
And who did you shoot at?
The guy that was on the hood.
So the guy on the hood didn't have the gun, it was somebody else?
It was the passenger in the car that had the gun and was shooting at the guy on the hood of the car.
Okay. And where did are they still in that parking lot?
No, we kept driving because we were on 410.
Uh-huh.
And so we kept driving. I'm not going to pull into a parking lot where someone has a gun.
Right, no, ma'am, I understand. Could you tell what the guy on the hood looks like, what he was wearing?
It looked like a Hispanic guy with glasses on the hood, right? With like jeans and a white shirt. Yeah. And then there was an African American guy in the passenger seat that opened the door and shot at him.
Okay, did he hit him, do you know?
Did he hit him? It looked like it. He was like right in front of him. I can't imagine he was in.
How long ago did you see this, man?
Just right when I called you.
Okay. Okay, ma'am, and do you know if they pulled off, or did they park and get out, or do you know like what happened?
We kept driving. They were parked in the parking lot when the passenger got out and shot at the guy on the hood.
Okay.
And then I don't know what happened after that. Because like I
You were
said,
gone after that?
we were getting on 410.
Uh-huh.
So we kept going down 410 and I don't know what happened.
Okay.
I'm just trying to tell you that someone needs help because they're shot in the parking lot.
No, ma'am, I've already sent this over to the officers on the way. I'm just trying to figure out, what they all look like or where they went, or just so they can find them when they get out there,
I have no idea, but I can tell you that the windshield of the car is shattered because the guy, it looked like hit the windshield also. So,
So he shot
someone with
so he like shot through the window?
yeah, it looks like he hit the window when he shot him.
Okay, and it was a black sedan, right?
Yes.
Okay. Did you want to leave your name? Hello, ma'am.
Hello?
Do you want to leave your name?
No, I mean,
Oh, you don't have to?
okay, no, I'm just trying to tell you that someone needs help because they were just shot.
Okay, so did you see them get hit though?
I mean, the guy was right in front of his face. I don't know how he would have missed. I mean, I wasn't in the parking lot. I was getting on the highway. I don't know what else I can tell you.
Okay, now we understand why they couldn't get a hold. But you had 8 years, and you do have. There's ways to get a hold of this person. So again, just because the prosecution took 8 years to get this from crime to trial, that should not allow the prosecution to take shortcuts, right?
And you know what the gun looked like?
Oh my God, no, they're in a parking lot. I'm getting on the highway. I have no idea what the gun looked like. It was a small handgun. It's not like an AK-47 or something.
Okay. All right, man. Well, we're getting them out there, okay?
All right, thank you.
All right, defense.
No further questions.
All right, is this witness excused?
Yes, Your Honor.
All right, the rule has been invoked. You're not allowed to discuss your testimony with anyone during the proceeding of this trial. Do you understand?
Yes.
All right, thank you. Make sure you leave the microphone behind.
Thank you.
Okay.
Just to make sure I'm correct, all 3 calls were admitted, right?
Yes.
Okay.
All right, and State, are you resting for today? All right, ladies and gentlemen, we are going to come back tomorrow at 1:30. And I will tell you, we will start exactly at 1:30. I only have 2 matters in the morning tomorrow that are unrelated to this case, but I must take up those matters, all right? So the same rules apply. You're not allowed to view anything. If somebody asks you if you're on a jury, you can say, yes, I have jury duty. I'm up to send from park.
Let's see if is anything leading out of this, and apparently not. Yeah, so that was the entirety of day 1. Let's move on to day 2, I hope. Let's see here if I can find it.
Up to, but
Is this the same guys? Yeah, that's the same guys. Okay, let's.
Let's. The 20th, because
before
I'm just
Still searching for when they start.
All right, Taymor calling 2019.
Okay, now here we go. Here we go. All right, day 2. Let's continue.
CR 12495 State versus Taymor McIntyre. Can I have parties announced for the record? State
Megan Galloway and Jason Garahan for the state.
defense.
John Hunter, Jerry Goldstein, and Thomas Lane for Mr. McIntyre, Your Honor.
And are you Mr. McIntyre?
Yes, Your Honor.
All right, are parties ready to proceed on motions that have been filed by the defense?
The state's ready, Your Honor.
Yes, Your Honor.
Okay, so day 2, they start out with motions. All right.
All right, so the first motion that I have a motion to suppress and or exclude digital cell phone evidence. And then I also have a motion to suppress, and I believe that motion to suppress is related to the affidavit for search warrant. Is that correct?
Correct, Your Honor. On that same cell phone.
All right, thank you. And counsel, do you wish to proceed first on the motion to suppress as it relates to the affidavit?
As to the Heath matter, yes, Your Honor. I think that would be the best way to proceed.
All right, you may proceed.
Thank you, Your Honor. As the court will recall, in late January, the defense filed a sworn motion for continuance on the basis that there was some issues with one of our experts that we needed additional time to resolve. We supplemented that motion for continuance with additional information because on the day that I approached the court on that, the state tendered to me an additional external hard drive with data related to Mr. McIntyre's cell phone. The phone in question was taken from a black Kia that was found in a parking lot of a Mexican food restaurant over off of San Pedro, near the shooting, about a mile away, several days after the shooting. And it was searched, and ultimately, I believe it was determined that that was Mr. McIntyre's cell phone.
And I'm sorry, just one moment. So the small microphone,
Yes.
if you could put it on your lapel, it's for the court reporter to hear.
Yes, Your Honor. Thank you. The phone was originally a dump of the phone, and by a dump, let me be very technical, or at least as technical as I can be, not myself being an expert in digital forensics, was what's called a technical extraction, and it was the lowest level technical extraction. And some of the data on that extraction was not intelligible, and the PDF copy that was tendered is not interactive, meaning that we are not able to open applications and look at the metadata. You're not able to look at the content of messages that were sent through third-party
Right.
applications.
So counsel, this is my question. Are we starting with the search warrant first
No,
on
Your
whether, so you don't want to start with the search warrant first
I'm
on
just-
whether or not it's the judge who found that the search, that there was probable cause? You don't want to start with that first. You want to start with discovery first?
Well, I'm happy to proceed with whichever Your Honor wishes to proceed with first. I just thought it was simpler to discuss the discovery matter because the court, some of our discussions previous at the bench indicated that the court also had a concern about the production timeline. And so that's how I was going to proceed. But if Your Honor wishes to get into the motion to suppress first, I'm fine to do that.
I think it will be easier to start with the affidavit for search warrant, because if the court finds in your favor, then there's no need to discuss the other portions. So I think it may be best to start with that first, the taking of the cell phone, the extraction of information from the cell phone. And then if the court does not rule in your favor on that, then we can go into discovery.
That works for me.
All right, so we'll start with your motion to suppress as it relates to the affidavit for the search warrant.
Yes, Your Honor. And I believe for the record, the state tendered to Your Honor a copy of the affidavit for the
Yes, and
application.
Yes, and if you all would like to have that marked for purposes of the record, for appellate purposes, I would suggest you all have that marked with the court reporter, and you can mark it as, if it's going to be tendered by the defense of the state, you can either mark it as D1 or D2R, which will signify it's for the record, or either states 1R, however you all want to do it.
Yes, Your Honor. I can mark it as 2. Well, I guess it is.
She has
It's
it already.
Well, I have it.
It's y'all's warrant. So we'll make it states are 1.
Yes,
That
I
works.
showed it to Jerry yesterday, but you.
I think it's the same as ours. Yep.
And what's being marked as states R1, do both parties have a copy of that?
Yes, Your Honor.
Yes.
And for those of you who are on docket and you're waiting for your attorneys, you have the court's permission to step out in the hallway and call your attorneys, because we're going to be recessing today at 10:45 because I have a meeting to attend. And if your attorney's not here, you're going to be brought back in the afternoon.
Yes, Your Honor. State offers state for one into evidence for purposes of this hearing.
Any objections for purposes of this hearing?
No, Your Honor.
All right. And for the record, the state had previously tendered what has been marked as states R1 to the court with no objection from the defense so that the court could review it in anticipation of this hearing. Is that correct, defense?
That's my understanding. Yes, Judge.
All right. So with regards to the affidavit for search warrant, defense, you may proceed.
Thank you, Your Honor. The application that's been tendered as states R1 is, in our estimation, and we believe the court will agree with us, insufficient to confer probable cause to search this phone. The contents of the warrant application detail roughly what I was explaining a moment ago, which is the way it was discovered. It was found in the center console of that black Kia, the 2013 black Kia Forte, that the officers believed was the vehicle that witnesses observed at the Chick-fil-A a few days earlier. In the warrant application, the officer details what can best be described as a boilerplate recitation of things that one would expect to find on any cell phone in the United States. Text messages, incoming and outgoing call logs, data associated with that, memory cards, subscriber information, etc. Then in the probable cause section of the brief, which begins about 2/3 of the way down the first page and continues on to the second and last page of the document, the officer details information that's roughly a fair summary of what the court has already heard in the trial testimony in this case, namely that witnesses saw a man in an altercation on the access road of 410 near the Chick-fil-A, that that man was out of the car. He got on the hood of the car, and then the vehicle pulled into the parking lot of Chick-fil-A. The man stood up and kicked the windshield, and someone inside the vehicle leaned out of the car and shot the deceased one time and fled the area. The affidavit also specifies that they recovered the cell phone of the deceased as a result of that preliminary investigation on the 23rd. And then on the 24th, they obtained a warrant for the records related to the cell phone of the deceased, Mark Anthony Saldivar. The review of those records divulged that there had been extensive correspondence with a person using a phone number 210-331-8356, which officers ascertained belonged to Joanna Marie Reyes, who also was registered as having possessed a black Kia Forte, which is the vehicle in question.
Okay, so far, nothing unusual here.
Then a bolo was put out for that vehicle, and after several days, it was eventually located in this parking lot where it was then impounded. And a blue iPhone with a cracked screen was found in the glove compartment. That's the recitation of facts. Then what I would submit is the mere conclusory statement that is the hobgoblin of courts everywhere. We immediately proceed to a bullet-pointed remark that Affiant believes the search of the above described thing for the above described items will constitute evidence that the offense of capital murder was committed on April 23rd, 2017 in Bexar County, Texas. There is, we've submitted in our brief, Your Honor, a citation to Baldwin versus State, which was a case, I believe, originally out of the 14th Court of Appeals in Houston that was granted discretionary review by the Court of Criminal Appeals and was issued, I believe, in 20.
Yeah, I've heard about this case before, if I remember correctly, and well, yeah, they will probably tell us, is that it's not enough with a phone being found in a car that is related to a crime. You have to go further than that in order to search the phone. You have to conclude that, not conclude, but you have to, by evidence, say this is the phone that belongs to this phone number, that this phone number belongs to this person. And in this case, here it is, the car belonged to the driver, and the guy had extensive phone calls with a phone number. In order for them to actually search the phone, they have to say, okay, we know whose number this is, and we know that this phone is connected to this number. And that is how it's connected to the crime.
23. In Baldwin, the court is concerned with the issue of using boilerplate conclusory language to authorize access to cell phone data, recognizing, as we must in the wake of Riley, that a cell phone contains all of a person's most intimate details, from their correspondence with other people to their location to their medical history, their banking records, everything. And that therefore the warrant requirement must be strenuously observed in searching the contents of phones. And we know that the Fourth Amendment requires particularity as to the place to be searched and the things to be seized. Things to be seized, I think, being the operative concern that the court had in Baldwin. The issue needs to be framed in terms of the affiant seeking access to a phone under these circumstances must draw a clear nexus to the matter that's under investigation and detail why he has probable cause to believe that those things will be on this phone. The officer does not do anything that would establish that. This document does not explain why they would have any particular reason to believe that that cell phone is the phone that would be associated with the number that was later connected to Joanne Reyes. And as we'll get into, if we proceed to the Franks aspect of the argument, we do definitively know that it's not the phone number for that phone that was recovered. And that there's very good reason to believe officers already knew that when this application was drafted. But I digress. Looking at the four corners of it, the officer doesn't do anything to explain why they would have reason to believe that that particular subscriber data for Joanna Reyes would be connected to this specific blue iPhone. It also doesn't explain why, even if it is connected to this blue iPhone, that would necessarily entail a right to search the contents of it. Even if they are able to ascertain that this deceased individual corresponded with someone named Joanne Reyes, that doesn't give us any indication that the phone was used in the commission of the offense, that the phone contained information that would establish a motive to kill or specific data related to the issue of whether or not it truly is a capital murder, whether it's a robbery, or anything else about the offense itself. But what's generally, I think, done here and is asking the magistrate to read between the lines and conclude is that criminals use cell phones. And that if a criminal has a cell phone on his person, it must contain incriminating information necessarily about that person's location, about that person's comings and goings, about the people that that person spoke to. But the court in Baldwin recognizes that, of course, that's true because everyone has a cell phone. Criminals and non-criminals alike use cell phones. Any person's cell phone would be able to provide all of the information about that person's comings and goings and correspondence. That's not the kind of nexus that we're talking about. And it dovetails with a concept that's been regularly recognized, which is there is no homicide exception to the warrant requirement. Routinely in homicide cases, the location where the death occurred or a suspicious place that is associated with the homicide is treated as though, I guess from a law enforcement perspective, the aim would be to say, okay, we believe that this is a suspicious place in conjunction with a homicide, or this is the situs of a dead body that we believe was killed illegally. We want to coordinate it off and preserve it in amber and say, this is ours now. We control it. It's our crime scene. We need to make sure for scientific reasons, for evidentiary reasons, that we are the only people that are able to influence what's going on, to collect and seize the search. And that's not the case. And so while certainly a suspicious location like an abandoned car or the residence where a dead person is found under suspicious circumstances might be a variable that needs to be articulated in a warrant for search of that residence, search of a phone, search of a vehicle. That isn't the be all and end all of whether it does get searched and whether everything within that particular area gets seized. It isn't a carte blanche situation. But when we read this warrant in its totality, it's clear that that's the assumption. The officer does not tell the magistrate any particular reason why he would have any reason to believe that this phone is going to be of greater evidentiary value than the phones of other individuals in the Chick-fil-A parking lot that day, other individuals in the parking lot of the Mexican food restaurant. And that's, I think, the problem.
But when you read and stay within the four corners of the affidavit, isn't it mentioned that the black Kia vehicle, that they have a license plate for the black Kia vehicle, and that black Kia vehicle is tied to the Kia vehicle that they're...
What does that have to do with anything, Judge Boyd? They are talking about, they are past the car. They are now talking about this is not enough, according to case law, to get access to phone data.
Saying was abandoned at the Chick-fil-A?
It does say that, Your Honor, but interestingly, and one moment to make sure I'm correct about this, it doesn't even say, I think I can get where the court's asking about.
Mm-hmm.
If we look at the things to be seized on the suspected thing,
mm-hmm.
which is the second bullet point of the application, It doesn't even talk about GPS or sword site location data.
No. I'm just going to your argument where you were saying that how is this any different than just seizing people's phones that were at the Chick-fil-A or parked at the Chick-fil-A? But I think that both parties can agree that the cell phone that was seized is a cell phone that is from inside the vehicle. I think we can do both parties agree that it was a cell phone that was seized from inside the Kia vehicle?
Yes, and that absolutely cuts to the bone of the question.
No. So I'm just going by your argument when you say, based upon this search warrant, anybody's cell phone from any vehicle at the Chick-fil-A could have been seized based upon this. But in the affidavit, they are only seeking to seize the phone from a Kia vehicle, which within the four corners of the affidavit, they have reason to believe that it was involved in some type of offense. According to this, they believe capital murder. And because the defense, you are not filing a motion to suppress the search of the Kia vehicle, I'm assuming, and if I'm assuming incorrectly, let me know, I'm assuming that you have no problem with the actual search of the Kia vehicle. Your only problem is the retrieval of a cell phone from that vehicle and the search of that phone. Am I correct?
Yes, Your Honor, we don't have standing to complain about the Kia, so I can't speak to whether that warrant was valid or not. We don't have a right to complain. It's not our car.
All right, so you don't have any standing to complain about the Kia vehicle.
Correct.
And you assume, or are you stating that you have standing to complain about the search of the cell phone?
Yes, we have standing to complain about the search of the cell phone because it's our cell phone. And well, just one second. The thing
And
about,
mind you, everyone, I'm just asking questions so I can be clear on everyone's argument.
yes, Your Honor.
Okay.
And I want to be sure that I have a chance to be heard.
Oh, yes. Here's the thing, everyone. You will all have a chance to be heard. I just want to make sure we pare down to what the specific issue is. All right, you may continue.
Yes, Your Honor. And so the issue of the seizure of the phone is, I think, I mean, it would be very difficult for us with a straight face to argue that we can object to the seizure of the phone because the phone was discovered in a vehicle we don't have standing to complain about. But obviously the phone is locked. It has its own contents. The contents are Mr. McIntyre's private matters and affairs. We have a right standing to make that complaint. The problem, I guess, would be to put it another way. Let us assume a hypothetical in which we all know who the killer is. We saw a person that everyone recognized discharge a firearm in broad daylight in public, and he was followed to a specific location and he was arrested. And yes, Your Honor.
All right, you may continue.
Sorry, Your Honor. In that hypothetical where we know that this individual is the killer and we have followed them and arrested them and we've acquired their cell phone incident to lawful arrest, the mere fact that the individual possessed a cell phone on him and we know that he is the killer, I don't believe under Baldwin would give them by itself probable cause to search it. And that's functionally what we have here. We know that this car was used in a homicide. That part seems to be beyond any meaningful dispute, at least not that we as the party could raise. And now, having acquired that, we found a cell phone. But that's literally all the officer seems to think is necessary is this car, like a known identified murder suspect searched into arrest, is involved in a homicide. So therefore we get to search the phone. And there doesn't appear to be any additional legwork. And that's really hard to accept, knowing that like the phone's in their custody and they had a warrant to seize the phone pursuant to what was authorized by the search of the Kia. And so in terms of whether or not this would mean, there's no excusable reason why there could not have been corroborative effort or due diligence to actually build that nexus that Baldwin talks about.
All right, and you're saying that this cell phone that was seized and searched is your client's cell phone?
Yes, Your Honor, that appears to be the case.
And they allege that, Your Honor.
Okay.
And if I can just interrupt
yes.
for a second, if you think about it, and I would call the court's attention to Riley versus California, which was a unanimous Supreme Court case, which there aren't many in the Fourth Amendment, written by the Chief Justice. It was a case where a cell phone was legally seized from the defendant. However, remember, it was search incident to an arrest. The court said you need additional probable cause to search the contents of the cell phone, even if you have legal possession of it. And in Riley, they talk about two additional matters. One, they talk about what cell phones are, that there are more cell phones in the United States than there are people. Everybody has a cell phone. And they talk about with all they contain and all they may reveal, they contain the privacy of every citizen's life. And the Chief Justice goes on to discuss the fact that cell phones, interestingly enough, have a nexus at the crossroads between the Fourth Amendment and the First Amendment. And that because of that, because they contain communication, which are the contents of that cell phone, it requires not just probable cause, but particular exactitude when you're looking at probable cause. And what it lacks here, and the court talks about the fact, otherwise we could assume that anyone convicted or charged or arrested for any crime, suspected of any crime, you could search their cell phone because you might expect to find some evidence. The requirement by the Supreme Court of probable cause is that it be particularized as the thing to be seized. We got the seizure, just like they had in Riley, as well as the person or items to be searched. And that's what is critical here. There is no probable cause. They do not allege any probable cause to believe what evidence would they expect to find on this particular phone. It is not a general idea that, well, you committed a crime. It looks like you must have planned something. Surely there must be something on your phone that shows something like.
So you all have no objection to the fact that the cell phone was seized.
I don't think we have standing to complain about it.
All right. So your only complaint is extracting information or data from the cell phone. Is that
Searching
correct?
the contents of the cell phone.
Access to it, yes, Your Honor.
Okay. All right. You may continue. I'm sorry for the interruption.
You didn't interrupt anything, and I'm finished.
All right.
I
Is
think
there
that-
anything else?
I think that's our argument. Basically, this warrant says that because it's a phone, it must have incriminating evidence on it. That's mere conclusory. Baldwin has disavowed that kind of boilerplate work. This is a boilerplate warrant. And I mean, it stands to reason it would be. This is a 2017 warrant. The state has had ample time to reissue a warrant if they wanted to. We think that this warrant's defective. We'd ask the court to find that it has no probable cause.
All right. In just one moment. All right. So what I'm reading from the affidavit is it states that the Kia vehicle, which defense you say that you have no standing to object to the seizure of it or the actual search of it, that Kia vehicle, according to the four corners of the affidavit, was driven by Joanna Reyes, and that Joanna Reyes has custody of the Kia.
You could be right, Your Honor. I think
From page 2,
it was.
from page 2 of the
Yes,
affidavit,
I think that might be.
paragraph 3. It
Right.
says that Reyes informed your affiant.
Well, she also drives and has custody of a black Kia Forte. In other words, she owns one, but I don't think that the affidavit is saying that she was driving it on the day in question. I think that that's an important distinction to be careful
right.
about. I don't think that they've confirmed that she's the operator on the day in question, just that she owns that make and model vehicle.
All right. And then it says she drives and has custody and control of a black 2013 Kia Forte, and it has the license plate number and the VIN number listed.
Yes,
right,
but they found it abandoned in a parking lot, so we know she wasn't driving it at the time that they seized it.
No, I understand. your
That's
point.
all I'm saying.
So the affidavit says that. And then in the paragraph, the first paragraph, it says that in reviewing the records, your affiant noted that the victim had been in contact with a person using a phone number, and they list the number, over a period of approximately 2 hours from April 23rd, 2017, 2:53 p.m. to April 23rd, 2017 at 4:48 p.m. And the reason why I bring that up is because, and maybe you would like to address that, because one, I understand that sometimes there's boilerplate where people just want to search everything. Hypothetically, sometimes there's someone who has a drug case and they're in a vehicle and people believe, oh, we found drugs, so now therefore we get to search everybody's phones. And there's no connection between the alleged offense and the phone. But on page 2 of this, you have someone using a phone number that they mentioned in paragraph 1. Then you have Joanna Reyes, who they're saying had control or custody in control of a black 2013 Kia Forte. So do you want to address the fact that in the affidavit, they're having a phone number, and then you're having this black Kia that they said was in the control of Reyes? Do you want to address that?
Yes, Your Honor, I think we can. A couple of things. As I was saying earlier, the affidavit identifies that the woman that Mr. Saldivar had correspondence with on the day of his death was, in fact, that she is registered to own or drives and has custody and control over. I think what we would find out if we dug into that is it's actually a man they say is her husband, but that she has a Kia Forte that's black. That doesn't that again doesn't establish that they have definitively determined that the black Kia Forte of Joanna Reyes is in fact the same black Kia Forte that was at the scene of the Chick-fil-A. They just are saying that they believe they have that. But more to the point, Your Honor, I think here's the most important thing we need to note. We know that there is no recitation of corroborative detail anywhere in the affidavit. In other words, apart from the fact that this was found in a black Kia, and they know that Joanna Reyes, a person that Mr. Saldivar spoke to that day, owns a black Kia. They have not done any additional corroborative detail that is particular to the phone. And more importantly, and this is where I think it gets interesting, and obviously this issue will become also significant if there's a Franks hearing, but it's important for the Four Corners because the officers tell us in this application that the telephone of Mr. Saldivar was tossed out of the window of that black Kia on the day of the shooting and that it was recovered. And they know from that follow-up and that search warrant application for the deceased's phone issued on April 24th, the day after the killing, that's how they come to know that he's been corresponding with this 210-331-8356 telephone number that they eventually establish as Joanna Reyes. What that tells us is they have the phone, they've been able to acquire information on it, but they've spoken of no additional corroboration. The thing that immediately comes to my mind is it would be rather simple for them to have called that phone number using the deceased's phone number and determining whether or not the phone that they seized from the black Kia rang. And that isn't in this affidavit. Nothing of that nature is described, nor is any other investigative effort leading up to the right to get into this person's phone undertaken. They have decided, or they have assumed, that because black Kia Forte is the suspect vehicle, make, and model, they found a black Kia Forte belonging to someone who has a phone number that was in Mr. Saldivar's phone, that somehow is the nexus required for them to be able to search the blue cracked iPhone found in the glove box. But that it hasn't said anything about the blue cracked phone on the glove.
All right, and counsel, your co-counsel wants to show you something. Yes.
And Your Honor, while they're doing that, if I may, Judge, the issue of the black Kia entitles them to seize it, just like in Riley, they were entitled to seize the phone. The question is whether there's probable cause to believe there's something in the contents. They got a search warrant for Joanna Reyes's cell phone separately. And that tells you that they understand they need that. And the problem here is that whether they came into possession of the phone, just like in Riley, the unanimous Supreme Court case, there's a separate issue requiring, and the Supreme Court makes it pretty clear. The Chief Justice says the question of what the law enforcement needs to search a search warrant, I think I'm quoting it pretty correctly, is simple. And it's -- get a warrant to search it, even though they had possession of it. So the fact that it was connected with a vehicle is fine. But the only call that they might find that they are looking at that says, okay, the guy used his cell phone is to a different phone. They get a search warrant for Joanna Reyes's phone. There is no search warrant to search the contents of our client, Mr. McIntyre's cell phone that gives probable cause to believe they have particular probable cause, and I believe the phrase I said, particular exactitude. I think the language of the Chief Justice was copious exactitude, that they expect to find something on that phone. Otherwise, every time they make an arrest and they find a cell phone on the person that they believe committed the crime, you might find something on the cell phone. The guy made a call. Well, everybody makes a call.
All right. So your argument is that there's no nexus between the extraction of the cell phone data and the offense. Is that what I'm getting from your argument?
There's no
corroborative detail, no nexus.
There's no particularity with copious exactitude that
I think they are talking beside each other here, over each other's head or under the elbow or whatever's. It's not really what she's asking here, because it is what the cops claimed in the original affidavit. That is the foundation of what they then did as a search. If the nexus isn't there, they're not allowed to search. they might have found the nexus later, but not at the time.
They know that, or believe, have probable cause to believe there's something on that phone any more than there'd be every time they arrest somebody and find a cell phone.
Okay. All right. Thank you. All right. State.
Judge, just before I get started, I just wanted to make sure for the purposes of this hearing, they are stipulating that that cell phone that was located and the black Kia Forte belongs to Taymor and McIntyre.
Your Honor,
No, they allege that.
their allegation alone is sufficient to confer us standing. And under Simmons, the defendant is not required to forfeit one constitutional right in order to assert the balance of another. The government has alleged that this is Mr. McIntyre's phone, and I believe that that is sufficient for us to have standing to have a complaint about the way in which it was searched. If the court disagrees and wishes us to make that stipulation, we can talk about that, but I think it's inappropriate for them to be asking that question.
And if we did, we do it under Simmons, Your Honor.
Well, this is what I'm telling everybody. I'm strictly going by the four corners of this affidavit, which I'm bound by the four corners of this affidavit. And within this affidavit, it doesn't say anywhere that this cell phone is your client's cell phone. So I'm strictly going by the four corners of this affidavit.
I think standing is generally speaking, not required to be within the four corners. I
Well-
believe that standing can be demonstrated outside of the four corners of the warrant.
Well, I will say this, your co-counsel stated that the reason for the defense not complaining about the actual search of the Kia is that you all did not have standing to complain about the search of the Kia.
We did.
And within the affidavit of the search warrant, it states that the officer who wrote the affidavit through witnesses or however he obtained the information was that the Kia was under the custody and control of Reyes. And so at the beginning of the defense's argument, the defense stated they did not have standing to argue about the search.
No, seizure.
No. Counsel said that y'all did not have standing to complain about the search
Of the Kia.
of the Kia because,
Or
The Kia-
seizure of the phone.
yes, because the Kia doesn't belong to your client.
That's
What
correct.
I'm saying is, in the four corners of the affidavit, it does not state to the court that this cell phone that was seized belongs to Mr. McIntyre. If it does state that, please bring it to my attention because maybe I didn't read that.
The warrant does not say that, Your Honor. That's
Okay, all right.
correct.
All right, so let me do this. Time out. Let me hear the state's arguments, and then you all will have a chance to address whatever argument they raise. Now, it
And the
appears,
state asked, would we stipulate to the standing, to our standing as the owner, possessor of that phone? And we will under Simmons, which is for purposes of this hearing, we agree that that is our phone, and we do that stipulation with my client present under Simmons with the obvious Simmons caveat
so-
that we're not agreeing that we possess it for any other purpose at trial.
all right, so they are stipulating that the cell phone that was seized belongs to Mr. McIntyre.
Yes, Judge, so that's all I was asking. So I'm going to be referring to State v. Baldwin, and the site for that is 664 Southwest 3rd, 122. And so I just want to make sure that the court, as you said, is bound by the four corners. I know there's been a lot of extra facts thrown out by the defense in their argument. However, that case states that probable cause for the issuance of a search warrant exists under a totality of the circumstances. There's a fair probability that contraband or evidence of a crime will be found. And so if we take a look at the search warrant regarding the suspected thing that is to be searched, that information that's contained within there is not boilerplate. It's referring to text messages, incoming and outgoing calls, and additional data and information to determine who the owner is. That is corroborated, the text messages and the call logs with inconsistent with what is later stated that I'll move on to, which is that on April 24th of 2017, the affiant did apply for a search warrant for the cell phone company records of the victim, Mark Anthony Saldivar. Upon receiving that information, he did observe that the victim was in communication with the listed phone number for approximately 2 hours before the murder. And so that is states in the four corners that the murder occurred on April 23rd of 2017 at approximately 17:22. And we can look at that in comparison to the hours of communication, April 23rd, 2017, from 2:53 p.m. to 4:48 p.m. So that's immediately in the vicinity of the murder. Using law enforcement databases, the detective then links that phone number to Joanna Marie Reyes. He receives information that Joanna Marie Reyes drives and has custody of that black 2013 Kia Forte. And so it's a reasonable deduction, Your Honor, that that was the phone, that the phone contained in the black Kia Forte was used to communicate with the victim. And we have eyewitnesses that say that black Kia Forte is the car that and that's contained in the Four Corners. If I could just have a moment to find it, Your Honor. The witnesses observed the victim inside a dark colored vehicle, and that had windshield damage. And so they get the make and model of the black Kia Forte, 2013 Kia Forte, the license plate, and a VIN number. And that was corroborated with the surveillance footage as listed in the affidavit. Furthermore, there was a be on the lookout place, and that's how they came in contact with that 2013 Kia Forte. And all of that information is matching the license plate and the VIN number. And so, just going back to Baldwin that I cited earlier, that case further states that the reviewing courts should give deference to the magistrate's probable cause determination, and even in closed cases, give great deference to the magistrate. And when in doubt, reviewing courts should defer.
Folks, I have to ask this of you. There are people here who have not seen the trial. So please, no spoilers. Please, no spoilers.
To all reasonable inferences a magistrate could have made in issuing the warrant. And I think that the Baldwin case is in direct conflict with the facts that we have here. The issue in Baldwin was that the affidavit that was contained in that case did lack particularized facts. And so the fact scenario in that case was that the affidavit indicated nothing more than that neighbors saw a certain white sedan with a black driver circling the neighborhood the day before the murder occurred, and that defendant, a black man, was driving the very same vehicle 4 days after the offense. And the affidavit contained nothing about the phone being used before or during the offense. That is in complete contrast with the facts that are contained within the four corners of the warrant that we have in this case. And so I would argue that there is no boilerplate language, and we're asking the court to deny the motion to.
All right, before we learn the court's decision, we got raided by Captain Williams. Heyo! Heyo! Good to see you all. Good to see you all. And folks, welcome to Judge Boyd's court. This is an ongoing trial we are watching. It is the trial against Mr. McIntyre, or better known as Tay-K 47, a Texas-based rapper. He is accused of capital murder, charged, and this is the trial. The murder took place in 2017. He wasn't arrested until 2019. He is currently 24 years old. So this took place when he was 16. Mr. McIntyre also is currently serving 55 years in prison for another murder. But this is the trial where they allege that he somehow lured the victim to meet up with them. The state's case says that he then stole from the victim. The victim then, it was a fight in the car. The victim got out of the car, jumped up on the hood of the car. They drove into a Chick-fil-A where the victim then decided to stomp the windscreen, the window, until it caved in, and then somebody in that car pulled a gun out and shot and killed the victim. And the state's case is people who saw this happen, and the testimony from the other people in the car claiming, no, we definitely didn't shoot. It was him. And they allegedly have changed their story on all the way up until the state offered them freedom in exchange for their testimony in this trial. That is the short version. And what we are listening to now is a hearing about was the search of the phone admissible?
If I may, Your Honor, just briefly,
Yes.
the most important word in this entire document that defeats her primary premise is the word occupants, which is in the 4th bullet point of the first page, second paragraph. Witnesses were located that observed the victim inside of a dark colored vehicle shortly before the shooting. The victim was forced out of the car and continued to argue with the occupants of the car. The victim jumped on the hood of the car as it began to move. Occupants, the plural, is the primary reason why the only argument I think that it was worth considering there has to be rejected. She's saying that the magistrate can draw a rational inference that because the phone is located in the car and the car is believed to be the car that was involved in the shooting, it must be the cell phone that Mr. Saldivar was corresponding with. But we know from the word occupants, there are multiple people in that car other than the deceased. And that would ostensibly mean that there could be more than one phone. That would be the reasonable inference. So the reasonable inferences that a magistrate would necessarily have to draw from the use of the plural in that paragraph is that he has no particularized reason to believe that this phone is the phone that Ms. Reyes possessed and corresponded with Mr. Saldivar on. And because of that, it is a boilerplate mere conclusory statement. Also, she said several things there that just, I think, take the application out of context. The second bullet point on page 1, very plainly, is just a boilerplate recitation of things that every cell phone in the world would have on them by nature of being used as a cell phone. And none of it is to say that there has been any investigative effort to determine whether this phone has those things on it, whether the things it has on it have relationship to the offense that they're investigating, or anything else. It's just a laundry list that could be copy pasted into any warrant under the sun that's talking about cell phones.
And if I'm correct, Your Honor, when you look at, if I may, Chair Schultz, I'm speaking loudly because I didn't pick up on mine, and I apologize.
Hey, Catnot Williams, member for a whole year. Yay! Birthday girl, birthday girl, birthday girl. Happy membership 1 year to you. Happy membership day 1 year to you. Happy membership 1 year day, dear cat. Happy 1 year membership day to you. Well, thank you so much. And thank you for the raid. Thank you so much. Once we are getting to the end of this, I will go through the Mr. Steele's response to Fani Willis' motion to revoke probation. But that will be in the once we are done with day 2.
It is the state's position that because the victim used their cell phone to call numbers, they know what number this cell phone is. And the problem is there's no indication that that they had any information that the victim's cell phone ever called the cell phone in question, which for purposes of this hearing, under Simmons, we have stipulated as ours. So the other cell phones that people might have had, if they had a number that corresponded with the numbers that were called or texted to or Instagram or whatever they were going to do to them, but there's none of that. So what you have is just a random cell phone, and we're going to look at it just since it was found in the vehicle where the related to the offense, we might find something. There's no indication that was the number called. As a matter of fact, it wasn't.
I would just point out,
And they could have found that out if they did. They may have known it, and that relates to the Frank hearing that we may have to have. But that there's nothing to suggest that they have any particularized, with copious exactitude, particularized probable cause to believe there's anything on that phone, and certainly not a call from the victim, because there aren't.
All right.
So once they went through the phone, they discovered there were no calls from the victim to that phone. Okay, so not even with the search of the phone, they found an actual nexus in that regard.
So this is what the court is going to do. Defense's motion is denied. Let's move on to your next motion.
Wow. Okay. Okay. So, phone is in my opinion, in violation of current case law, the Texas v. Baldwin. Okay.
And yes, Your Honor, before we, just so I'm clear, the motion in question seeks essentially two alternative paths for suppression. The main thrust of our argument is the Baldwin claim. But as Mr. Goldstein has pointed out, we believe that both with Mr. Goldstein's proffer and also the proffer made in the motion itself, that we have made the thresholds showing that would.
All right, so everyone, this is what I want to tell you all. I've heard your argument. I've allowed both parties to present their argument. The motion is denied. So we're going to move on to your next motion. So what I'm denying.
Okay, so she heard both parties and then she's flat out denying. By what standard, Judge Boyd? By what standard? I'm missing what standard. What is it in the Baldwin statute that you say? What is it in the Baldwin statute that the defense have not shown you?
So that everyone can be clear, the court is denying your suppression or your motion that there was no probable cause for the search warrant. The court is denying that. The court is finding, based upon the affidavit for the search warrant, just the four corners of the affidavit, that probable cause was presented to seize the cell phone, to extract information from the cell phone. So let's move on to.
Yeah, I think she's using the wrong standard here. Did they have probable cause to seize the phone? Yes. Nobody's arguing that. It is the extraction, the search of the phone. According to Baldwin, you need more.
May we ensure that the record reflects, is the court saying that you're denying our request for a Franks hearing based upon the fact that we believe we have made a showing that we're entitled to that hearing, Your Honor?
No,
That's beyond the under
first.
Franks, you assume that there's probable cause. In the
All right,
warrant,
so-
you're just suggesting that there's reckless or intentional misstatement.
All right, so here's the thing. This entire hearing that we have been having, defense, correct me if I'm wrong, you've been requesting the court to find that this affidavit for search warrant, in layman's terms, should never have been signed by a magistrate judge. Is that correct?
Yes, Your Honor.
All right, so-
The four
so-
corners argument is
so-
what you're denying.
So I am denying that.
Right.
So we're moving on to the next step.
Which
So
is the Franks hearing.
all right, yes.
Yeah, but the Baldwin case was in, let's see here. Baldwin case, I have to find the date it was signed. Because this happened in 2017. The Baldwin case became statute in 2022. So just because a magistrate signed it 2017 during the previous statute does not mean it was correct under the new statute. So yeah, here I believe Judge Boyd makes the wrong decision. Just because it was correct at the time doesn't mean it's still correct. That is because of the change of statute.
That's what I've been saying.
I didn't realize that, Your Honor.
I apologize, Your Honor. I put both theories in the same motion.
All
so
right.
I just misunderstood you.
That's okay. So we're just doing one step at a time.
So
I think it's important to do things one step at a time so the record is clear. And so the record is clear. Your argument that there wasn't probable cause for this magistrate to grant the officer or whomever it may have been to seize this phone, which you said there was no objection to seizing of the phone. Your objection was to the actual search of the phone, which would mean extracting the data. The court is denying your motion as it relates to the affidavit of the search warrant. So let's move on to your next argument.
Yes, Your Honor.
So the search warrant, the court is finding in favor of the state with regards to probable cause within this search warrant to to search the phone, because you have no objection to the seizure of the phone. Your only objection was to the extraction and obtaining of the data that was located within the phone. So that part of the defense's motion is denied. So let's move on to the next part.
Okay, now I'm with
Yes,
you.
Your Honor.
Yes.
Yeah.
The next argument that we would like to make is that we believe that some of the things we've discussed with the court this morning that we know are outside of the four corners of the affidavit, vitiate probable cause, that undermines what the affidavit purports to confer. And in particular, what we're saying about this is, number one, we know that the police immediately upon seizing Mr. Saldivar's phone called numbers that were on that phone to try and develop suspects and leads, and would have also called in the course of that, based upon what the affidavit is displaying, the number that they later determined belonged to Joanna Reyes. And so on just the most simplistic basis of understanding this, the police had all of the appropriate equipment, and I believe did ascertain by just simply calling the phone. That the phone they seized from that Kia doesn't ring when you dial Joanna Reyes's phone number, which is that 331-8356 number that's in the warrant application, which would have absolutely wiped out the insinuation of this affidavit. That
All right, so here's the thing. I don't have anything before me unless it's in the affidavit that suggests they called a number and that number that they called didn't go to the seized cell phone. Is that in the affidavit, or is that another argument outside of
That's
the
the
difference?
what I'm now trying to ask the court is for permission from the court for us to have an evidentiary hearing to understand whether or not, going outside the four corners of the affidavit, the officers were intentionally misleading or recklessly disregarding of the
No, I
truth.
understand what Frank says, but I just want to, it's not in the affidavit. So you're trying to state that the officer either was untruthful or misleading in his obtaining of a search warrant?
Yes, ma'am.
All right.
My position is that the evidence would show that the police were calling the phone numbers on the deceased phone and would have been able to determine through that this is not the phone number that was used, and I believe they did do that. I also
And to
believe
tell the magistrate.
that they had Joanna Reyes's cell phone already in their possession when this warrant application was filed. And so they knew when they filed this application that they weren't going to be cracking into Joanna Reyes's phone. And that is very misleading based upon how this affidavit is drafted.
And that's why they got a separate warrant for her.
Those are what we believe the evidence would show if we were able to go behind the four corners. And so we'd like to be able to have testimony and for the court to consider that what's being said here is just not true. And that
So you want to call an officer to say that within the four corners of this document, this is not true what they've given to the magistrate? Are you saying it's
There is a
misleading?
misstatement that if excluded would render the warrant lacking in probable cause.
What
And I think that's
misstatement?
the essence of Frank.
well, the way that I read this warrant, Your Honor, I read the warrant and I say to myself, as we've already argued, I'm not rehashing it, that it never connects this phone to Joanna Reyes's phone number. It insinuates it. It implies it. And I think that the state's argument on the four corners is it's a rational inference from this
But no,
document.
what are you bringing to the court to support, other than conclusion statements? What are you bringing to the court to support that this officer was misleading or that this officer was untruthful? That's what the court wants to know.
What we're bringing, what we believe we can demonstrate is that they issued a search warrant number 2017-W0295 for the phone records.
Excuse me, slow down with your numbers, because remember, the court reporter has to take it down.
They issued warrant number 2017-W0295 for phone records from Verizon for Mark Anthony Saldivar's phone number, 210-382-3826. That they issued a warrant number 2017-W0308 for the phone records from Sprint PCS account for Joanna Reyes's cell phone number 210-331-8356. Then they issued a warrant for number 037672 for Joanna Reyes's black Kia Forte, and then issued a warrant number 2017-W0405 for a forensic search of the blue iPhone belonging to Taymor McIntyre found in the black Kia Forte. The position we would take is that they already had ascertained Joanna Reyes's records and knew that this cell phone was not Joanna Reyes's before the blue iPhone was seized, or at least before the application was signed. And that what is represented here, that the reason why they don't just come out and say it, because if in fact they really believed, as this warrant implies, that they were going to find Joanna Reyes's cell phone when they cracked into it, they could have just said that.
But in the affidavit, it clearly states on page 2, using the clear search engine and other databases, your affiant determined that the phone number was being used by Joanna Marie Reyes. And when they're speaking, No, no,
That's a different phone.
That's a different phone.
that's what I'm saying. So you're saying that this officer was being misleading when clearly in the four corners of the document of the affidavit for the search warrant, he is telling the magistrate that he has a phone number, that number ending in the number 56, and that's in paragraph 1 on page 2. And then in paragraph 2 of page 2, he says, using the clear search engine and other databases, your affiant determined that the phone number was being used by Joanna Marie Reyes. So nowhere in the affidavit does this officer state or try to state that the phone number that they seized, the iPhone, that in some way was Joanna Reyes's cell phone, and that they knew, and thought that that cell number was Joanna Reyes. That doesn't say it anywhere in this affidavit. I mean, am I incorrect?
That's part of why I think that the court should reconsider the probable cause question. The only
No, it's
only
denied.
reason why this warrant should have issued is if it would be reasonable to read the warrant as suggesting that there was a reason to believe it was Joanna's
All right,
phone.
so here's the thing. The court is finding that probable cause existed for the magistrate to sign this warrant. The court is denying your motion.
Here is my issue here. Judge Boyd says, let's listen to it again.
Probable cause existed for the
Probable cause existed. Yeah, but that is under pre-Baldwin. Yeah, at the time he signed it, it was correct. But that was 2017. Now we are after Baldwin, the new statute, in effect 2022. Now that is not enough.
magistrate to sign this warrant. The court is denying your motion for a Franks hearing. The court is finding that defense is merely presenting to the court conclusionary statements, and that what the defense is presenting should be addressed during cross-examination. If you all could give me just one moment, please.
No, it is. All right.
Oh, no, 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 no.
Thank you.
Okay. We are taking a break.
Martin Act, which was passed. This is the the court had asked as I was coming in about
The NCIC, TCIC. All right, thank
these
you.
are two cases, the Monk case and the Watkins case.
Sure.
Are,
All right, I'll review it.
they are 2006. They predate.
Yeah. In all of this, the prosecution or the investigator, after the 2022 new Baldwin statute, they could have refiled with the knowledge they had at the time. They could have refiled this to a new magistrate. They chose not to.
The Michael Martin Act, which was passed in 2013. I would point out to the court, for purposes of our request, that if the text of 3914A says we're entitled to copy, retain, all sorts of items
Well,
that
not the NCIC. It says that they have an obligation to provide you with Brady.
I understand.
but-
sir. Those are before the Michael Martin Act.
Okay, so, and according to the rules, they are required to turn NCIC, TCIC to you for purposes of cross-examination. My understanding is the state actually gave it to you. Well, did you all give it to them well before cross-examination of the witnesses?
They gave it to us yesterday on April 1st, Your Honor.
Right.
And
Now, I will tell you, that is usually unheard of. Usually, in the past, the state would drop NCIC, TCIC immediately before cross-examination, not earlier in the day.
I think two things, Your Honor. While that's maybe the court's practice, I think realistically, as a former defense lawyer, you understand that the records are not themselves admissible. So counsel may need them in a little bit in advance. And by the way, we're not arguing about timing, because I want you to know that the state did tender them to us, and we're not arguing that was untimely. And the issue is whether we could copy them and retain them for use during the proceeding. And what I was going to advise you, those two cases, Monk and Watkins, just say we're entitled to just discovery of them. I believe that the state has provided us with discovery with them, and I want to compliment. Here is where the issue is. Whether we can use them during the proceedings, I think, requires us to have copies, and there is a conflicting provision in 3914A. It says we're entitled to copy these documents, and there's the last sentence in 3914 subparagraph A is subject to any applicable privilege.
All right, so,
And Manfred,
yes.
go ahead.
no.
No, you're the person that got to
No, what I was going to say is the court is not going to allow the defense to have copies or leave the courtroom with the NCIC, TCIC.
Right, and I'm trying to make a record.
Sure.
Just obviously, we will abide by this court's ruling. I want the court and counsel to know that. Secondly, I'd like to make a record as to why we think that that's wrong. As I mentioned in my opening briefly, we can disagree agreeably. I would like to point out, Your Honor, that the provisions are confusing because in 3914 subsection H, it says that we're entitled to any and all Brady material. And if you notice in the Watkins case, the court does recognize this as Brady material. And if you look at Bagley, Giglio, never understood how to, but I can spell it Giglio.
Yes.
I've heard it pronounced all sorts of ways. But in Brady versus Maryland and his progeny, Giglio and Bradley, the courts have said we're entitled to it not just instantaneously, but in time to be able to use it. And the problem is, while we're in the courtroom, it is impractical for us to actually use the information on that realistically in order to prepare for cross-examination, because the rap sheets, I'll just say for NCIC and TCIC, are not admissible in themselves other than as business records. What you need to be able to prove is the substance of what they're saying. So we've got to do some investigation and produce that information. While it does help to be able to ask a witness, is it in fact true that you were convicted on such and such a day? Or if it's relevant as a 404B, other crime or misconduct, is it true that you committed this offense if it's just an arrest or something like that? Then you got to go and get the substantive evidence so you can extrinsically offer it into evidence. And that's what we're suggesting, is that we would like to have that opportunity. And if we're not, we believe that violates the spirit of Brady and his project.
All right, thank you so much.
You're welcome.
So, yes,
If I may just briefly respond, so, with this,
okay, go ahead.
okay, so just, I just wanted to cite some statutes. So I have a federal statute, it's 28 CFR for 20, which governs the release of NCIC, TCICs, and then also the Texas Government Code, section 411.083, which both govern decimation of criminal histories, and they specifically accept agencies which are allowed to keep them in their custody. Defense attorneys are not listed in that. I am happy to provide them with a copy to review in court, but just like Mr. Hunter stated, he would not like to be charged with a misdemeanor. I would not like to either, and so that is the reason for our position.
All right, so with regard to, I don't, okay,
Counsel for the state brought up section 411.083. I would just would like to make the court aware of section 6 of that statute, which states that an individual or an agency that has a specific agreement with a non-criminal justice agency to provide services related to the use of criminal history record information disseminated under the subchapter, if the agreement specifically authorizes access to that information, limits the use of the information to the purpose for which it is given, ensures the security and confidentiality of the information, provides for sanctions if a requirement imposed under paragraph A, B, or C is violated, and requires the individual or agency to perform the applicable services in a manner prescribed by the department. As Bexar County attorneys are subject to the Bexar County discovery rules, we both agree to a contract for relating to the dissemination of discovery information, and are also similarly bound under 3914 and the Code of Ethics, which directly relates to this issue.
All right, so the court is not going to allow you to copy or leave with the NCIC, TCIC. All right, so back to the other motion.
Yes, Your Honor.
Yes, counsel.
The next reason we are arguing that the cell phone should be excluded from the trial of this cause is based upon issues related to production. As I explained a little while ago, before we segued to motion to suppress, in February and in late January, we were discussing matters of scheduling in an off-docket conversation, advising the court that we were having some concerns about one of our experts and that we might be needing to seek a postponement of the trial date. When that occurred, which I believe would have been, it was certainly after January 15th, but before January 31st, the prosecution came up to me and advised me that they had a new cell phone dump that they needed to provide me. And I received an external hard drive the next day, I believe.
All right, and what approximately, when was this?
This was in late January of this year, in 2025, which we then filed supplemental briefing on in our motion for continuance for the February trial setting, explaining that a cell phone dump is a very voluminous and large amount of material. It's very cumbersome and time consuming to go through it. It requires expert consultation, especially if there are deep concerns about the material on it, and that we weren't going to be able to do that in the time period afforded. The court at that time indicated to us, I believe at our formal trial docket setting, while we were urging our motion for continuance and the supplement, that if the cell phone dump was going to be a problem, then the court might entertain the fact that it would not be admissible because it's untimely produced. Understand that this dump has been tendered to us 7 years after the seizure of the phone. It's a little more complicated than that, though.
So have you been on this, how long have you been on this case?
The earliest piece of correspondence I have about this case is in 2018, when Mr. Goldstein and I believe, were first retained.
All right, and so that was when you were, when it was in juvenile court, or was it in a different court?
Juvenile court, yes, Your Honor, and it was, I believe, our discovery request may even predate his actual physical transfer of custody to Bear. So it would have been still up in the air, as it were, whether he be certified formally by the court as an adult in this trial.
Right.
In any event, Your Honor, it should be stated and be clear, a dump was tendered to the defense counsel a long time ago. I can't say whether it was in 2018 or 2019, but a cell phone dump was tendered at that time. That dump was a technical extraction of the data. It was in a PDF format. A lot of file folders or a lot of documents that were listed within that PDF format.
All right, and when was the dump done?
The dump was in 2017.
So in 2017, there was a cell phone dump.
Yes, Your Honor. Extraction. An extraction.
Okay. And did you have access to that extraction or no?
We received a PDF format copy of it, which we reviewed and we largely found to be sort of unintelligible.
All right, and so that was in 2017.
That's correct. Strategically, we felt that that level of extraction would probably be advantageous to us, because our argument could be that the way in which the data was extracted leaves doubt as to certain key questions that may exist on the phone. In other words, we felt that the work of the police was insufficient to merit a great deal of additional attention to the matter. And we didn't have many discussions about the cell phone afterwards. Then in 2025, in late January, we're provided with another dump. We have been trying very hard, and I still do not know this definitively, but we've been trying very hard to compare and contrast it with what we have been previously tendered, which is a time-consuming process because it's like a 4,000-page document. That effort, I mean, they appear to be very, very similar in nature. And we also engaged a expert consultant to help answer some key questions that we as technological Luddites don't know about why it's in this format, why it's so difficult to understand the format. Why can't we just get a UFED Cellbrite reader dump where we can go on our computer and open Snapchat folders and open Instagram folders like we would for a dump in 2025? And what's been explained to us is that this is a technical extraction. It is the lowest tier type of extraction. In other words, it's a summary of the information. It isn't really the full contents.
It is not the current Cellbrite, that's CELEBRITE.
And let me correct for the record. I've said technical extraction. That is not the right word. It is a logical extraction.
All right, just one moment off the record. Who are the people? This is students from a school, I think. For mock trial. All right, just give me a moment. All right, you may please find a seat. All right, you may continue.
Thank you, Your Honor. Suffice it to say, between our efforts internally with my office to try and compare and contrast the new dump with the old dump, and then getting an expert to help us sort of better understand exactly why the discovery is in the state that it's in. We have consumed both man hours in my office that could be spent with other aspects of Mr. McIntyre's case, and we have spent Mr. McIntyre's money on trying to determine whether or not this is something new and what exactly about it is different than what we had previously ascertained. And while it appears to me that there is nothing new, I can't say that with absolute certainty yet. The problem we have here, and the basis for our motion for exclusion on this motion, is that under Heath and Watkins acknowledge that 3914 requires timely production of discoverable material.
Yeah, and we are at trial and heard on day one that they have just days or maybe a week prior got an entire discovery dump.
And that this has complicated the question of the dump, whether the dump
So
comes
the dump that occurred in 2025 that you're saying occurred, that seems to be similar to the dump that occurred in 2017. What month in 2025 are you saying that you received that?
it would have been in February, I believe. It would have been-
February,
whatever the date of our last docket appearance, it would have been the Friday before, I think. And State, please correct me if I'm wrong about the exact timing of that, but it was around that day.
And Your Honor, the expert that Mr. Hunter has described is an individual by the name of Eric Devlin. He's a nationally recognized digital forensic expert. His affidavit is attached to our motion, which points out the fact that it is unusable in the current form and that he would require at least until the end of April to be able to even determine whether it can be turned into a useful format.
all right, and I'm sorry, just so I can have the dates clear, counsel.
Yes.
So the Friday before would have been January 31st. The court shows that motions were scheduled in this case for February 3rd. So because you're saying it's the Friday before was January 31st.
And it wouldn't have been that date because I was in a trial in another court that day.
All right, so
I-
I'm just saying that's the day before. That's the Friday before February 3rd.
And John, just, I don't want to interrupt you, but I have email correspondence from us from January 28th, so I think it would be fair to say it was somewhere between January 28th and February 3rd date of the motion.
That sounds roughly what my recollection of it is. Your
All
Honor.
right, so-
And I need to correct something else because I'm just not very technically savvy.
No, no,
so
no,
I said
so-
something wrong.
So my understanding, and I'll give you a chance to correct, I'm just trying to make sure I have the dates in my mind correctly. So your correspondence is somewhere between what dates?
The correspondence between me and Mr. Hunter's office was from January the 28th. And so I believe it's fair to say that it was turned over in between January 28th,
Oh.
2025, and then the February 3rd.
Okay, that was not what was alleged yesterday.
2025 hearing date.
All right, and so do you agree with that defense that the information would have been given to you between January 28th, 2025 and February 3rd, 2025?
That tracks with my recollection. I believe that's right. Yes, Your Honor.
Okay, and
Yeah, then you have had 2 months. That is kind of plenty of time.
I'm just, for both parties, I'm just trying to get all of the facts so I can make an informed decision on your request. All right, you may continue. And you said there was something you wanted to correct?
Yes. So there is one difference between the 2017 and now, and that is that we now have the raw data for a logical extraction, the lowest level of extraction, which was not provided in the 2017 extraction. But to be clear, it's the same extraction. In other words, it isn't as though the phone was worked over again in 2025 or 2024 or something. It's just that additional information that is attendant to that original file has now been provided. And that's that. So I just wanted to correct that.
And I believe in the motion and affidavit, it would appear that we did hire Mr. Eric Devlin, excuse me, shortly thereafter, after the February 3rd hearing. And he examined the material, attempted to use it, and the affidavit attached as Exhibit 1 to our motion that the court has before it is dated February 30th, which will indicate that he was working diligently until that time, and he set that out in the affidavit.
All right, and so my understanding from what the defense has informed the court is that you received data in 2017, and at that time, This case was not before this court because it was in juvenile.
That's correct.
And from defense argument, or what the defense is telling me, is that in 2017, you received a PDF for this cell phone dump. Is that correct?
That's correct. I don't know what, so I think that we requested discovery from the former prosecutor while this matter was being transferred to Bexar County and awaiting in juvenile on March 1st of 2018. So it would have been sometime in 2018 or 2019 that we received the original extraction.
All right,
Which,
so
by the way, was not in a usable format.
no.
Yes.
This is what I'm asking. So 2017 or 2018, you received a cell phone dump. And that was when your client was in juvenile court, correct?
Right, it was a PDF of a cell phone dump.
PDF,
not
all
the
right.
Actual dump.
Not the actual cell, right?
All right. And then you received that PDF and you state that what was turned over to you in adult court, and I'll just call it adult court so that the record can be clear, appeared to be similar, but you're saying maybe it's not similar. But the information that you receive in juvenile court from 2017 to 2018, you stated that it appeared to be unintelligible.
Right, we couldn't make any use of it, right?
No.
You see entries and the PDF.
No, I understand. You're just saying it was,
You can't
Yeah.
dive deeper.
yeah, all right. And so you said it appeared to be unintelligible. But what you said was you were fine with that because as a part of your strategy, you're fine with that.
My thinking was, if I can't make heads or tails or make much use of this, then they can't either. And that there would be good arguments under the rules of evidence to exclude different portions of it. And that we would at minimum have good argument about the true context and meaning of what those things on the phone actually stand for because of what isn't there. That was the original thinking at the time.
Okay.
The problem we face now is that we've been given a version of it with a UFED reader so that there can be deeper inquiry into what it contains. But it's a cell phone and it's a lot of material. I haven't been able to go through all of it. And what I worry is that there's going to be something on that phone that I have not seen or don't know about that's going to be used by the prosecution to advance their position and that I have no way to rebut or be prepared to attack.
And under the Michael Martin Act, if it is relevant, we're entitled to it. So we would like not just the entire 4,000 pages, which contain terabytes of information.
So here's my
We
question.
would like to know if the state has anything that they intend to use, they believe is relevant. We'll take their word for it. We would just like, one, to be advised of what they think is relevant. And two, we believe it is untimely because we can't go look for stuff that might help us. We've got an expert trying to do it.
But here's my question for the defense. If you have information in 2017 or 2018 that you're saying, it's unintelligible, and as a part of strategy, we're not going to ask or receive it in any other format because that's a part of our strategy that if the state tries to use it, we can argue, hey, we received it, it's unintelligible. So you're saying,
Think about it in this context.
no, I'm just trying to clear up,
Right.
Because I want the record to be clear. So everyone's argument can be understood by me and whomever else needs to hear the argument. So how does Michael Morton Act purport with defense, perhaps saying with strategy for strategic purposes, for trial purposes, I know this is unintelligible, but I'm not going to say anything. And then when it comes to trial, I can argue, you know what? By the way, guys, this is unintelligible. I knew it was unintelligible in 2017. And as a part of my strategy, I really wanted to remain unintelligible and nobody to figure out that it was unintelligible for us or our expert, so that at the time of trial, that can be my argument.
Actually, Your Honor, Actually, Your Honor, we're not saying, it was our strategy because if somebody gives you a blank piece of paper or a book and just says here, we don't have possession of the phone. We can't do anything with it. And if that's all they're going to use, they're not going to be able to use it either. So it wasn't that, it's like we have probably gotten terabytes of jail calls. I don't think anybody in this courtroom, prosecution or defense, has listened to every jail call. It's just not usable. What we got was something we couldn't use, and we assumed they couldn't use it either, and we didn't have custody of the phone. We couldn't go do any additional thing. What happened?
This is kind of a weak argument because if it is unintelligible, you ask the court as soon as possible, Your Honor, this is bad. We need something better.
And is all of a sudden we get something that is actually slightly different in that they apparently have figured out how to use what they had, not what they gave us. We couldn't do anything with that. No experts could do anything with a PDF. That's just a copy of something. And so what I'm suggesting is, we didn't know that there was anything relevant or material.
Let's see, Skillepan says, what they are saying is it was unintelligible until the extra data was provided. Yeah, but they have had 8 years to ask for more, and they didn't. They assumed that they had the same. It's like having a map but not the street names, then they give them the street names later. Yeah, but then you can ask for what is it call it, the reciprocal discovery, or you say this is unintelligible, we need it to be excluded. Skillpen says that's not how it works. Okay, I'm open. I'm very open for suggestions.
If they think there is something relevant or material in that, we'd like to know, because we would like our expert to look for other things on there. If they're able to find things on there that they think are relevant material, we'd like to see opportunity, Your Honor. That's all we're saying.
No, no,
And
no.
if they don't
And-
think there is, then we don't.
And let me just tell everyone, I ask questions. And the reason why I ask questions is because I want the record to be clear.
Right.
And I want to be clear on your argument and what your argument is. That is why I'm asking these questions. It's not saying that I have I've already decided on which way I'm going to rule. I just want all of the questions answered in my mind so that I can make an informed and intelligent ruling.
I think that's fair, Your Honor, and I didn't mean to imply that.
No. Yeah, no, that's why I'm just saying that. These are just questions I have.
And I wanted to make sure you were characterizing what we were trying to say.
Oh, no. I'm not. I'm just asking questions.
I know, but you were saying, is this what you were saying? And I was just trying to say, that's kind of what we were saying, but I wanted to point out the fact that if somebody gives you something you can't use in evidence, that they couldn't use in evidence, is useless to everybody. But if they think there's something in there that we could have used, and they found something, I'd like to have the same opportunity, that's all.
And that is why I brought that up and was asking questions about it, because your co-counsel was saying that it was strategy. But now
Well, it
you've given your explanation
Of
that
the
it's the same
strategy.
if you receive a blank sheet of paper. Your strategy is it's a blank sheet of paper. They don't have anything because it's a blank sheet of paper. We don't have anything, so we're not going to bring it up. I understand that. Okay.
And what I would equate it to is, let's say that as a case starts off, we have received discovery that there's been swabbing done for
Mhm.
biological fluid, but no results are in, right? And so we know that there are swabs, but we're just proceeding on our course. We're getting ready for our trial. Then later we get a notification. Oh, by the way, serology's back. This is human blood. It isn't chicken blood or something. Okay, well, we're just still proceeding to trial. Thanks for letting us know. They don't know anything more than it's human blood. So if the trial happens today, then that's all they're going to be able to say. And there's nothing else for us to do. But now they've given me the full DNA breakdown.
So depends what you're asking for. Is you're asking for the information to be excluded because you're arguing that it was given to you untimely.
Yes, you are.
That
Correct.
and the fact that we don't have the ability to do anything about it, because in the form they've given it to us, our expert says it's going to take him at least another 30 days
Okay.
to be able to use it.
All right. And when did you give this to your expert?
Well, that's what I was saying.
March 3rd, Judge, and if I may,
Actually, it was in February because his affidavit is February 30th.
I wasn't able to get to it.
Let me just kind of explain that real fast. Then, Mr. Lane,
February 30th, and we are now on April 3rd. That's more than 30 days.
I would like to have one thing added to it. The first thing that we needed to do was, when we looked at it, it looked an awful lot like what we already had. And so it was like, okay, is this different? Is this the same? Is it the same plus?
Yeah, thank you. There is no February 30th. So what's going on? March 1st. Yeah, you go directly from February 28th to March 1st.
Something else? And we sorted that out. And then it was like, okay, I don't really understand what's going on here. We need to get an expert. That's what I wanted to clarify.
And we got him. We got the expert in February, obviously, shortly after we received the material, and the expert says he needs considerable additional time.
So you would have obtained the expert sometime,
It was early March, March 6th, I think, March 2nd.
Or third, somewhere in that range. It's in the affidavit. And I just would like to make something abundantly clear for the record. Two pieces of evidence that we're discussing, the PDF that was provided subsequent to the 2017 extraction and the subsequent extraction that was provided to us in late January or early February of this year are different pieces of evidence and have contained different things.
All right,
The original document that was provided to us is a PDF, so it does not contain, the ability to interact with video files, to enhance or enlarge or manipulate photos, to follow any attachments, to listen to any audio. Okay, it's a PDF. It's just a paper printout of the data contained on the phone. The information that was provided to us in late January or February is the raw data of the extraction, a logical extraction of the phone, and a UFED reader format, so that is interactable on Celebrite, and so that you can then access all of this additional information. So I want to be very clear, these are different things and there's different information.
no. So what I want to know is, I think both parties have agreed that the information that was given to the defense in 2017 was when Mr. McIntyre was in juvenile court.
Yes.
Then we have more data, or maybe the same data, but in a different format that was given to the defense January 28th, 2025, or somewhere between January 8th, 2025 and February 3rd, 2025. Somewhere in that time frame, that's when the data was given to you. And I think everyone has stipulated to that. Am I correct?
That's correct.
And I want to
Alright,
correct
and then-
myself, Your Honor.
Yes.
It is, the affidavit is not February 30th, but March 30th.
Okay.
Uh,
And then, so,
I don't want.
Okay, affidavit is March 30th. Yeah, then that was just a few days ago.
oh, no problem.
It was 3:30 and I took that.
Oh, no, let me just tell you, it happens all the time. So then, so you stipulate the information was given sometime between January 28th, 2025 and February 3rd, 2025. In addition to what was given in 2017, and in the data that was given to the defense between January 28th, 2025 to February 3rd, 2025, some of it was the same as what was in 2027. I'm sorry, 2017, and there maybe have additional information that was given
I think
instead of just 2017 information.
a better way to describe the relationship between what was given then and what was given now would be to say that it would be the difference between running the program and being able to manipulate it with your mouse or
All right, so
cursor.
this is what I'm saying. Everyone, listen, please listen. What I'm saying is you all received data in 2017. In addition to the data that you received in 2017, you received data in between January 28th, 2025 to February 3rd, 2025. Both parties have agreed upon that. The state and the defense have agreed upon that. The data that you received in 2017, you received that data between January 28th, 2025 and February 3rd, 2025. And there may have been additional data related to the cell phone between January 28th and 2025 and February 3rd, 2025. I think both parties agree upon that. Am I correct?
Yeah. And we can't use either one of them.
No.
in the
Let me,
court.
let me just take it step by step so the record can be clear. Then the defense, you have this data and you have your expert. I believe you said March 30th, 2025.
Well, we got him actually at the
March
end
6th.
of February, early March, and the affidavit is after he has spent that time, the month, trying to use it, and he says he will need additional time. And what I'm advising the court in the motion is basically, here's an easy solution. If they're not gonna use it, we don't want to use it either. We don't know that it has anything because we can't use it. If they are gonna use it, we'd like to know what they want to use, and we'd like additional time to be able to develop what we need.
All
And
right,
that was the
so,
purpose of our motion for continuance the last time.
so February, when did you all have your expert look at this data?
We sent the data to him on March 6th or March 2nd. It's in the affidavit.
All right, so March 6th, we'll just say March 6th, you send the information to your expert, correct? Even though you had the data at the beginning of February. Am I correct?
Well, what we did first, Your Honor, was we were
Right,
looking
you-
at the data to see if it was the same as what had been previously sent, because what was confusing was, wait a second, how is this different from 2017? I don't understand exactly how it's different from 2017. We were trying to avoid the need of incurring the expense of having an expert consult with us on it if it was going to be the same data and it just, was called something else.
All right, state.
But that wasn't the case.
Judge, okay, so
And by the way, it is March 6th, Your Honor. It's paragraph 12 of the affidavit.
All right, thank you. Yes.
So it is my understanding that there was, and I would still classify it as one phone dump. Okay, the phone dump regarding that blue cell phone that is located in the Kia Forte was conducted back in 2017. What was given to us by the law enforcement agency was a CD containing the PDF of the Celebrate extraction report. That was turned over to them and that has been stipulated to them back between 2017 and 2018. Upon my assignment to this case, when I reviewed the PDF, I started looking at it and I wanted to click on the PDF. It's intelligible. It contains call logs, device information, images, and things that were contained on the phone. When I was looking at the images and some of the sounds on there, I noticed that there was thumbnails that I would try to click on and would not open. Once I realized that, I contacted the detective to see if he had a master copy or if it was just an error in the way that it was run. So close to that January 28th date, I went over.
Why would you not ask for the master data directly in 2017?
The SAPD CSI unit, they had a master copy. The only difference, my understanding, because I don't have an expert, I have to lean on my own understanding, but when I look at it, the page numbers are the same. All the information that is contained within the PDF is the same. However, now when you go and click on the thumbnails, you're able to see the actual image or listen to the sound that was contained in the original PDF.
And
That's the problem, is because we have to rehash the same 4,000 some odd page document that we previously had and make sure that whether or not each of these thumbnails works. So the idea is, you can look at this and say, well, my gosh, it's been 7.5, 8 years, but understand that this is a very lengthy, time-consuming, monotonous process to get completed.
All right, state, do you have information that you're planning on using from the phone?
I do, Your Honor, and if you would like to just exclude from whatever was turned over and we can just go on to 2017 that they've had for 7 years, I'm completely fine with that.
All right, if you would inform the defense specifically what you are seeking to use from the 2017, and you're saying that the defense says it was unintelligible. You're saying that's not the case?
PDF, read what is on it.
All right, so if you will inform the defense of what you're specifically seeking to use from 2017, and then I'm going to have you all come back at, I'm going to say 1:20 because the jurors are going to be here at 1:30, and then I will make my ruling on this part of your motion. So if you all can confer on what you're seeking to use from 2017 that was given to them in 2017. And then I will hear a final argument once you all see what they're saying that they're intending or want to use from 2017, then I'll hear your final argument in regards to that. The state is saying that the information that was given to you, that's additional information from January 28, 2025 to February 3rd, 2025, they will not be using that. No. This is what I want everybody to do. Hear me clearly. The state is going to tell you what they're seeking to use from 2017. Your co-counsel has stated, we'd like to know what they're going to be using. So what I want you all to do, and I don't want to hear anything else. What I want you all to do
You tell me
is,
what I said.
no. What I want you all to do, hear me clearly.
Right.
State, I want you to show them what you are seeking to use from 2017. I'm not saying I'm letting it in. I don't know. I want you all to see what they're saying they're going to use.
May I have one clarification? Your Honor?
No. I'm sorry. You all going to come back at 1:20, and then counsel, you can put your clarification on the record. So you all can come back at 1:20, and the jury will be here at 1:30, but I want you all to see what they're saying they would like to present. And then I will hear your final argument based upon what they're saying they would like to present, and the court will make a ruling.
Thank you, Your Honor. And well, the only thing I would like to ask is, are y'all just offering things off the PDF? Or are you saying?
I think we can talk about it.
Okay, because I think it's not the PDF that we got in 2017. They have now figured out how to click on it.
No. They're going to show you specifically what they had from 2017. And if it's something that you think was not was not given to you in 2017, that's something we can take up at 120.
Okay,
But I
and
think you all
maybe
may,
co-counsel has something he wanted.
all right, here's the
They
thing.
will wait until then.
Yes, you all may decide that you're fine with the 2017. I don't know. So I want you all to have a chance to view it, then we can come back and discuss it. All right, so if you all can be back at 120, because the jurors will be here at 1:30, and then I will hear argument. If, of course, if you all decide, no, we're fine with 2017, then we won't need an argument, because the state has already stated they will not go forward with information that is in addition to the 2017 dump. So anything that's additional that was given to you on January 28, 2025 through approximately February 3rd, 2025, they're saying that they're not going to use it if it's additional information. But if it's the same as the 2017, they're saying that they're wanting to use that, but they're going to go over with you what they're seeking to use, and then we'll be back at 120, and I will hear all of your arguments.
Thank you, Your Honor.
All right, thank you. All right, who is here? Leo?
Yeah, all right. Now let's go to what the decision became. Let me just do this. Dun, dun, dun. Dun, dun, dun. Dun, dun, dun. Boom. And this is not that. Oh, she's handling other things before. We don't need to listen to that.
And who's the attorney? All right, then we can hold his time till 2. And if he doesn't show up, we'll recall him for tomorrow. Thank you. McIntyre, can I have the parties announced?
Megan Galloway and Jason Garahan from the state of Texas.
John Hunter, Jerry Goldstein, and Thomas Lane for Mr. McIntyre. Mr. McIntyre is present, Your Honor. We're ready to proceed.
All right, so where we left off is that the state had informed the court that the information that was additional information that was given to the defense January 28th, 2025 to on or about January 28th, 2025 to February 3rd, 2025, that they are in agreement to exclude that.
Yes, Judge.
Right. And then that just leaves the information that was given to the defense on in the year of 2017. So did y'all have a chance to confer with each other and to let the defense know what part of the information from 2017 you were seeking to use?
I have, Your Honor.
Yes, Your Honor. We met with Ms. Galloway and went over her proposed exhibits. Our concern is that without the entirety of the data with the UFED reader in the digestible format from 2025, our ability to have any sense of what the context of those exhibits is, or if there's more to any of the things offered in that exhibit, is severely hampered. And so I don't think that a partial exclusion as a remedy would solve the concern that we make, because we haven't had time to be able to make use of the 2025 data that may underlie some of it. The state's proffer of exhibits includes the underlying identifying like slides that would show the make and model of the phone, its serial number when it was made, those kinds of things that more readily identify the phone, and then a series of photographs of Mr. McIntyre with some are selfies by himself, some are of family members, some are with other individuals. There are a
With
couple
regards to the make and model of the phone was seized, so you would have known the type of phone it was and what the make and model of it was, since you've had access, knowledge of the phone. You've had knowledge of the phone since 2017 at least.
But
We didn't have access.
and Your Honor, I mean, as a practical matter, if we're talking about the identifiers of the phone themselves, if that was the only thing that the state was offering out of the phone, then we would, of course, without waiving our objections under the motion to
But
suppress, really
counsel,
not have
you
anything.
said that your issue, the things that you were concerned about, one of them was the make and model of the phone. Did I hear incorrectly? That's what you were saying. So
No, Your Honor, I just want to make sure that I'm clear. I said several things. I'm giving you a litany of all of the things that the prosecutor just showed us, which were to include identifiers of the phone, photographs of Mr. McIntyre, photographs of some of Mr. McIntyre's family and friends, photographs of Mr. McIntyre, ostensibly, Mr. McIntyre doing certain things like filling out a document. what the prosecutor is going to argue with those things obviously is beyond the purview of this. I can't tell that in advance. And I don't have the metadata. So if I hear an argument from the prosecutor about what one of those photographs means or why it is significant or why it proves some element of the offense, I wouldn't be able to go into the metadata to try and demonstrate why the prosecutor's interpretation is wrong. The other thing I want to make clear of, though, is that there's a secondary concern, which is that contemporaneous with the state's 2025 production of this secondary dump with the UFED reader, as the court will recall, it came to the defense's attention that in, I believe, 2019 or 2020, the cooperating accomplice witness, Joanna Reyes, went on the record in this court pursuant to her plea agreement and gave testimony under oath as a condition of her plea, outlining her involvement and participation in the alleged offense. And we were not made aware of the existence of that transcript until January of this year. The court had a hearing on the matter, and the matter was unsealed from her cause number so that we would have access to that information in advance of trial. There are some concerning aspects of Ms. Reyes' testimonial account that differ from previous statements that Ms. Reyes has given to law enforcement, particularly remarks about her relationship with Mr. McIntyre that would be essentially 404B conduct, in the sense that she has implied that Mr. McIntyre and Ms. Reyes' relationship was not fully consensual, or that she felt forced or coerced into being with him. And I believe that in light of that, the extent that the 2025 dump may contain material that would be impeaching to Ms. Reyes on that matter, since Ms. Reyes' phone, I don't believe, has been imaged or dumped in this case. And so there are several different aspects of this where a remedy that just says, let's isolate these few things from the 2017 extraction in PDF form, and we'll only let the state use those things, doesn't fully cure the problem of the untimely discovery production, because it also has this component of we can't go back and vet the contentions that they make, and we have not been able to make meaningful use of the phone to go and vet the contentions that Ms. Reyes made in that transcript that we just received this year. And so I understand that the court was hoping that that remedy might split the baby in some
No,
way. And
I was not having any hope for
Correct.
anything. I'm just here to listen to both arguments. I have no hopes, no dreams with regards to whatever arguments either side is making. I'm just here to listen to your argument and make a ruling. Whether you all agree with the state's proposal to exclude the information from January 2025 to February 3rd, 2025, that's completely within the state's purview if they want to do it. It appears that the state is saying, court, we don't need you to rule on the January 28th, 2025, February 3rd, 2025 information, because we are going to exclude that and not use that. So whatever you all have reached an agreement to or whatever.
There is no agreement.
All right, so there you go. So the state has said that they have no intention to offer the January 28th, 2025, February 3rd, 2025 information that you all say that you received. And that information is information that's additional from the information that was received in 2017. Is there anything else?
We would ask the court to exercise its discretion under Heath and exclude the entirety of Mr. McIntyre's cell phone in either version from the trial of the cause pursuant to Article 3914, the Due Process Clause, 5th and 14th Amendments, Brady versus Maryland, and Heath and Watkins.
All right, state.
Judge, they've had the 2017 dump since at least 2018 by their own stipulation. And so I, just to make this process go along faster, agreed to exclude the 2025. I mean, if they want the 2025 stuff in, I'm fine with that. But, I complied with, especially the 2017 version, it was turned over pursuant to Brady and Heath in a timely, reasonable manner. When the case and dump occurred in 2017, it was given to them back in 2017. And so I believe that we should be able to use that.
A cell phone with that much material on it and a 4,000-page report that describes the material on it cannot be said to be timely produced if it's produced a month and a half prior to the date of trial's commencement. The previous version of this thing was unusable, and I want the court to be aware, if both versions are allowed in the course of this, and no matter how the court rules, the problem the state's going to have is when we look at how the images exist on the 2017 version, they're little postage stamp size thumbnail images along with a code descriptor of where it is on the file location. But that's not what they want to offer. They want to offer a blown up version of the photograph, but they're not using the 2017 version to make the blow up of the photograph. They have to use the 2025 version because that has enough pixels to actually enhance. So even if they say that the content that they're using is from the original dump, that's not accurate. They're going to have to use the 2025 enhanced version of it in order to make an exhibit that you wouldn't need a jeweler's loupe to be able to look at in the course of publishing it to the jury. And so they can't separate these things out. the bottom line is that if they were going to make use of this forensic material in a forensic way for trial, that should have been done at some juncture other than in 2025 for this trial date.
All right, so is there anything else from the defense?
Only that they can access this material, which what we are gonna get from 2017, we cannot. It's just like a sheet of paper. There's no way to access when you see the thumbnail, they were able to go into it and look at it. We still can't, even with the 2025. And we certainly couldn't with the paper. You can't do anything without it with PDF.
All right. So this is the court's ruling. The court is finding that the giving of information on January 28, 2025 through February 3rd, 2025, that's in addition to what was given in 2017. The court is going to find that that wasn't untimely given. By the defense's own admission, they didn't give the information to their experts till a month after that information was given to them. The court is finding that the information given in 2017 was not untimely because here we are in 2025 and that information was given to the defense, according to the defense, in 2017. And based upon the argument by the defense stated that it was their strategy to not say anything about the thumbnails that they could not see. And that was their strategy. This is what the court is going to do. Because the state is saying that they are not going to use and will not use the additional information that was given to the defense on January 28, 2025 to February 3rd, 2025, I'm going to hold the state to that, and I'm going to exclude that because the state is agreeing to exclude that. But that information, the court is finding that it was timely turned over to the defense, but I will exclude it because the state is agreeing to exclude it. With regard to the data that was given to the defense in 2017, the court is going to find that that data was timely given. And the fact that the defense is saying that you would need a jeweler's equipment in order to see the data tells me that the data was available for viewing. With that being said, if you could bring the jurors in, please, and state,
Your Honor,
make sure your witness is available.
a couple of just housekeeping matters for the preservation of the record. In light of the court's ruling, we would re-urge the motion for continuance that we urged in preparation of the last setting. We would ask that the court give us additional time to be able to prepare this matter for trial and to be able to rely upon the 2025 disclosure data, because we anticipate that there could be favorable material in it, and so that we can make use of the metadata underlying the state's proposed exhibits from the 2017 data.
All right, motion for continuance is denied.
And Your Honor, lastly, with respect to the court's ruling this morning on our motion to suppress evidence, both under the four corners and under our request for a Franks v. Delaware hearing, we would request written findings of fact and conclusions of law.
All right, thank you. All right, let's bring the jurors in.
All right.
Okay. Yeah, I mean, she did say that she would hold the prosecution to its word. They can't use the 2025 release. They can only use the 2017, which means that if they have one of these old type thumbnails, that is all they have, not the enhanced ones from 2025. And yeah, and if an extraction has not been handed over, then there's still a Brady issue. Yeah. It's a appellate issue as of now. All right. That we have handled a day and a half in just under 5 hours. So what I'm going to do now is we are going to end this stream with taking a look at Attorney Steele's answer to Fani Willis' motion to revoke Mr. Williams' probation. So that is what we are going to do. Hold on while I bring this up. Dun, dun, dun. And before, because I will make this into a separate video as well. Because there might be more. I have a certain portion of my audience that only watches videos. So first, a swoop. Yes, folks, that is my Norwegian fire farting dragon. You can't sneak up on that from behind. Okay. Add to stage. Let's do this. And let's try to... Oh. There you go. Let's see. How does this look? Yeah. All right. In the Superior Court of Fulton County, State v. Georgia versus Jeffrey Williams, Mr. Williams' response to State's motion to revoke probation comes now. Jeffrey Williams, by and through undersigned counsel, and hereby files this response to State's motion to revoke probation in the above reference case. In support of this response, Mr. Williams shows as follows. 1. On or about April 2nd, 2025, at 7:48 p.m., the State filed a motion to revoke Mr. Williams' probation. Oh, when was this? 10:32 a.m. today. 2. The prosecution must place in writing, pursuant to the due process clause of the United States Constitution as well as Georgia Constitution, the specific act or acts that Mr. Williams supposedly committed to violate his probationary sentence. As shown below, the prosecution's motion to revoke Mr. Williams' probation fails on its face to allege any conduct by Mr. Williams that would rise to a violation of the probationary sentence. Taken in the light most favorable to the prosecution's allegations in the motion to revoke probation, this honorable court could not find a matter of fact and or law that Mr. Williams violated any term of his sentence. See Miller v. State. Which is the Honorable Court of Appeals of Georgia reversed the trial court's determination that Mr. Miller violated his probation since there was no evidence to support these findings. The State's motion to revoke probation must allege conduct which, if proven by a preponderance of the evidence, shows that Mr. Williams violated a term of his probation in the specific manner charged in the motion to revoke probation. See Moten v. State. As discussed below, taken in the light most favorable to the prosecution's assertions, Mr. Williams did not violate any term of probation, and thus the State's motion to revoke probation must be dismissed at this time with prejudice. The material allegations in the State's motion to revoke probation are as follows. At a preliminary hearing in an unrelated case, the magistrate court ordered that no witness be shown on television while testifying, and a, quote, known blogger deliberately violated, end quote, that court's order by posting on social media a photograph of investigator Viverito. Yeah, the court's order in the unrelated case was do not televise this witness. What was shown in the post was not from that case. Not at a preliminary hearing. Now, I've heard that she, as in the YSL trial, she's lying her ass off there as well. But that's besides the point as of now. This allegation has nothing to do with Mr. Williams. First, even the quote-unquote known blogger did not violate the magistrate's court's order as asserted in the State's motion to revoke Mr. Williams' probation, because there was no image shown of investigator Viverito while testifying in this unrelated proceeding. The allegation cannot support the revocation of Mr. Williams' probation. On its face, it fails. 2. Mr. Williams amplified this blogger's act by reposting the image with the caption, Marisa Viverito is the biggest liar in the DA's office. First, there is no suggestion that Mr. Williams knew of the magistrate's court's order not to show investigator Viverito on television while testifying. Second, the allegation asserts that Mr. Williams reposted an image and wrote a caption. This allegation does not violate the magistrate's court's order or Mr. Williams' conditions of probation. Third, there is no violation of Mr. Williams' probation by reposting an image on social media and opining that investigator Viverito is untruthful. The prosecution asserts that Mr. Williams' repost went viral, and unknown persons commented on same, which included supposed threats to investigator Viverito, her family, as well as the district attorney. Mr. Williams, undersigned counsel, and all moral persons do not condone threatening another without justification. However, these comments on social media by unknown persons cannot be attributed to Mr. Williams in order to support a violation of his probationary sentence. I completely agree. If the DA's office has a problem with those comments, then charge them. Mr. Williams' original posting does not say in any way, shape, or form that go on, folks, and threaten Mr. Viverito and Fonnie Willis. Nowhere. Absolutely nowhere. Let's see. Oh, that is a bit. Let's go up there with that. Sorry. The state's motion to revoke Mr. Williams' probation then lists quote-unquote direct threats in attached exhibits. Again, this allegation did not allege any act attributed to Mr. Williams to support a violation of the probationary sentence. The prosecution spaciously alleges that Mr. Williams is conducting a quote-unquote calculated campaign of intimidation, harassment, and misinformation designed to undermine the legal process, end quote, and other baseless assertions. Yeah. These conclusions do not support a motion to revoke Mr. Williams' probationary sentence, and the remainder of the state's motion to revoke probation is an argument without any substance to allege an illegal or unlawful act conducted by Mr. Williams. Yeah, and in that motion from Fonnie Willis, she more or less said that anybody who is criticizing them for their conduct in the YSL trial, we are more or less a part of and aiding this criminal organization. So, folks, that T-shirt of mine that says not an unindicted co-conspirator, that might not be true anymore. I might be an unknown, unindicted co-conspirator, according to Fonnie Willis. And to that I say, Miss Willis, fuck you and your corrupt ass. You lied in church. You lied in Nathan Wade's when he is separated from his wife. You are a lying liar who lies. Okay? Want to do anything about it? Come get me. Four, a revocation of Mr. Williams' probation involves the loss of liberty, which is a serious deprivation. See Great House v. State. Therefore, Mr. Williams is entitled to due process of law. See Meadows v. Settles. This honorable court may not revoke any part of Mr. Williams' probation unless Mr. Williams admits the violations as alleged in the state's April 2nd, 2025 motion to revoke probation, or unless the evidence produced at the revocation hearing establishes by a preponderance of the evidence the violations alleged. In the case at bar, in the light most favorable to the prosecution's motion to revoke probation, Mr. Williams can admit to all of the alleged allegations alleged and still not have violated any terms of his probationary sentence. Thus, the state's motion to revoke probation is deficient. Therefore, Mr. Williams asked this honorable court to deny the state's motion to revoke probation without a hearing. If a hearing is needed, Mr. Williams will be prepared. Wherefore, Mr. Williams respectfully requests this honorable court to order that the motion to revoke probation be denied. This 3rd day of April, Brian Steele, Keith Adams. Yeah, I mean, Fonnie Willis, your motion is absolute horseshit. Absolute horseshit. Now, was it a great idea for Mr. Williams to retweet? No, because he knows that the prosecution is out to get him. They really, really hate that they lost, because anything but putting Mr. Williams away for life is a loss for Fonnie Willis and the DA's office. Anything else. That is why they keep having Jack Gotti in jail, for instance. So, yeah, Fonnie Willis, your motion is horseshit, and you are a absolutely worthless attorney. I am ashamed on your behalf, because you represent people with law degrees, and you do it so absolutely bad. Absolutely bad. All right, folks. That brings us to the end of this. And folks, thank you. Thank you for the super chats. Thank you for the gifted memberships. Thank you for staying members. And yeah, just thank you. And I will continue tomorrow with the Judge Boyd trial. I hope I can get another day and a half in, and maybe even more. So, but that will be tomorrow at 9:30 a.m. Eastern Time. That we will continue with that. Okay. Again, thank you. Thank you for allowing me to do this. And remember, folks, hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. Okay? Have a good one. Bye-bye.